Now convene this public hearing of the Government Administration and Elections Committee. Are there any remarks from the co-chairs? No. Any from the rankings? No. And so we'll begin with the public testimony portion. First up is Peter Lewandowski from the Office of State Ethics, followed by Secretary of the State, Stephanie Thomas, followed by Mark Garofalo, Town Clerks Association.
Good morning, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished committee members. Thank you for this opportunity to provide testimony regarding Senate Bill 434, which this committee raised to increase various monetary thresholds under this state code of ethics. Recognizing that it has been almost 30 years since the last amendment to the monetary thresholds under the state codes of ethics, and that the cost of goods and services has risen over such time period, the Office of State Ethics supports reasonable increases to various gift exceptions and reporting requirements as noted in Senate Bill 434. The proposed monetary increases closely reflect inflationary increases over the last 3 decades. It is important to note that restricted donors, such as registered lobbyists, are required to report any benefits provided to public officials and state employees, and that the requirements of such disclosure, other than the amendments to the monetary thresholds noted in Senate Bill 434, remain unchanged. Further, other than those few enumerated gift exceptions under sections 1-79 and 1-91 of the general statutes, including those that this bill addresses, the state codes of ethics prohibit public officials and state employees from accepting gifts from restricted donors, such as lobbyists and those who are doing or seeking to do business with the state. Thank you for your consideration of this testimony, and I'll be happy to answer any questions you may have.
Thank you, Director Lewandowski. Are there questions from the committee?
Easy.
Thank you.
None. Thank you very much for being with us today and for contributing your testimony on your work on behalf of the state and all citizens, residents. Next up is Secretary of the State, Stephanie Thomas, followed by Mark Garofalo of the Connecticut Town Clerks Association, followed by Duncan Wilbur.
Good morning.
Good morning, Secretary.
Ranking members of the committee. That was faster than I anticipated. Oh, so I feel like this will be a long public hearing today, but I want the people of Connecticut to know that overall, my confidence in Connecticut's elections is very strong. But like any system, it can always be tweaked to make it more efficient, more secure. And I believe that many of the provisions we'll be discussing here today will do just that. I'm also sure that Bridgeport will feature prominently in testimony today based on the recent court case. And our office has learned a lot through the installation of our election monitors, not just about Bridgeport, but the system as a whole. And I would like to thank the committee and the chairs for hearing our input based on that experience in drafting 2 very comprehensive bills, SB 441 and HB 5498. I believe that both will help maintain public trust and create better elections overall. I have submitted my written testimony on those 2 bills as well as HB 5495. SB 441, I believe, will have a profound impact on preserving election integrity. Since taking office, I have observed a significant gap between the jurisdiction of our office and the operations of SEEK, our judicial decision. And our hands are tied if a law isn't broken or if there's no judicial intervention. So I've submitted my testimony, but I think closing that gap is of a huge importance. HB 5498 also contains very many varied measures, from Dropbox security to forms to administrative changes that I think will strengthen our system. And we have included suggestions to improve both of those bills. I know ROVAC and CTCA have also added some helpful points as well. The topic of election security has garnered much attention in the media, so I'm going to close the same way I opened. I maintain my overall confidence in our elections, but there are always ways to make the system better, and I believe 441 and 5498 will do just that. I'm sure you will have questions, so I will stop there. Thank you.
Thank you, Madam Secretary. Questions from the committee? Senator Sampson.
Thank you, Mr. Chairman. Madam Secretary, nice to see you again. I think it's a record 3 times before our committee in 1 year. And I'm delighted to have you here. Senate Bill 441, first off. I've just taken a kind of a cursory look at the language. I guess what I would like to know from you is really kind of your interpretation of just how it would actually work, in reality. You can read the text of the bill, but where are we missing? And I just from my own experience, I think that am I correct in that the election monitors, for example, in Bridgeport, they have a very limited access to things. Is that part of the reason for this particular bill?
It's actually, thank you, good question. It's actually the opposite. The election monitors have a lot of authority, but it's authority we would not typically have had in our office. So, for example, little things we noticed, staff maybe could have used more training, or, best practices have evolved over time that an election worker may not have been utilizing. Little things like the font on a form or the explanation on a form. A lot of these things are things we would not have the jurisdiction to compel a local election worker, because they're elected in their own right, to actually do, unless the law is being broken. So there's a huge gray area that falls from the most simplistic, take 1 hour of training, take a refresher course. This is the way this process is intended to work, all the way up to what we saw with the election monitors in Bridgeport, which was someone installed in the office of the town clerk during all hours of operation. The bill as written, we suggested a few changes, but essentially it would work. An independent board of volunteers, 17 members are contemplated here. Referrals made from ROVAC, town clerks, COST, CCM, our office, SEEK, and then the legislature. And towns, SEEK, our office, individuals would make referrals, much like we see with the SEEK process now. And this board, and I'm going to oversimplify, but in short, this board would review the information and either dismiss the referral or refer it to a tier. Tier 1 is meant to be mainly, like, I would just say very simple changes. Like, a good example, I received a call once about a registrar's office not being open at a time that a resident thought it was open. And it was just a matter of them having a note on the door, which they hadn't thought to do. Something like that, very simple. The middle tier would be slightly more complicated, more training, perhaps having our office review some paperwork they have to complete, etc. And then the final tier, again, would be, serious malfeasance, but perhaps we're still waiting on a SEEK investigation, or like we saw with our election monitors, things that hadn't been contemplated by the judge needed some intervention. So the third tier would be more hands-on.
Understood. Through you, Mr. Chairman, thank you very much for that information, Madam Secretary. Just listening to you, a few things came to mind. First and foremost, You mentioned like the election monitors were installed in the office.
Mhm.
And I guess your interpretation of that is that's a kind of an aggressive way to address the issues versus going through this, tiered process that you just described that is laid out in Senate Bill 441. And I can understand that too. I guess my question really has to do with like the real world effect or impact of what they can do, because, for me, the election monitors were not able to do what I wanted them to do, which was to be outside of the office, understanding what is going on as far as the absentee ballot process and the potential for any type of ballot fraud or for absentees and the harvesting issues that I think Bridgeport brought to light. So my understanding about this process is it's not going to do that either. But what it might do is create a more of a structured way to oversee a municipality that maybe is not up to snuff as far as their best practices in running an election. Am I right in that interpretation?
I think it could, right? If I had unlimited resources, or if the election monitor bill had provided additional resources, right? I could have hired 10 people to walk around and go to every building and hand out information flyers and be on the radio and on television telling people, don't do this. There are so many things that could be done, but, time and money are finite. So in the statute that did pass, we were able to have an election monitor. I interpreted that into we could have multiple monitors so that the office was always under observation, which had not been done in the prior years when an election monitor was appointed. So I think within this tier system, tier 3 could be the mitigation is to go to public housing buildings or senior housing buildings. The mitigation to me, or I think this is designed to be suitable to address whatever the concern is.
Yeah, thank you very much. Through Mr. Chairman, I appreciate those answers. To me, it highlights the problem, which is that you mentioned there's not enough money or resources to go out there and go to every building and provide information. But the fact of the matter is the bad actors that we are trying to capture and catch in the act, that's what they are doing. They're using their resources to go out to various buildings and interact with voters and potentially engage in, a fraudulent election process. And to me, that's the concern. So we keep making these steps to expand the authority and power of government, but we're not going after the problem in my mind. One of the big issues I have with this bill, and I'm not opposed to it on its face, but I'm looking at it and I'm asking myself, why are certain people included in the Municipal Election Accountability Board? You have the Secretary of State, of course. You have some oversight over elections, I think. Okay. The State Elections Enforcement Commission, that makes sense. But then why do we have representatives of the Treasurer's and Comptroller's office?
So most people don't realize the treasurer, the comptroller, and the secretary in tandem certify elections in our state.
Well, I can understand
So
that
that's why.
they might have a role in the final certification, but any actual on the ground knowledge of elections and so forth, I think is lacking there. But the bigger concern for me is that what we're doing is we're putting partisan elected officials in a position to have oversight over what towns are doing as far as their election process. Now, I understand that we have no way around that because that's kind of how the towns do it also. But to take the most significant constitutional officers in the state that are elected, they're partisans by virtue of being in some political party. It raises a red flag for me as a what is the purpose of their role in the ultimate oversight. I'm certain there's no nefarious desire behind it, but the fact of the matter is, I'm certain that every person elected to constitutional office has a preference who they want to see win our, office for governor, for example, or maybe their own election.
Yeah, I don't feel strongly about those two offices. We actually our desire was to round it out beyond an audience that had such direct ties to our elections. And because they have to actually sign their name to certifying the elections, we thought they might feel they had some skin in the game and it made sense. And it's not the constitutional officer necessarily. It could be their designee as we envisioned it. So they could name someone, a lawyer from their office, for example, or someone who is used to the MARB, for example. So I don't feel strongly about it, but that was our thinking.
Just a final question on that
Mhm.
particular bill, and that is, regarding the resources. You mentioned the lack of resources to be able to, properly equip the
Mhm.
election monitors to do everything that I might have wanted to see. And I'm certainly sympathetic to that. What kind of resources are going to be used by this group? I mean, obviously it's going to change based on their need, but is there any thought to how it will be funded?
I don't know. It will require funding. One of our suggestions, I don't think this board, the administration of it can't fall within our office without additional resources. I don't think most people realize how small our elections division is. We have 12 and a half people. And we have 500 town clerks and registrars who we serve directly, not to mention the political parties and all political candidates. And in a state year like this, we get a lot of calls and questions. And then, of course, the people of Connecticut who also like to hear our input on topics as varied as should Trump be on the ballot to how many days of early voting should happen next. So we don't have the resources to administrate this board, but I would imagine you could get by with probably 3 staff people, like an admin, an attorney, and maybe a director. And then it would depend on how many referrals start coming in.
Understood. Through you, Mr. Chairman. Thank you, Madam Secretary. I appreciate that answer. I know I said that was the last question on that, but I guess you opened the door for just a couple of other things, which is that I guess I don't know if you and I are on the same page on this. For me, the Bridgeport issue brought to light the potential of absentee ballot fraud. To me, that's a pretty straightforward. What we saw with the Dropbox and the video and all this kind of prima facie, we have problems with that process. And nothing that I've seen in this bill is necessarily going to address that. I mean, would it be your argument that, that what happened in Bridgeport is a result of the failure of the election workers in the city of Bridgeport? Or is it a result of the policy that we have regarding absentee ballots that opens the door for that kind of activity? Because that's the way I see it. I mean, I can't speak to how well any of those folks necessarily did their job, but I know that election workers across the state, I think, are pretty responsible people. I know how hard they work, certainly in my community. So I certainly don't think that they necessarily need any state oversight to solve problems. But at the same time, I would much rather take the resources that you're referring to and maybe give them to your office or SEC from an investigative standpoint, to say, we need real people on the ground to prevent ballot harvesting. What's your reaction?
As much as I would love to take that money, Senator, what I've learned in this year plus is that there are more issues that are not as impactful in the news headlines, right? There are little things in the process that can be fixed fairly simply and make our system stronger and better for all voters, not just voters in one city. So that is my charge as Secretary of the State, to make sure our process is as efficient and effective as possible. So in terms of the video footage in Bridgeport last year, I'm not sure that there is one cause and effect. I think there are a few different pockets. And I try to remind people there's a difference between voter disenfranchisement and someone who may be breaking the law. As I've reported many times, one of the things our election monitors did was conduct spot check calls to people who had applied for absentee ballots to make sure that they actually applied for absentee ballots, etc. And we made, I believe it's 4 referrals, maybe 5, where we talked to someone who's like, yes, I love to vote. I support voting. I'm going to vote in this redo. I got my absentee ballot. I filled it out and I gave it to the nice lady to drop off for me. Now that voter voted as she intended to. She did not feel disenfranchised. She just wasn't aware that there are specific categories of people who are allowed to return an absentee ballot. So we have to be careful when we are interfering in a process that we are not creating more barriers to legitimate voters to offset a few bad actors. So there are some things in the various bills that I think many of our suggestions came as a direct result of being on the ground in Bridgeport for several months every day. A lot of those things are not headline getting, they're not sexy, but they're very boring administrative things. We also have one of the loopholes, for example, Dropbox footage. We wouldn't even have had that court case without the Dropbox footage, but there was no requirement to keep that, to retain that footage for any period of time, or to have it available for public consumption, or even to have a Dropbox camera. So those suggestions were made as a result of being on the ground in Bridgeport. Another, like, no one knows about the ED3A form, but that is a form that allows a voter to request an additional absentee ballot when their first one is ruined. So imagine I'm sitting here, my ballot, I spill water on it, I can't use it anymore, a coffee, whatever. And there was no limitation barring circulators from taking out additional absentee ballots, saying that they are doing so for the voter who had one spoiled. And sometimes that's legitimate, but I thought it was a loophole. So one of our suggestions was you can't take out multiple ED3A ballots. So there are quite a few things sprinkled throughout the bills that are a direct result. The absentee ballot application window, the fact that absentee ballot applications can only be used in 1 year and not carried over. And, you know, we have had this conversation, and I have said this to anyone who will listen often. And appropriations knows I have requested funding because I do think that right now, most information gets to voters by political parties and political candidates. And I believe the state, who is a neutral party despite being elected, should be responsible for that communication and that circulation. Where we disagree maybe is who should pay for it.
Through Mr. Chairman, thank you very much, Madam Secretary. I appreciate you getting into kind of the meat of the election integrity items that are in 5498 predominantly. So I guess we can talk about that to a degree. You know, I appreciated everything you said, and you know, looking at the bill that's before us, some of the items that are contained therein are definitely moves in a positive direction. Can I ask you, I mean, since you and I have had this conversation twice now, about you bringing us certain types of policies for us to digest and potentially debate and vote on here in this committee, is this bill a product of your suggestions, or is this you're simply testifying a bill drafted by the chairs of the committee? I'm curious to know what ended up in this bill based on your input.
Don't quiz me on the sections. Much of it is based on suggestions we had. I'm sure other legislators submitted ideas for the committee to formulate and put together. A lot of the technical fixes I know came from our office. Some might look familiar from years past. And certainly some of the things I mentioned, like the ED 3A form, et cetera, came from us.
Yeah. So through you, Mr. Chairman, are you satisfied with what's in the bill? Do you think this is going far enough to address the issue of Bridgeport and potentially where that might be happening elsewhere?
I'm definitely satisfied outside of, some of the comments I have in our written testimony. I think every system needs tweaking, right? And sometimes it is better to err on the side of solving. I hesitate on how to phrase this. We are at risk, I think, of overcorrecting and disenfranchising the vast majority of voters based on a few bad actors. And I can only qualify that based, I'm not a judge, I'm not an investigator, so I can only qualify that based on what has been reported to me. This is where 441, I think, is a tremendously helpful bill because you don't risk broader disenfranchisement. And if you have a real issue in one municipality, you would then have the opportunity to insert the force that you need in that one locality without, making Canterbury do the same.
Understood. Through you, Mr. Chairman. So, Madam Secretary, I mean, you used a lot of different language, that I've been writing down keywords, not just pockets either, which I thought was interesting. Pockets, barriers, tweaking. You just said overcorrection. I certainly am sympathetic to those ideas, except I would disagree. I don't think we're anywhere near the point of overcorrecting. In fact, I don't think we're addressing the problem at all. I don't see how creating please, folks, we don't.
Sorry, just for everyone, there are no demonstrations or speaking out of turn allowed in committee hearings in the General Assembly. Thank you very much. And please continue, Mr. Ranking Member.
Thank you, Mr. Chairman. Yeah, no, and again, I mean, my duty here is to ask you questions. Not to debate you, but I mean, forgive me for pushing back a little. I know that we've had this. You and I have been debating this issue since you were sitting on the committee and numerous times since. The concern is, potentially depriving someone of the value of their vote. And for me, every tiny bit of potential election fraud is also impacting the validity of everyone else's vote. I don't know the extent of what happened beyond what we saw in Bridgeport. I don't think anybody knows, but I can tell you, and I can certainly speculate, that the system is the problem, and that system exists statewide. We just happen to become aware of it, as you mentioned, because of the video footage. But I'll remind everyone that there's no requirement that those drop boxes be videoed, not since they were first created. And that video footage was leaked, and in fact, I think that the police department was upset that the footage got out, but fortunately it did, and we are the beneficiaries of knowing that set of circumstances occurred. so that we can be having this conversation, which I'm very pleased of, because, you know, I was having this conversation several years ago, I think back to the pandemic back in July of 2020, when we came in for a special session on the drop boxes at that time. And I was screaming from the rooftops that this is a bad idea. We're opening up the door for potential fraud. And, you know, I was dismissed more or less out of hand by my colleagues in the majority. And the news media didn't seem particularly interested. And I've been having that same debate over and over again as we've expanded the definition of that's contained in the Constitution about what sickness means, to effectively create no excuse absentee voting out of whole cloth. Because, you know, the Constitution, I think, is pretty clear that it is very specific reasons that you would have eligibility for. But nowadays, every political cycle since 2021, you have political candidates sending out absentee ballots to their targeted voters, not caring whether they're actually sick or out of town, because they've effectively, you know, recognized that our laws in the state, coupled with it with an erroneous Supreme Court decision, in my opinion, has expanded us into the realm of absentee voting. I don't mean to get off on a tangent, but I just want to say that that's my concern. My concern is that our absentee voting system in the state is a problem. And I'm disappointed to hear this, you say that you're satisfied with what is before us as a mechanism to fix it. So let me just ask you a few things specifically. The voter rolls, you know, the generation of the ballot applications that are going out, sent by every political candidate up and down the spectrum in both parties, including the governor of our state, who in the last election not only sent out absentee ballot applications to people, he also sent out a mailing encouraging them to vote by absentee because they are eligible now based on our foray into no excuse absentee voting, or, you know, through the changes in the way the law is written. Does this any of the legislation that you've asked the committee to bring up address the inconsistencies in our voter rolls, which is the source of those ballot applications?
A few things. I think when I've had discussions about Bridgeport specifically, a lot of people have raised this issue about circulators, right? Right now, it is legal for any entity to sign out more than 5 absentee ballot applications as long as they are on file with the town clerk's office. We've had this conversation, certainly. I believe these things should be out of the hand of political parties, political candidates. I think it unfairly biases people who don't belong to the major parties. But what I am against is a removal of one system without a substitution of another. So I believe that, you know, if political parties aren't doing that, the state has to do it. And I know there's a price tag there, so people haven't been willing to move down that path. But that is actually how many states keep their voter rolls clean. Like, for example, in 2020, I know you were against this when I was on the committee. When the state did send out the absentee ballot applications, guess what? We got a lot of return mail, and it enabled us to update the towns to update the systems. When political parties are the ones doing it, you don't always get all those updates. So many states use that process to keep their rolls as clean as possible. So I think it's a help, not a hazard. And I'm sorry, you asked something else about lists.
Yeah, through you, Mr. Chairman. So the issue really for me was, you know, I asked about what we're doing to fix the voter rolls. I mean, you said a lot of things I'd love to debate you on too, which is what happened in 2020. I mean, thousands and thousands and thousands and thousands and thousands of those ballot applications were returned because our voter rolls were in error. And I don't know the extent that the voter rolls were updated or fixed after that. I'll take your word for it that some of it happened, but certainly it's still not fixed. I mean, there are independent groups out there that are right now and they contact me regularly. They're canvassing, various voters and reviewing voter rolls in every town across Connecticut and discovering, people that have passed on or moved away or in multiple jurisdictions, or, the dog is on the voter list. These are
Don't know about
problems, that need to be addressed. And my question was not about replacing one system with another one, which is what you implied I was asking for. What I'm asking is, how are we fixing the voter rolls if we're still leaving that as a mechanism for people to use as a way to mail ballot applications?
So fix, I think, is the wrong word. When I worked as a fundraiser for nonprofits, we would always have a mailing list, and we would say, the moment we finalize it, it's obsolete because data happens in real time. People die every day. People move every moment. People get married, divorce. All of these things change the voter rolls. So what is often ignored are, one, the legal process by which someone can be added or removed from the voter rolls. Sometimes there's not a distinction made between active and inactive. So if you're inactive, for example, you are still on the voter roll, but if you ever show up to vote, you have to prove certain things, like you were registering for the first time. So sometimes those things are not considered. Every town is also different because we do administer our elections on a town by town level about how often they compare death records to the updates. So if you're a town that does it once a month and someone's looking at your list and says, I know so-and-so died 2 weeks ago, it seems inaccurate, but it will be updated. And every town leading right up to an election starts to do it on a daily basis. We also get information, as you know, from the ERIC system, which is still the only system nationwide that allows shared data. So but those updates also come once a year, and all of this is timed in the election calendar to maximize the most complete information closer to the election and the recanvass. That happens. As you know, every town also has to do a recanvass every year, where they send a postcard to all their voters. So when those, if any, come back unaddressed, and Kristen, please feel free to chime in if I'm getting any of this wrong. But so when any information comes back as a result of that mailing, that's also when the lists get updated. So fixed is a bit of a misnomer. Like, it is fixed continuously, but there will always be data that is in between some of that timing.
Through you, Mr. Chairman, thank you very much for that answer. I think you kind of made my case for me. It took you several minutes to describe all of the ways that the voter rolls could be inaccurate. The thing is, the reason why we have absentee balloting at all is because, long ago, folks wanted to make sure that we gave an opportunity to people that were not able to show up at the polls in person. They weren't trying to create some whole other system. Oops.
It's just water.
It's just water. We'll send you a bill, Madam Secretary. So,
It's a good thing it's not my coffee.
so, so what has happened in the most, just in the last few years, this all happened since the pandemic, that we've reached this epic number of mail-in ballot applications and ballots that our system was just never designed for. And we're witnessing the result of that. And Bridgeport is just the most obvious one, but I think there's a lot of other results that we could point to. But the voter rolls are not going to be accurate. For the last 6 or 7 years on this committee, I have put in bills every year to audit election day registration for the exact same reason that you suggested. which is that I want to see what happens when somebody votes by election day registration. They get sent a registration confirmation after. If it's returned in the mail, somebody should do something about that, but we don't, not in Connecticut. And yeah, and I'd love to hear you, tell me I'm wrong on that. I'd be very pleased, but I'm told by the registrars that I know, nothing is done. There's no audit process. They don't have a mechanism in place. Absentee ballot audits, I know that there is some sort of mechanism for that, but I don't know that it goes to truly addressing the problem, which is that our voter rolls really are out of whack. During the pandemic election, I had folks reach out to me, letting me know that they received 5, 6 ballot applications for people that lived at the address prior to them. So that's just, some examples of just how out of whack it could be. I listed many of these on the floor of the Senate during our debate, the many, many letters and calls that I got. The bill does address drop boxes. If it was up to me, we wouldn't have had drop boxes at all. I don't think they serve any legitimate purpose whatsoever. It's an open door for fraud. But they only have one advantage over post office boxes from a voter standpoint, in that they are able to be used, at town hall effectively right up to the election, with a little less fear of relying on the mail at the last minute. But getting rid of drop boxes isn't really going to solve the Bridgeport problem from my standpoint. And I'd just like to hear your perspective on that, because I mean, what quote unquote Wanda, what she did, she could have easily dropped those same ballot applications or ballots into a post office box. I mean, she could have actually walked into the town clerk's office and handed them in. I mean, I don't know that it would have made any real difference. How does getting rid of drop boxes or deciding that we need to monitor drop boxes right now, which I'm in favor of, don't get me wrong. I'd say, number one, get rid of drop boxes, but if you can't get rid of drop boxes, then we should begin to monitor them. How does this address that problem from your perspective?
Which problem?
The Wanda problem.
Well, as you say, if drop boxes are under surveillance, it gives options, right? To see exactly how they are being used, who's using them. The mailbox does not have that requirement. It also, what I like about drop boxes, they're locked. They're only open during the election period. So, and part of the 5498, I believe, yeah. There's also requirements in there. We thought the judge had some good ideas about making sure that town clerks are tracking where the absentee ballot applications or ballots are coming from, a Dropbox, the mail, in person, etc. I think, I talk to a lot of people, everyday people who may never come to this hearing room, and I hear stories all the time, and that's what I use to help inform my work. And it may sound like a mailbox, Dropbox, it's all the same, but people are very specific about how they want to exercise their right to vote. And I've talked to a lot of seniors, for example, who like putting it in the Dropbox because they know that an election worker is the only person touching that envelope. They feel it's more secure than a mailbox. They feel that, they take pride almost. It's like it's the next best thing to going in person, which might be hard for them because, they don't feel great all the time, or they can't walk or stand for a long time, but they get someone to drive them over and they put their Dropbox in. They put their application or their ballot in the Dropbox, which is easier than if they might not be able to get out of the house on election day. And some of the stories I've heard are there are some people on medications where they don't feel, they don't know if they will be well enough to get out of the house on a certain day, and they'll have their caregiver on a good day because now they have 30, right? To go over and drop off their ballot. So people like having both options.
Through you, Mr. Chairman, I appreciate that. I mean, certainly, I would wish things were a lot different. I wish I didn't have to go in person to, renew my driver's license or, I mean, I wish a lot of things, but that doesn't mean that it's necessarily good policy to open up the door to mechanisms that might be rife with fraud. And that's the concern I have. Secretary, you didn't really answer my question. I'm not trying to
Oh,
be
no, it's
hostile
fine.
to you at all,
Fine.
but I did ask you a pretty direct question, which is, how does this solve the Wanda problem? I mean, what are we doing in this bill or in any piece of legislation to actually solve the problem? I know you mentioned a few things around the edges. It amazes me that we were not tracking, where these absentee ballots come from, whether they come from a drop box, post office box, or dropped off at the clerk's office. I mean, I can't even believe that actually is not already monitored. So thank God we're going to address that. But the fact of the matter is, I don't see anything changing with the system. We're not going to update the voter rolls. The absentee ballot, harvesters that, do that around the state are going to continue their activities. Maybe there'll be a little more scrutiny on them as a result of the attention that's gone on for the last year. But I'm afraid that if the attention goes away, so does the any diminishing of their efforts. And the fact of the matter is, as we mentioned before, every erroneous or faulty or fraudulent ballot is taking away someone else's legitimate vote. So the person that you described, the elderly person that, might want to vote by drop box or by mail-in vote, I mean, their vote's going to be canceled out by somebody, in a Wanda type situation. And that's what I have as a frustration. People are genuinely frustrated and doubt the validity of our election process. We're going to hear testimony from a lot of people today, and I think that's going to be a theme. People are going to say, I just don't trust the election process anymore. And that's new. I think that's new since 2020. I certainly won't put that on you. You weren't the Secretary of State at the time. But and I know that you've been trying to manage this situation, which I can't even imagine how difficult it has become given the circumstances. But is there, to my question again, I'll ask it as directly as I can, is there anything in this bill? I mean, I get we're gonna monitor drop boxes. Okay. To me, I mean, I don't know what that means. There's gonna be a video camera on it. I mean, who's gonna watch all this footage? Is it gonna be stored? Is it gonna require someone to go back and watch all of it? Or is it just gonna be available for someone else to look at? These are questions, but at the end of the day, I don't know that matters. If somebody wanted to put harvested illegitimate ballots into a drop box, if they knew they were monitored, they're just going to put them in a post office box now. I just don't see how that fixes anything. And even monitoring with a camera, I don't think is going to catch somebody. I don't know that anything conclusive has come out of Bridgeport. I don't know that those individuals will ever be charged because of anything that's ultimately conclusive about how many ballots they were putting in the box, et cetera. And all of that is a concern to mine. And it's all part of this new creation, which I don't know has done much to generate the ability for people to be able to vote that they didn't have before. My argument, and I know I've presented to you many times and to this committee, which is that you can leave things as they are. You can have the expansive access to voting that we have that has been created largely by the majority. I'll give you credit for that. But you got to have something on the other side of the coin, which is an element of security and integrity. And the number one thing I would suggest, which seems to be a non-starter, and I'll pose it to you one more time, in companion to my question is, how does this address the Wanda problem? Wouldn't my idea that we get rid of the unsolicited mailing of ballot applications, period, so from anyone, from the Secretary of State's office, from municipalities, from candidates, Wouldn't that go a long way? Because what it would do, it would say to that person, the elderly person you were talking about, or anyone else, that if they wanted to vote by absentee, they still can. It's just that they have to take the initial effort of requesting it, which could be done super easy, internet, phone. You could make it happen a lot of different ways, and I'd be willing to even open that up. Yeah. So, what's your response?
Okay, so I'll use your words, the Wanda problem. What would solve it would be adjudication of the charges levied over years. I have no control over the court system. As I think most people know, the same person was named in a case in 2019, which was referred to the courts in June of 2023. And that is still presumably moving through the process. So what would serve, and I assume by the Wanda problem, you mean bad actors who are allegedly interfering with our election system. We have many laws on the books. We have fines, we have jail time, but those cases need to be adjudicated. And there have been bills in this General Assembly this year talking about court process, court timelines, etc. That's outside of my scope. Many of the things that we have suggested would help solve the types of problems we've heard about. I do believe the biggest loopholes are the amount of time that absentee ballot applications are available before an election, and the so-called banking of absentee ballot applications by holding on to them for a long time. So closing those windows, I think, would be very helpful. And again, we have agreed to disagree many times in the past, although, I feel very strongly about protecting this system because it's what I was elected to do. But I have to do so outside of the news headlines, the media glare. I look at the entire process. I speak every day to the people who are on the ground doing this work. I listen to them. I take their suggestions, their recommendations, and I also have to listen to the voters. And I take all of that data and try to walk a fine line between making sure that people have the opportunity to express their right to vote in a way that works for them while closing any potential loopholes that would open it up for broader malfeasance. There are some people who say absentee ballots shouldn't exist at all. And there are also 8 states that conduct their elections entirely by mail. And that is the beauty of the United States of America. And we just have to find the system that works for us. And I think we'll find out what people think with the constitutional amendment on the ballot in November, which is obviously outside the scope of today. But I believe in letting the voters decide and making sure that we are providing opportunities for people who are good actors, which is like 99.8% of our electorate. And something like 441 is aimed at really clamping down on the minority.
Thank you. I'm just going to interject very briefly. I just wanted to make sure, keep us on track with how we're talking about things. And generally, we don't make reference to specific individuals or allegations in our hearings. And so I would just caution everyone, both in terms of our rules, but also just in terms of the kind of the quality of the conversation and the precision. It would be best if we are referring to any problems or solutions that we refer to those problems in terms of what the actual specific problems are, not in relation to any person or their name. Thank you. And Senator, please continue.
Thank you, Mr. Chairman. I appreciate that. I was using the term simply for the edification of people watching who would know exactly what I was talking about by doing so. I appreciate the feedback, Madam Secretary. I mean, you started by talking about adjudication, and I'm with you. I mean, you know, I've listed all the convicted folks over the years based on absentee ballot fraud, and there's a rather lengthy list that you can go through from numerous communities, not just Bridgeport, around the state, going back several decades, and I've pointed those out on the floor because many times, you know, when you start talking about election fraud, you know, people on the left tend to say that you're making it up, you're exaggerating, et cetera, and I don't think I'm exaggerating. I think I've been very forthright about pointing to legitimate occurrences, and the Bridgeport issue is definitely one of those. And I appreciate the bill that's before us. I mean, I do have concerns about a couple of sections of that bill, but overall, I do support the ideas that are in there. I just don't think it goes anywhere far enough, and I don't think it addresses the problem that we have been discussing. I especially like the loopholes that are being addressed, those timelines that you mentioned, and the banking issue that you described. But those things I think, are going to continue, maybe not on a significant a level, because the fact of the matter is what's happening here is that by virtue of having either the state or municipalities or individual candidates mailing out ballot applications to people on the voter rolls, people that don't legitimately deserve to receive them are going to. That's just a fact. People are going to receive them for prior residents of addresses, for their kids that have moved away to college. And the sad reality is some people are going to fill them out. This is the reality. Not everybody, might be a very small percentage of people, but some people are going to fill them out for their parents. Some of them are going to fill them out for their kids away at school. Some of them are going to fill them out for their elderly, relatives. It's going to happen. I think it has happened. And elections are decided by small margins. In the town of Southington, in the last state cycle, we had an election decided by one vote. And an enormous number of absentee ballots were cast in that election as well. I also, would just remind everyone of some of the frailties of absentee voting, which is that a significant number of votes are thrown away at the end of the day. That doesn't necessarily happen with in-person voting because people don't follow the proper protocol about putting more than one ballot in an envelope, and votes that were dropped off in drop boxes and post office boxes after the election had already gone by. There was a huge dust up in this committee 2 years ago because I made a big deal about a drop box that had a bunch of ballots stuffed in the door of it. And, the SEC investigated and they came back and they were so pleased to tell me, oh, Senator, no, that was perfectly legitimate. There was nothing wrong with that, except for the fact that those people thought they were having their votes counted, but their votes didn't count. There's nothing to celebrate. So I think what we've done is we've taken what used to be our in-person voting system that makes allowances for the fact that some people can't vote in person by creating a program that allows those people to vote by mail through our absentee system. And we've turned it on its head. And now we are trying to expand mail-in voting when we don't have protections. You mentioned 8 other states that have mail-in voting as a regular means of voting. Those states also design their whole system with that in mind. When they register someone to vote, they take legitimate data. I don't know, maybe some of them take a fingerprint, for crying out loud, but they take some way to verify someone's identity, and then they track it and they keep that those voter rolls secure. And then when you actually submit your ballot, you have an identification number or a signature verification process, or you've got to enclose a copy of your photo identification. We don't have any of those things. So what I see is a wide open door for people. You call them bad actors, and that's indeed what they are. I just think there's way more of them than just one or two people in Bridgeport. And I think every time you have a Bridgeport redo, we find out just how extensive this problem is. But I think it's happening all over. Maybe not in, tens of thousands of votes, but it wouldn't take much. As I won my first election by 46 votes. Again, the election that was decided last year, it happens every cycle. There are elections decided by a handful of votes. And who knows just how many of those are being impacted by this. I mean, I share every concern you have about disenfranchising voters. The fact of the matter is that I think having a system that cannot be relied on is the biggest potential for disenfranchisement. There are a bunch of things that we could certainly talk about. There is nothing in this bill about photo ID for in-person or for absentee voting. Getting the recording the drop boxes doesn't, in my mind, solve a problem, which is people filling out ballots that don't belong to them and then delivering them to either a drop box, a post office box, or in person. And the easy solution is the unsolicited mailing ban that I've discussed, which you didn't really address, but I take it that you're not in favor of getting rid of it.
I just don't think that would solve the problem that you described before for the reason that I described before, which is in some of these instances, bad actors co-opted valid votes, right? From the voter perspective, they did everything right. They just didn't know. I do think public education would be one of the second most powerful things to solve a lot of these issues, because most people, especially if you move here from another state where things operate differently, or you don't follow the GAE committee in the legislature, you're not intimately associated with Title IX, what is or isn't legal. And I could easily imagine if I went to one of my neighbors' homes who was elderly and said, "Hey, I'm going by town hall. Can I drop off your AB?" They would say, "Oh, that'd be great. Thank you, honey." And they wouldn't think anything was wrong with that. So getting information into the hands of voters across many different election-related issues, I think is of huge importance.
Yeah, through you, Mr. Chairman. Thank you for that. I don't disagree, except that I don't think that that's the problem. Certainly those people intended to vote, and their vote would end up there either way. I'm more concerned about people that are acting maliciously and for the purpose of disrupting our election process and us creating a system that allows it to happen instead of focusing on security. But I suppose we could beat that horse all day, Madam Secretary.
Can I give you an example? If you don't mind. No, I think of it as counterfeiters, right? Like there are people who counterfeit US currency, and it was a big problem. I remember my first job at the local ice cream shop. There were news stories all the time about all these counterfeit $20 bills. And what the US government ended up doing was getting more information into the hands of little shop owners like my boss, making sure we understood, hold it up, look for the threads. This was knowledge that was not generally available, but we learned that there's no way for the US Treasury to police every single $20 bill, and that you had to rely on the people understanding what a counterfeit bill looked like so that you could stop it close to the root. If a town saw a proliferation of counterfeit bills, the feds knew where to attack. We have to empower people to understand and act on malfeasance when they see it. We can't be the only ones to reach out and try to block every bad actor. So the same lady who told our election monitor, I gave it to the nice lady to drop off. If she knew that weren't allowed, we might have gotten a very different call. She might have called and said, someone tried to take my ballot, and that would allow us to get to the root of the problem. So I think we have to also empower and educate people to help us root out problems where they do exist.
Through Mr. Chairman, thank you, Madam Secretary. I appreciate your example, except I would put it that, the government improved the money. They decided to change the way they print bills. They put different types of security protection measures in the money. They improved their security to combat the problem.
And there are still counterfeiters.
There is, but I think it's a lot harder to counterfeit a bill today than it was, 20 years ago. And the sad fact is that in the last 3 years, it is way easier to cheat in a Connecticut election than it was before. That is why we're here. That is why I'm asking you these questions, because this bill doesn't go nearly far enough. It doesn't even scratch the surface in addressing what went on in Bridgeport and is happening at some level across Connecticut. And there are going to continue to be problems. And I'm going to say it on the record right here. Watch. I told people in 2020 on the floor of the Senate, I said, watch. And I'm saying it again today, watch. We're not addressing the problem. And sadly, I think it's because a lot of people like the system the way it is. And that's unfortunate. I want to see people have the most access to voting possible without interfering with anyone else's, the validity of their votes. And that concerns me. Madam Secretary, I'll just wrap it up. I hope that we can continue on the things that we do agree on. And I do appreciate that you brought some things to the committee that we will no doubt act on that will help the system. I just, as I said, I don't think it goes anywhere near far enough. And I know there's a lot of other topics that we should definitely talk about, and maybe this is not the time and place, but I would just think, with early voting, coming into play, I mean, I think that ought to be enough of a mechanism to kind of scale back the pressure on more mail-in voting, because I think that the in-person voting actually solves a lot of the concerns over, giving people access without the potential for so much, wrongdoing and bad actors being involved. I appreciate your time today, Madam Secretary, and that's all my questions, Mr. Chairman. Thanks.
Thank you, Senator. Questions from the committee? Representative Massey-Francesco.
Thank you, Mr. Chairman. Madam Secretary, very nice to see you again today. Senator Sampson actually covered a lot of the questions that I have, but I do have a few follow-up. On Senate Bill 441, the board that we are creating here, in part of that bill, it says that the board is to adopt regulations in there. Can you tell me
Can-
exactly what that means? I
Can you
think it's
give
in
me a line
section
number?
4 of that
Or-
bill. I don't have the line number. Let me look it up here. Give me a second.
Oh, I see. Are you referring to line 150?
Let me look here. Line 150. Yes. So I'm curious, maybe give me an example of a type of regulation they may adopt, and are they supposed to report back to this committee? Does their recommendation or the adoption of the regulations, are they voted on by the legislature? Through you, Mr. Chairman.
And I didn't write this sentence, but what I suspect is that by regulations, it is meant that this is a volunteer board, so they would have to put together a working system that's transparent to the public about how the board operates, and that they would do so by January 2025 to conduct the activities in sections 1 through 3.
Okay, yeah, it doesn't specify that. What you said in here is very broad. So they're just saying that the Municipal Election Accountability Board shall adopt regulations. That could mean anything. It could mean anything. It's very, very broad in here. So I had a question on that. So I guess we will try to iron that
That's a
out.
fair point
Yeah.
for the committee. Certainly in my testimony, we made some suggestions about how the review process might work, et cetera.
And you did mention when you were speaking with Senator Sampson through Mr. Chairman, that you did have some recommendations on this particular bill. Can you tell me what those are?
Oh my gosh. Yeah, so like I said, the original concept from this bill, I think we created the idea because exactly as I said, there's a huge gap in between our jurisdiction. You know, people often think we can tell a registrar or a town clerk how to do something, when to do something, but we don't have that authority. But there are times where issues come up where it would be helpful to be able to compel a town to undertake additional training or talk to their peers to adopt a best practice, and so many other types of things that come up every day in election administration. So the idea of it, definitely we suggested. In terms of every section, I think the easiest thing to do would be to look at our testimony. Section 1, we definitely thought that this could not rest in our office because we don't have the administrative support. We have 3 admins in our entire election division. I also thought it should not rest within our office because I think it should be a more neutral body, sort of absent being housed in a constitutional's office. In section 1 also, one of the things we did not suggest was being on the advice and consent of the General Assembly for the board members, because we have already pretty narrowly defined who can name people to be as nonpartisan as possible. 2 registrars, 2 clerks, 2 town leaders, but those people would be drawn from names suggested not by our office or SEEK or anyone, but from the Registrar of Voters Association, the Town Clerks Association, COST, and CCM. So it felt like a conflict. We already have a narrow scope, and I think going through the General Assembly might be harmful to the timeline. And the caucus leaders already have the ability to name people to the committee. In section 2, we talked about, in terms of the process, based on what we see during election season, and I'm sure SEEK would echo this, you get a lot of people reaching out with concerns. And as outlined here, I think any volunteer board would be suddenly overwhelmed because you could get dozens of complaints. So we suggested a monthly standing meeting, and we also suggested a process by which the board gets all the information first, especially in the case where an individual is making a referral, and then they have the public hearing, which is a slight tweak. We also talked about where we thought the tier structure should fall, and also how someone can get off a tier, especially if they mitigate before the timeline set by the board. And then lastly, Actually, that's basically the process. I mean,
Okay.
it's very detailed.
Thank you. When you talk about, through you, Mr. Chairman, when you talk about the members of the board, and I always feel that when we're dealing with election laws, that it should truly be bipartisan.
Mhm.
There should be no, more Republicans than Democrats, no more Democrats than Republicans. So when you talk about the town clerks, the registrar of voters, you said there would be two. Would there be one from each party representing? And will this board completely be even registered Democrat, Republican, or maybe somebody independent?
Yeah, I was gonna say, I believe it should be nonpartisan, right, which is different than bipartisan. Right now, our registrar system, towns have a Republican and a Democrat. But all of the members of the board are to be chosen, opposing parties. The legislature can name 4 people, and we just said they shall have expertise in election administration or election law, so not party specific at all. And the same is true of the other designees.
Okay, yeah, because, thank you, through you, Mr. Chairman, I don't see anything in here that actually specifies that. Sometimes they'll do a task force, they're doing appointments. They will say one selected by, the chairman of the committee, the ranking, or the minority party, majority party. There's nothing in here at all that indicates that this board would be bipartisan, and that's why I'm questioning.
Nonpartisan, and it says, like, for
Or
example,
bipartisan.
line 30, must be enrolled in different political parties.
But that's when they're talking about the registrar of voters. That's only for for Rovac.
And town clerks on line 33, and town officials on line 36.
See it, okay. I see.
And then, like I said, for the legislative leaders, there is no requirement, just election administration or election law, line 41.
Perfect, thank you.
Mhm.
And as you had mentioned, your office doesn't have the authority to do certain things, which was really going back to my concern of this last section of the bill where it talks about the Municipal Election Accountability Board, they shall adopt regulations where you have no authority. I would hope the same thing will apply to this, but this part of the bill is really concerning because who knows what they could adopt without the legislature's oversight or approval. So that was a
yeah.
concern. So
Sorry, may I, my colleague? has-
Sorry,
Sure.
Kristen Sullivan, Director of Elections. I just do want to point out that in that section, section 4, they do have to adopt regulations, but in accordance with chapter 4, which is the UAPA. So those regulations would have to go before the Regulation Review Committee. I think the Attorney General, there's a whole process. So that's the standard language for adopting regulations with oversight.
okay, thank you. And then would that, through you, Mr. Chairman, would those regulations come back to this body?
The Regulation Review Committee.
Okay, thank you very much on that. Just a couple comments, and I agree with Senator Sampson on some of these things. I see that you have 3 tiers, the serious one being obviously tier 3. Is there anything in this bill creating this board that you feel would really deter a bad actor from committing election fraud? And that's what I'm really looking for here in all of this language that we have here today. What is the deterrent? In this particular thing, the board is good, it's oversight, I get it. But I don't see anything in here that is going to deter them from doing it again. The part on section, on tier 3, you talk about the fraud has already been committed, right? The election's over. They've been, SEEK investigates it, whatever, they go to court. But the fraud was already committed. I'm looking for something that's going to stop or deter bad actors. And I just don't see it in this board.
I don't think you can always deter bad actors, right? They're bad actors. And we already have many existing laws, fines, etc., meant to deter bad actors. You have to build infrastructure. And I think what's good about this tier system and this volunteer board, there are more eyes on the problem. I think about some of the people I see here today that I've heard testify in the past, and I'm sure they will testify to similar things happening in certain localities again today. In this bill, they would now have a remedy. They can refer things that they see on the ground that are troubling. Right now, the burden is on them to know that it is a bad enough problem to refer to SEEK. And SEEK has 1 year to investigate, and they also have to find that Title IX was broken. It is very hard sometimes to track down these issues because it's often hearsay. I know our election monitors, just in the redo, received calls. I heard, someone told me. That's incredibly hard for SEEK to investigate. In this board structure, you get those types of referrals by any individual in this room. They have to look at it. They're looking at it in a much more timely manner, and they can remediate actions quickly. The remediation might be go to this building or this street where all of a sudden 50 absentee ballot applications have come in from, and see what's going on there. I think this does a huge amount to solve the problem.
And I appreciate that. You know, obviously more eyes on the process is always good, right? 4 eyes are better than 2. I certainly agree with that. I guess I'm just looking for something that's going to deter. And you said we cannot deter bad actors. How do we know that? We haven't had any significant penalties in the state of Connecticut to do that. So we don't know that. Because obviously, right, what we have here needs changing. So we don't really know for sure if we can deter bad actors. I mean, we can say that in pretty much anything, but you know, when you have harsher penalties, or there's more oversight, or there's fear put in that bad actor, it may prevent them from doing it. But we can't even say here in the state of Connecticut that it will not deter bad actors, because we don't know, because we have never done it. So that was obviously a concern I have. If I can, I have some questions on the 5498 bill.
Yes.
Thank you. Through you, Mr. Chairman. And I believe it's in the first section. It talks about the video recording devices for each Dropbox for the municipalities. And that is required by July 1st of 2025. Why is it 2025 and not immediate? Through you, Mr. Chairman.
Again, I had suggestions. I didn't write the bill, so I will try to guess. I actually, in terms of video surveillance, I actually suggested a later date because I was sensitive to all the towns right now implementing early voting, and I was loath to create another unfunded mandate, quite honestly. However, given the SEEK referrals we've had to make, I agreed that moving this date up, the issues that generally occur are in the municipal election years. So we felt strongly that there should be a date before the next municipal election, but still give towns time enough to implement this when they have so many costs this calendar year.
Okay, and you had mentioned that most of this happens in a municipality's election. I don't necessarily know if that's true. I think things like this happen in every election. As Senator Sampson said, a lot of our House seats, state seats, have been lost by lost by very few votes, and sometimes they're questionable. So I don't necessarily know if it's just on municipal elections. And I am not in agreement with drop boxes to begin with, right? I don't really think they're necessary, but it's very evident that they are not going away in the state of Connecticut. So some oversight on them, I think, is appropriate. So with these drop boxes, are the towns are required to buy, can they use any kind of equipment that they want? Are they required to be put in each location where the drop boxes are? For you, Mr. Chairman?
The bill assumes any Dropbox that you have is monitored.
And then the cost associated with those drop boxes would fall on the municipalities, I'm assuming.
Unless this body granted funding.
Yeah. So I'm thinking about small towns. Like I said, I don't believe in the drop boxes to begin with, but I'm thinking about small towns. Maybe they have one drop box and they're a small population. Would they have the option, or would you recommend to this committee that instead of doing a camera, that town can just do away with the drop box completely?
No,
Very small town. So they would be mandated as well to put in a camera for the drop boxes. And then that would be, in your opinion, you're okay with that.
I think it's a bit of a loophole that existed that, many towns, and I'm happy to do a survey. I don't know the number off the top of my head, but many towns, based on the prior secretary's recommendation, placed the drop boxes to begin with in locations already under surveillance for the security feature. So many are at town hall, police stations, fire departments, that type of institution. But it was a loophole that footage did not have to be retained. And that is the bulk of what we are putting here, because if SEEK has 1 year to conduct an investigation, what happens if that footage would have been helpful to have to prove or disprove a case? So we are requiring that people who already have drop boxes under surveillance retain that footage to make sure, because there's no guarantee that if you're in a small town, there's not an allegation or a case, etc., where that footage would be needed. So that is a lot of it, but also this is suggesting that footage be made public.
Thank you. And through you, Mr. Chairman, the footage that is to be made public, is that just simply by request to the town? Does it have to go through Freedom of Information? Does it have to go through SEEK? How does one, if someone suspects that there's something going on with a Dropbox, how does one go about requesting the footage? Through you, Mr. Chairman.
I believe, and maybe jump in if I'm wrong, Kristen, as I recall, I think the intent was that it would be posted to a public site, maybe the secretary's site or this board site, where it would be available, and they would have a timeline within which they have to post.
Okay, so based on what you're saying, it appears that there's probably going to be some maybe put on the website where people can just kind of randomly go on there and look. And also it requires the municipality to retain the video for 12 months unless there's some form of an investigation. So in the case of Bridgeport, I'm assuming that video footage is being retained. For how long will that, once the case is adjudicated and it's done, will the video then be destroyed, or is it saved for many more years?
I have no idea their police retention policies. Obviously, we've had election monitors there, so we have all the footage during that period. And again, that's a loophole we think should be closed for all Dropbox surveillance.
Okay, thank you. Through you, Mr. Chairman, on section 3 of the bill, when it talks about the absentee ballot applications, should someone need an additional application ballot, because like you mentioned before, maybe they spill coffee on it or whatever. That section only applies to someone requesting a second ballot because of an
Correct.
error. Has nothing to do with anybody else.
Correct.
Okay, I just wanted to confirm that. And in section 4 of the bill, all we're really doing is clarifying that it's a felony to willfully, and we hear this this a lot, because it has been said in this committee that we don't want to make penalties too harsh, because innocent people may not know that it's illegal to touch a ballot, have somebody else transferred and so forth. But the language clearly does say that it's willfully. And all we're doing on that section, if I'm not mistaken, is just adding in a portion about mailing it, putting it in a Dropbox and so forth. Is that correct? So we're not changing any of the penalty. We're not making it harder for them. We're just really adding a section that, listen, you can't put ballots in a Dropbox.
No, this is extending what already exists about forcing, coercion, bribery, etc. Extending that same language to drop boxes, early voting locations, or same-day election registration locations.
Correct. And through you, Mr. Chairman, that already is the law, right? The policy right now. You can't influence or attempt to influence anyone in that part.
Correct.
But the part that we're adding in here is the part about putting it in the mail, right? Depositing in a secure Dropbox or person at a polling place or designated early voting or same day election registration location. We're
Correct.
just adding that portion in there.
Correct.
And letting them know that it is a Class C felony.
Correct.
Just informational. We're not enhancing any of the penalties on.
We're just making sure there's
They-
not a loophole that now that we have other types of entities like early voting locations, which didn't fall into the existing law. So we want to make sure that it still is a Class C felony.
Okay, thank you. And again, I keep harping on the penalties because I think it's so important that these penalties be harsher.
Yeah.
And I know you have mentioned when you were talking with Senator Sampson that people may not know the law.
Yeah, but
And-
that to me is not relevant. This body at some point in the past, I don't know what year, decided that $5,000 and 5 years up to 5 years in jail would be the punishment per incident.
Ooh.
I happen to think that sounds like a fair penalty. But I have no control over why these cases haven't been adjudicated. But as I said last week when I was here, I believe I agree that part of the way to deter some actions are to make sure that people are held to account when they are caught.
I guess we disagree again.
Fair.
Yeah. Yeah.
Yeah,
Yes,
yeah. Oh, sorry, my colleague.
I just wanted to point out that under that particular statute, it's a Class C felony. So that is punishable by up to 10 years in prison and $10,000 fine, or both.
Thank you. Thank you for the clarification. And just a quick comment on that. It could be punishable, right? Up to 10 years and a $10,000 fine, but we've never seen it happen. Again, they're just words, right? It's not deterring anyone from tampering with ballots and so forth. On section 5, it's talking about the application ballot AB application, right? To include a notation of the year of the election. How does that work?
We're still working that through, but essentially think of it like a watermark that would be, so right now, people can just, if I downloaded a form last year, I can just replicate it and use it. We would be setting up a system where, you know, you can't use that form from last year, or in this case, a couple of months ago. It would have to have our watermark, if you will. And as you know, people can also apply online, which we have some control over when that portal opens and closes. And if you have something more detailed to say, feel free. But I would say the best way to think of it is a watermark.
And that is something that your office will take care of. It's not the town's responsibility to put the
Correct.
watermark or put a marking in it. Is
So
that
then our
correct, Mr. Chairman?
official form would only be available on our website at a certain time. Town clerks would be able to receive it from our office.
So you talked about a watermark, right? It's just a watermark on there. How would someone applying know just by a watermark? I mean, that it's the wrong
It would-
application.
The wrong one wouldn't be available. And if for some reason a town clerk received an incorrect application, they would be informed.
Thank you. So that application would be denied?
Replaced.
It would be so how would that happen? How does that happen? Does the town clerk have to call the voter who requested the ballot and let them know that it's the wrong one? They'll have to send them a new application to make sure that they fill out the right one. Is there any language in here that says that the town clerk would have to reject that application because it's the wrong one? Do you know?
I'm not aware. Go ahead.
There is,
Okay.
lines 190 to 194, section 6. A clerk can't provide or accept for return an absentee ballot application unless it has a notation of the year.
Thank you for clarifying that. So going back to, I want to look a little bit about section 8 through you, Mr. Chairman. It requires by July 1st of 2024 that the town clerks utilize the statewide central voter registration system right now. When are all towns doing that right now?
No, but most are. And the reason we are proposing this fix is that it should be all, and it should be a shall. Most town clerks, when they receive this information, they enter it automatically in CVRS. There are a few times where it may lag behind based on whatever reason, but now that we have early voting, it is of more importance that all this data be entered in a timely fashion to ensure that, for example, if someone has returned an absentee ballot already or returned an application, or someone wants to know if someone early voted or voted by absentee ballot, that all of that information is as real time as we can make it.
Thank you. Through you, Mr. Chairman. So they're using the system. How would a town clerk know if a ballot came back right now or an application for a ballot? No, that the person who requested it is actually that person? Or the person who signed the ballot is actually that right person? Is it just because they're signing something under penalty of perjury and that's how we?
I don't want to misconstrue what town clerks do. I really don't. I think CTCA is here testifying today, or if you feel like you want to weigh in, but I don't want to misspeak about their daily process.
Okay, I guess through you, Mr. Chairman, it's not more about their daily process. What is the current law or recommendation from your office when they get an application back or a ballot back to verify that the person who actually sent that back is indeed that person?
I do not know those statutes off the top of my head. I'm happy to go back and look and send that over. I don't know.
Okay, it's pretty significant to me that there's no verification process in place. Because I think if there was, that'd probably be a big deal and it probably would deter or prevent a lot of misuse, I would say.
I
But
honestly can't
is-
confirm or deny what I've learned over this last year is that election law Title IX is incredibly wonky and detailed and yeah.
Okay, so you would maybe agree that we do not have any laws on the book right now to verify a voter. That must be verified
No,
when it comes to
I-
an absentee ballot or an absentee ballot application.
no.
Aside
I
from them
disagree.
signing off their penalty, attesting to who
Well,
they
no,
are.
the CVRS, the centralized voter registration system is the place where you check if a voter is eligible. So town clerks aren't just getting a application and saying, hey, Jane Doe sent an application, let me just send it out. They're looking them up and making sure that the application has come from an eligible voter before they send it out.
Okay, thank you. And through you, Mr. Chairman, yes, it's just, they're just cross-checking to see the name on that application is on the system to make sure that they are an eligible voter.
Well,
That's
Well,
all they're
not just
doing.
on the system, but eligible in the system.
Correct.
Yeah.
And that's what I did say, eligible, but there's no checking, obviously, a signature, photo or anything like that to make sure that they are actually the person who handed it. That's the
It
point.
may actually vary because all of our 169 towns may do things slightly differently.
I would like to see that data. I'd like to see one town that is actually checking signatures, to do that. When it comes to the absentee ballot applications, in section 6, it talks about the municipal clerks from providing, no more than 5 absentee ballot applications at a time. Is that correct?
Section 6, give me a moment.
Fine, yeah, it's on lines. I believe it starts on lines 185.
Yeah, section 6, and Kristen, please correct me if I'm wrong, has more to do with the window in which the applications are available, not the quantity.
Okay, through you, Mr. Chairman. I'm looking specifically on lines 185. It doesn't say anything, I don't believe, about the timeline unless it's referring to section 9-140, but no municipal clerk shall provide for an election primary or referendum more than 5 absentee ballot applications at a time to any person earlier than the 90 days prior.
Correct. So the 5 absentee ballot applications is existing law. So this is changing the time frame. So 187. So it's setting a new time frame for the existing law allowing more than 5 absentee ballot applications to be taken out.
So through you, Mr. Chairman, current law right now, there's a time you can't take out more than 5 at a time. Is that
No,
correct?
there's no time frame. In current law, I could submit an absentee ballot application for an election 10 years from now. That's the loophole we're trying to change by making it a limited time frame.
Right, and you're also limiting the number, excuse me, of applications as well. to
No,
5.
that's existing.
That's what I just asked you before. It's existing now, it's 5.
5,
You're just changing the date on there.
correct.
So if existing law right now is no more than 5 applications to a
No,
person.
5 or more, you have to register as a circulator with the town clerk.
Okay, perfect. Thank you. And just to follow up on that through you, Mr. Chairman, when they circulate, they're supposed to, I believe they have to put a number down on them. They are
Mhm.
supposed to give an Excel spreadsheet or to the town who they gave those applications to. I don't know if you have the data for all 169 towns, but are they required to report that to your office?
No, they don't. Yeah. So town clerks have to keep a log of who signs out 5 or more applications. They have to number those applications, if you will, so they can track it. And the person who signed them out has to be the only person who circulates them. So if I sign them out, I can hand them out to everyone in the audience. But if I gave them to Kristen to hand out, I would have to tell the town clerk, I'm also giving them to Kristen before she hands them out. So all of that is existing law. What we are trying to close here is the ability to have those applications circulated anytime for years or for a specific window.
Thank you. And through you, Mr. Chairman. So you had mentioned that should someone take out applications at the town clerk's office, they have to let them know they are supposed to be the only person circulating them. If they were to allow someone else to circulate them, they would have to let the town clerk know
Correct.
at the time they take out the applications or at any
Just
time.
before the person circulates.
And should they not report that to the town clerks, how do we know if they are just, I went out, I took out 500 applications. I went to someone here's 20 for you, 20 for you, go hand them out. How
Well-
would we know that if they don't report it?
When the circulators take them out, they receive a list of these rules about it. I can only give a recent case during the redo of the election. Someone saw a photo at a campaign event or maybe in a campaign office of some of those applications, like just sitting on a public information table. And something like that got referred to SEEK. This is where having more eyes available, having individuals understand that if they see something, they should make these referrals. In this case, it came to our election monitor, so we made the referral. But yeah, it's anytime anyone suspects that someone is circulating and not authorized, they can also call the town clerk and find out if that person is an authorized circulator.
Thank you. I just have a few more questions. There's really a lot to this bill to go through, and I'm sure other people have questions, so I don't want to tie everyone up. I guess we can iron out the details when this bill comes before our committee. We've talked a lot today about the solicitation of absentee ballot with the applications. And I wholeheartedly agree with my co-ranking member here, Senator Sampson, that's where the problem lies. In my opinion, we talk a lot in this committee about disenfranchising voters, but when a group goes out and gets 500 applications and they send them out, right? They're targeting their voters. Any campaign, anybody would say that. They're targeting specific people, and the other campaign is targeting another specific group of people. But what about the people that are not being targeted? Aren't they being disenfranchised?
I agree. That's why I think the state should handle it.
Right. Well, I am glad you agree with me. We agree to agree on the substance of it. I don't necessarily agree that your office should be mass mailing them out to everyone. Our voter rolls obviously need to be cleaned up. And, but we talk all the time in this committee about disenfranchising voters, but yet we disenfranchise them intentionally by taking out mass amounts of applications and just sending them to a select few people. I agree that policy obviously should be changed. It doesn't look like this body is willing to take that up. There are some decent things in here that I agree with. I don't think this bill is perfect. I don't think it's going to deter bad actors. I think we will see, but I don't believe it will. It's it may be a step in the right direction. Yes, there's some good things in here and maybe some things that I have concerns about. But I don't necessarily think it's going to stop. Because we don't know what, unless we, make it harsher and make some significant changes. I think it's a Band-Aid and it'll, it may do something. I don't know. I guess we'll see. But I think there's some things in here that I would like to see changed and obviously have harsher penalties for people. It's just something in here. I just don't see where it's going to stop, anything. It's like, when people break into your homes, they put a lock on the door, right? They put an alarm in their house to deter people from coming in. And I know that's probably not a great analogy, but I don't see anything in here that's doing that. Although it may be a step in the right direction. One more question, just on section 9 in this bill. It talks about about the voter registration information. Can you explain what exactly that new language does there? It does talk a little.
Yeah, you're talking about subsection 2, like 257 through 265.
Let me see, section 9, 250, yes.
Yeah. So many states, I believe it's most states now. Let me back up a little bit. The voter file is available for purchase in most states. Maybe all states, actually. I don't know if you know, Kristen, but in Connecticut, it's very cheap, $300. In many other states, it's much more expensive, and many other states have prohibitions on using the voter file for commercial purposes, outright, etc. So we have looked at many other states and their policies, and we think it's a good suggestion for Connecticut, mainly based on the price of our voter file. It saves you from having to do a lot of market research. And that's what that section is about.
Okay, thank you. Yeah, it does say that the information can be used for political and governmental purposes.
Correct.
Correct, as determined by the Secretary of State. So I guess I would like to, can you elaborate on that? What does that mean exactly through you, Mr. Chairman?
Sure. Again, we borrowed that from other states. I think it's meant to provide, I don't know, some authority that would weigh in. So if someone says, I don't know, I need to sell water and that's a governmental purpose, there would be some official entity with the state who can weigh in on that. I'm happy to have that power reside elsewhere. It could equally say governor.
Yeah, okay. Thank you. I mean, I have probably a ton more questions on this bill and need to spend more time on it. But like I said, it's probably a step in the right direction. It's not perfect by any means. I don't think it has any real significant teeth in it that is going to deter bad actors. But I appreciate your time today. Mr. Chairman, appreciate you giving me the time to ask these questions, although I could sit here for more hours, but I will give my colleagues an opportunity, and perhaps if I have questions, we can talk offline.
Thank you.
Thank you, Madam.
I'm running
Madam
out of
Secretary.
water. I can't stay much longer.
Thank you. I'm sure my
Can't spell it.
chairs are happy that I'm going to stop. Thank you.
Thank you, Representative. And as you know, and as a secretary, and as you know, the secretary and we remain open to continue the conversation with you and the other ranking member and members of the committee about the form of this bill. And we look forward to those conversations. So thank you, Representative. Further questions from the committee? Representative Hoxton.
Thank you, Mr. Chair, and through you, thank you, Madam Secretary, for appearing before us again. Like my colleague mentioned, I also like a lot of things in this bill. Maybe not a lot, but a few things. I'll give you that. But I have many more components of this bill that concern me. Now, like my colleague just said, we can't go through everything. You know, and there's some things that we can maybe discuss offline. But one thing in particular that really stood out to me, because I happened to be reading it while you were specifically talking about this topic. And that is for bill number House Bill 5498, section 2, lines 49 to 60. It mentions in there the types of designations, or I guess you could call them, you know, people that are qualified to handle an absentee ballot on behalf of somebody else. And it looks like the distinction was made between where they're listed A through D. It says after D, returned in person by the designee or immediate family member of an elector, which to me, the way I interpret that means that a designee does not have to be an immediate family member of the elector if that title is a separate term. Does that make sense through you, Mr. Chair?
And that's correct. So that part is existing law. What this is doing is just outlining that how it has to be tracked. Meaning in existing law, a designee does not have to be an immediate family member. It can be, in some cases, for example, a registrar of voters or a police officer. It's all statutory. I don't know do you know the,
Yes, excuse me. So under 9-140B subsection A, it lists all the people who can return absentee ballots, including designees, and it defines designees, excuse me, and family members in certain circumstances. So that is essentially lifting the authority under 9-140B subsection A and just copying that language.
For the new bill, through you, Mr. Chair, sorry. So the new bill will, like the old bill, allow for a designee to be someone that is not a family member.
That's correct. There's also, and I know my colleague will know the statute, the process by which a designee is declared. For lack of a better way of explaining.
Well, so that statute defines designee as someone who is caring for an applicant because of their illness, physical disability, including a licensed physician, registered nurse, a member of the applicant's family who is designated by an absentee ballot applicant who consents to such designation, a police officer, registrar, deputy registrar, or assistant registrar in the municipality. So I believe there is a consent process. I'm not sure of that statute off the top of my head, but I could find out for you.
Okay, yeah, I would really appreciate that. So there is some sort of consent process. Okay, let me just jot that down. Okay, you had used the example of counterfeit currency. Is it, you know, to make your point, is it possible, or have you ever come across anybody trying to pass a counterfeit ballot?
No.
And I'm assuming there are mechanisms in place, whether in this bill or current statute, that would prevent something like that?
Yeah, ballots are incredibly secure and detailed in that there's security built into the ballot itself that would, for example, cause it a false ballot to be rejected by our equipment.
Thank you for that. And just a couple more questions, Mr. Chair, through you. I think I had mentioned to you this particular scenario last time that you were before us, and I think it's actually more relevant that I bring it up now with what happened in my particular race. which was that I had come across a particular home where there were six people registered to vote there. No, I apologize. 5 people registered to vote there. And the person that was currently residing at that address was not one of those 5 people. The other 5 people, I think I ended up probably looking up 1 or 2 of them. And outside of the sort of voting records, I think I may have just like Googled them or something to see where they resided now. And it just looked like a case of people, various individuals that had lived there who had moved out but never changed their voter registration. But that's a total of 5 people that lived at that address. Like I said, last time you were before us, that in and of itself is problematic because it presents the opportunity for somebody to request absentee ballot applications on all their behalves. Is there anything in this bill that would try to tackle that problem preemptively before any damage is done in that regard? Through you, Mr. Chair.
Correct me if I'm wrong, no, but for all the reasons I mentioned earlier, some of it's a timing issue. Every registrar has to send a recanvass by law every year. And if any of that mail comes back undeliverable or no longer lives here, the recanvass is how they update their list. We also receive data from ERIC so that when the ERIC data comes in, and this is the benefit of ERIC and why it is still the only system in the country that allows multi-state collaboration. So if a name pops up that Stephanie Thomas is also registered in, I don't know, Colorado, California, wherever, it now gives the registrar has to look at that data and try to reconcile it. Because if Stephanie Thomas is still showing up in Connecticut and now she's showing up in another state, where is she actually living and voting? So there are other things that are done annually. So there are a lot of existing laws, existing processes that seek to solve that exact problem. And even so, just because those names are on the list, again, doesn't tell you if it's marked inactive or active, and there is a big difference.
Thank you for that. And through you, Mr. Chair. So for me, reconciling where a voter lives with where they're registered to vote, it isn't the most problematic part of this sort of scenario. It's that there are 5 people registered or more at a particular address, just to use my example, that could all those names could be subject to a bad actor who is interested in using their names to ask for absentee ballot applications. Now, we know that they're not registered somewhere else, at least within Connecticut, because if they were, we already have a system in place that would knock them off the rolls in Bristol and they would appear on the rolls and wherever they're registered to vote. I'm just more concerned about literally if that person that did live at that address was a political operative, let's just call it for lack of a better term, interested in benefiting one cause or one party, that they could take it upon themselves to call town hall, request an absentee ballot under 5 different names on 5 different days, for example. And the only mechanism that the towns or the cities have to know or to verify is the voter rolls. And they essentially would send these applications out because they would look to see if John Smith is registered at 123 Main Street and John Smith is registered at 123 Main Street. They can't know just from the voice of the person on the phone whether they're John Smith or Jane Doe. So that is really what I'm trying to get at. Is there regardless of whether those individuals register somewhere else or not, can we do anything preemptively through this bill? Is there any avenue provided through this bill where we could do something preemptively to address that sort of issue? Whether it's education that, hey, if you try to do something like that, you could go to jail for a long time, or to, maybe force towns and cities that are slacking, for lack of a better term, to kind of, pick up that slack and purge some of these, names that of individuals who no longer live there. Through you, Mr. Chair. Thank you.
The education side of that equation rests in another committee outside of this one. So yes, I've certainly proposed some education measures. I've also proposed some funding measures to make sure that there is funding to keep our list as updated as possible. In this bill specifically, as many sections, I'm trying to remember. I don't think there's nothing contemplated on lists per se, no. But there are things this committee could certainly look at, such as a second recanvass, for example. It's just another expense for the towns, but again, I think we have a lot of good procedures in place. I would love to see a public education campaign where people remember not only to register where they moved, but to tell the old place that they left. Oh, yeah, good, yeah.
Another mechanism for updating the voter rolls continually on a continuing basis is through our automatic voter registration system. And also the requirement under law that when an elector submits a change of address to DMV or another voter registration agency, that agency has to report that information to the registrars of voters. And this is happening like not just annually, but continually. If someone moves, presumably or often, they will go to DMV to update their license. I know I'm not speaking in totalities here, but this is another way that we address this.
Good point. I forgot.
Thank you, Mr. Chair. That's all I have.
Thank you, Representative. Further questions from the committee? I have a couple for the Secretary. Thank you for being here today and for very patiently answering our questions. We've heard a lot about a lot of different subjects, and I wanted to take an opportunity to clarify some of these issues a little bit. First of all, the terms voter fraud or tampering with ballots, those terms have been used in this hearing today. And it's my understanding that in the general parlance, when people are talking about those words, they're referring to a vote actually being somehow counterfeited or fraudulently filled out, something like that. Do we have has there been any evidence that has happened with regard to the situation in Bridgeport this past fall, or any recent situation?
It's a good question. I believe in all of the comments that came through our election monitors and the day-to-day monitoring. I believe there was one instance where we got a report that someone's actual vote was being coerced. Most of the information we received had to do with either improper circulation, meaning the person who signed out the ballots the applications, gave them to someone else to circulate, or like the nice old lady example I gave, where someone who voted legitimately gave their ballot to someone to drop off for them. Please add in if I'm forgetting something, but I'm not aware of nothing that came through our office.
I think
There might have been a couple more instances, things that we heard from the monitors that we may have referred. For example, I think one person reported that their voter registration was changed without their permission. Like someone reported that someone came to their house and had them sign some paperwork and took their ballot. But there were just a couple of examples of those things.
And one thing I like to always remind, many of these things are hearsay, and a referral is not proof that something occurred. It's just we received something that sounded troubling, so we refer it.
Okay. Well, I appreciate that answer. And I think it's important to emphasize any violation of our elections laws is serious and needs to be enforced, and needs to be enforced timely and with appropriate accountability to establish deterrence. But what we are dealing with in this situation is not fraud or tampering, or at least evidence of those things, as they're commonly known in how we consider election. We don't have evidence that people have been impersonating other people or submitting illegitimate votes that could not be properly cast. We have our allegations and evidence of improper handling of votes, which again is serious, is a serious matter, and laws need to be enforced, but not the same as illegitimate votes being cast or votes otherwise being tampered with. And also there have been indications about improper handling, perhaps of absentee ballot applications as well. But again, we're not talking about fraud in the sense of someone impersonating someone else. We're not talking about someone submitting votes that are illegitimate. If those things come to light, they need to be investigated fully and forcefully with full accountability. But that's not what we're dealing with here today. And I want to we need to be clear, I think, in our terms and precise in our terms so as not to mislead the public. We talked a bit earlier about let's see. Sorry. So there was some talk earlier about the mailing of absentee ballot applications or absentee ballots. Again, I want to be very precise for the public's purposes. Has the state of Connecticut or any other entity ever done a mass mailing of absentee ballots that were
No.
not requested?
No,
Okay. Other than during the pandemic, has the state ever done a mass mailing of absentee ballot applications?
not that I'm aware of.
Okay. Certainly not since you've been in office, right?
No,
Okay.
certainly not since 2015, I'll say.
Okay. And there's also often confusion between absentee ballot applications and absentee ballots. Now, absentee ballots, as you indicated, are very secure. They have a number of security measures. You can only get them under certain circumstances. An absentee ballot application, that's just like a paper form, correct?
Correct,
And you can get that online.
correct.
And in order to get an absentee ballot, you have to submit a filled out application under penalty of perjury. It has to match all the data registered to the voter. And only then can someone get an actual ballot, correct?
Correct. And it also has to be an eligible voter.
Thank you. Something else I wanted to talk about is you mentioned in terms of video surveillance, this bill would mandate video surveillance and also the keeping of the records and making them publicly accessible. Could you just describe briefly how that could help deter wrongdoing with regard to absentee ballot drop boxes?
Yeah, I think obviously knowing it's under surveillance hopefully will deter bad actors, but I think this committee knows we just made a referral on Friday. Allegedly someone looked like they made multiple trips to a Dropbox. So I think there are gaps, and it certainly will not hurt to have it under surveillance. Making it available to the public, I think, provides a great opportunity to restore any lost trust based on what happened last fall. Any individual would be able to go watch that footage to um, assure themselves that nothing untoward has happened. Um, Keeping that footage, I think, is an important security measure. Again, so that it matches Seek's investigation time window, so that if there was any important evidence, it's not being lost.
Thank you. I appreciate that. And I agree with you completely that it's vital not only to have this oversight and transparency, but also have the public confidence. And so I
Yeah.
think that this measure will be helpful with that. Representative Hoxa raised an interesting issue, which is, I guess, people move, sometimes voter data gets stale. Obviously, there are a number of measures to correct for that you've outlined, but it's never going to be perfect in real time. But I wanted to talk a bit about what would need to happen in order for someone to successfully fraudulently obtain absentee ballots on behalf of the individuals that the good representative was talking about. Isn't it true that if someone were going to represent, or excuse, someone going to request absentee ballots on behalf of those people, obviously they'd have to be they'd have to submit applications for all of them under penalty of perjury. So first of all, they'd have to fool the registrar into thinking, 5 applications with all the same handwriting are not.
Town clerk.
Town
but
clerk, I'm
yes.
sorry. Good correction. But also, how would they know that those people didn't try to get absentee ballots for themselves or vote in person? Would they have any way of knowing that?
If someone voted in person, that would be noted, right? If, for example, someone had submitted a fraudulent absentee ballot, Seek has seen, I think, 1 or 2 cases of this over the decades. The real person showed up to vote. And it showed up that they had cast an absentee ballot. So that triggered an investigation where it was rooted out what happened, etc. Towns talk across Connecticut. So if a town suspects that they received something like all the handwriting is the same, our election officials are amazingly dedicated and detail oriented. They're very detail oriented. So when they see similar handwriting, things like that raise a red flag. And I know I've spoken to clerks over this last year or more where they tell me stories about just those instances. Like, we suspected this didn't look right, so I picked up the phone and made a call, or this handwriting looked the same. They're not investigators, but they are incredibly detail oriented and they take their job so seriously. So it would be difficult.
Yeah, so I agree with you completely. I think our elections workers do a terrific job. They're very detail oriented, and when they see something, they say something. And if you do, I think it answers some of the current concern raised by Representative Hoxa in completely good faith. In order to try to pull off fraudulently obtaining absentee ballots or trying to vote in person for somebody else, you have to know that they're not going to vote themselves. And given voter turnout rates, once you do that once or twice, the percentage likelihood that the real person is going to show up and therefore that you're going to get caught ascends to very close to 99% very quickly. And we've seen that, as you indicated. There's been times in the past where someone has attempted to do that, they got caught. It happened in Stanford. So I think people should take some confidence in that being the case. And it also creates a powerful deterrent. You know, we have criminal penalties in these areas of the law of 5 years imprisonment, 10 years imprisonment, and you're almost certain to get caught if you try to pull off any of these things. And so I think that in itself is a strong deterrent. You know, you would have to be very, very dumb to take that kind of risk, not knowing whether the person who was registered and whose registration you're trying to imitate or otherwise impersonate was going to vote. And that brings me to another issue. I know Judge Stevens in his opinion in 2019, and I believe Judge Clark both recommended that we loosen our restrictive absentee voting laws. And the rationale for them was essentially our restrictive laws encourage people to try to engage in misconduct because I was talking before mostly, sorry, about how you can't know that someone's not going to vote themselves unless unless you have some sort of inside information or something like that. I guess one of the exceptions to that is when you know someone is not eligible to vote by absentee ballot. You know they're not going to be able to get to the polls, but you get them you help them get an absentee ballot anyway. Then you know you're getting a free vote for your campaign that the other side can't get. And so that is kind of an incentive to actually engage in misconduct around absentee ballots. If anyone can get an absentee ballot, you never know whether that person already ordered one or requested one on their own. And so I was wondering if you agreed with those judges' appraisals of the situation, and whether expanding our extremely restrictive absentee voting eligibility laws could help deter misconduct around absentee ballots.
Yeah, I definitely think so. You know, I think it is interesting that you're seeing judicial decisions almost arguing for broader access, whether it's early voting and or no excuse absentee voting. And as I mentioned at the beginning of this process, there are states who use the no excuse absentee process as a way to make more secure elections. I also think about states like Massachusetts. I don't want to butcher their law, but they send out a mailing asking voters, how do you plan to vote this year? In person, early voting, or by no excuse absentee ballot? And if you do something contrary, that's a trigger for them to question to make sure you are the valid voter. It also saves them money by planning adequately for the various forms of election.
Thank you very much. That's helpful information. I also think it's notable. My understanding, you can let me know if I'm wrong about this. My understanding is that in the past 30 or 40 years, the vast majority of issues related to violations of our election law, especially with regard to absentee ballots, have been people who were properly registered to vote, but under our restrictive absentee voting laws, not eligible to get an absentee ballot, getting an absentee ballot when they shouldn't have. Is your understanding similar?
I don't have data, but anecdotally, that sounds right.
Okay. And, you know, more generally, I appreciate your conversation with us today and with all the members of the committee. Just for the public's knowledge, your office, you and we have been communicating and working on this legislation together, correct?
Yes.
And obviously, you don't write it. Frankly, we don't write it. The wonderful nonpartisan attorneys in our legislative commissioner's office write it. But we'll be continuing to work together on this legislation, I assume.
Absolutely. I hope so.
Okay. Yes. So we fully anticipate doing so, and we welcome any input from both sides of the partisan aisle on this committee and welcome any suggestions from the distinguished ranking members.
And if
Uh,
I
yes.
may, just for a moment, because I do think it gets confusing sometimes. We met with you as the chairs, we met with the ranking members, we have many ideas. I think we had a list of, 2 pages of ideas. We took your feedback, we took their feedback, we gave LCO whatever information we thought made sense based on the loopholes and problems we were trying to solve. They draft the bill, we read it. The reason we have recommendations is because we're like, oh, we had some internal meetings after they drafted it and thought maybe this should be done a different way. We read the testimony of ROVAC and CTCA and we talk to our election workers, but it's a very open process. And I do appreciate having the opportunity to work with the chairs.
Well, we certainly appreciate the work of you and your office, and we'll continue to take advantage of your expertise. I had one more question that's kind of an esoteric issue in this bill, but I think there have been some questions about it outside this room. There's a provision dealing with use of the word independent or independent party in the bill. And I was wondering if you could just tell us what the rationale for that provision was and the concerns that animated it.
The best way I can explain it, I was being interviewed for a news program just a few weeks ago, and the anchor said, she was encouraging people to go out and vote. And she said something like, if you're independent, you can like vote in this or like change your party. And I'm like, no, you can't. And she's like, what? And I'm like, that's unaffiliated. And she's like, what's that? A lot of people mix up independent and unaffiliated. Some of it is a natural problem because in most of the country, what we call unaffiliated, it's called independent. I have also sat at many college fairs registering young voters, that type of thing, where they're just reading, I don't want to be a Democrat or a Republican, I'm independent. And that's what they write on the line without realizing that in Connecticut, independent is a specific party, much like Green Party, Democrat, Republican. And what they mean is that they do not want any party affiliation. So this is aimed at alleviating that confusion. And where it's problematic and where we often hear about it is when someone who signed up for the independent party thinking they were unaffiliated, they show up to vote in a primary and they cannot. Unaffiliated voters can enroll in a party very close to the election, but you cannot switch parties. This sounds confusing. So, for example, an unaffiliated person could still vote in the presidential preference primary. An independent person cannot switch parties to Democrat or Republican. That deadline passed on January 2nd. So it has created a lot of disenfranchisement. It's created a lot of confusion. And I think this rule change, we're not trying to eradicate the independent party. They would still exist. They would just have a different name.
Okay, thank you. And I know there's some concern from folks who are either members or leaders in the independent party about this issue. And I certainly understand your concern and intent to avoid confusion. If there were other measures raised that might eliminate that confusion in the problem you described, would you and your office be open to those as well?
Absolutely.
All right. Well, thank you very much. You've been extremely patient with us and with me. I think my co-chair has some questions for you.
I have one simple word left.
Thank you, Mr. Chair. Good afternoon, Secretary Thomas. Thank you very much for your patience, and I'll try to be brief.
No
'cause You're
problem.
getting on close to the 3-hour mark at this
Am
point.
I? Time flies.
Yes. I appreciate your testimony today and the nuance and the balance that you're trying to strike here between how do we look at the system, as you said, and figure out, as all systems, how do we improve it? And how do we balance that against not doing anything that's an overreaction that limits people's access to their right to vote, the most important right, I think, that we all have. Can you just talk a little bit? You talked about the monitor in Bridgeport and what you would have done if you'd had more resources. And unfortunately, in this building, there's not a lot of dreaming of what could be. You have to deal with the reality that's put in front of you. But I wonder if you would talk a little bit about what you might have been able to do in a little more detail if you had had more resources. That monitor has been in place, I think, for the better part of a decade at this point, and an appropriation of about $150,000. What could have been done differently and better if your office had more resources?
Thank you for the question. We definitely tried to mix it up a little bit, and we did put some changes in place that I think made the monitors have a little more teeth, if you will. If I had had more resources, we would have hired people to conduct calls to every single person who had put in an absentee ballot application. We did many spot check calls. We called hundreds of people. So I think it was significant, but you could have done it all. I definitely would have been up on radio and television,
Secretary Thomas, can I interrupt you for
Sure.
1 second? When you say could have done it all,
meaning we could have called every single person who
wow.
had put in an application, but that's thousands. So we didn't have the resources for that
Thank you.
within the time frame, because it can't be done over a long time. You have to wait until they come in. So it creates, you would need dozens of people. I definitely would have been up on television and radio, definitely in multiple languages, talking about what is against the law and what schemes maybe to be wary of. I would have also looked to send volunteers out, or some cadre of people into neighborhoods where we have data, right? We can look up where the absentee ballot applications are coming from. And, we were looking for any odd patterns, like an entire floor or an entire street or many people on the street, because there shouldn't be that many people eligible for an absentee ballot. Like statistically, it seems not possible. When we saw that, we did reach out, but to be able to have boots on the ground in the neighborhoods would have been, I think, more effective. And lastly, it's a bit of a dream, but I would have loved to have a whistleblower fund because, again, you need more eyes on the problem, and you need people. Much of this is happening in someone's own home, so it's hard to monitor. So it would be great to have a way for community members to be able to see something, say something, and know it's going to have teeth in some way.
Thank you. I appreciate that. Do other states have that whistleblower fund?
Not that I've heard of, I
No.
don't know. It's
Yeah.
just my brainchild.
Thank you. Well, and your answer segues to what my next question was going to be about, how to get more information to voters. I think this conversation this morning has highlighted, and you've highlighted it very well, that when all of the information about how to vote, what the rules are regard to actually executing that vote, when that information is only in the hands of partisan operatives, that's when trouble really can persist. And so I wondered if you could talk, as you just did, but maybe a little bit more of, and I know in the Appropriations Committee, you've asked for additional resources to get information out there to voters as in your role through your office. To try to make sure that every voter in Connecticut has that same baseline of information in terms of how to actually exercise their rights so that it's not information that can be used in nefarious ways because only certain people have all the details.
Yeah, thank you for the question. I spend a lot of my time thinking about civic education, civic engagement. It's easy in this building to forget that most people are not in this building. And what I've observed, and I think I've visited 128 towns so far. I talk to a lot of people every day of all ages. And what we forget is that for many people, they don't vote every year. I mean, most people only vote we know 80% vote in presidential elections, 53% in statewide, and 32 in municipal. And many people registered and began voting when they were young. And they don't realize that election laws change all the time. They're not looking up the GAE hearing. They've never heard of Title IX. And I would say only 3 in 10 have heard of the Secretary of the State. So they don't even know to go to our website as a resource. So what this means is there's a lot of hearsay. There's a lot of, my brother said this, my cousin said that. And that is where public education becomes of paramount importance. And when you think about the lack of most of this material in multiple languages, it becomes even more problematic, which is why I think it's really important to match the cadence of political parties in terms of advertisement on the radio, on air, OTT, digital ads, etc., because our largest voting bloc are unaffiliated voters. But in some places, Democrats or Republicans don't need to reach out to them. So they are getting even less information than many of us. So we have to have a cadence where we're educating people all the time, all year, not just like the week before an election, so that we inculcate a culture of understanding and perhaps even inspiration to participate.
Thank you. Thank you, Secretary Thomas, again for your time and your testimony. And we all look forward to working with you in the weeks to come. Thank you, Mr. Chair.
Thank you.
Thank you, Madam Chair. Are there any further questions from the committee? Seeing none. Okay. Seeing none. Thank you very much for being with us today, as well as your work on behalf of the people of the state and the voters of the state and with us. So thank you very much. And we look forward to talking more soon.
Always a pleasure. Thank you.
All right. Next up is Mark Garofalo of the Connecticut Town Clerks Association, followed by Duncan Wilbur, followed by Representative Gary Turco.
Good afternoon.
There we go. Whenever you're ready, you can begin.
Thank you very much, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and members of the Government Administration and Elections Committee. On behalf of the Connecticut Town Clerks Association, we thank you for the opportunity to present this testimony today. My name is Mark Garofalo. I'm the second executive vice president for the Connecticut Town Clerks Association, and I'm also the town clerk in the great little city of Derby. Here to speak to you regarding Senate Bill 441. The Connecticut Town Clerks Association recognizes the importance of ensuring the integrity, transparency, and accuracy of our elections. Town clerks are heavily involved in each aspect of the state's 169 towns elections. Town clerks play an important role providing the public with absentee ballot processing and early voting storage and accounting of each ballot. Town clerks assist registrars of voters and moderators before, during, and after the election to ensure a fair and free election and that the procedures are consistent, safe, and secure and provide accurate and verified election results. The Connecticut Town Clerks Association would appreciate the opportunity to be involved with the Municipal Election Accountability Board We are all invested in the successful administration of Connecticut's elections. We all play a vital role in ensuring the integrity of our elections and maintaining the public's confidence in the election process and outcome. Therefore, CTCA thanks the GAE committee for working in collaboration with town clerks to improve election administration and the voting process in Connecticut. I thank you for your time today. I know it's going to be a long day, and I'm happy to answer any questions.
Thank you, sir, for your testimony and your work on behalf of the people of Derby and also town clerks statewide. Questions from the committee? Looks like there are none here, but we certainly appreciate you being here today in addition to all your work. And we look forward to engaging you and your insights as we develop these bills further.
Thank you, Mr. Chair.
Thank you, sir. Next up, we have Duncan Wilbur, followed by Representative Gary Turco, followed by David Super. Good morning. If you could just make sure the microphone is on. If you hit the button in front of the microphone right there, there you go. And just make sure you state your name for the record in the beginning of your testimony.
My name's Duncan Wilbur. I'm here to support Senate Bill 435, Section 1. All right. Good afternoon, everyone. I'm from Colbrook, Connecticut. My story is about farming, assessing, and taxation. Colbrook is where my farm is located. I also rent additional farmland in that town and in the neighboring town of Norfolk. Crops I grow and sell are hay, grain, vegetables, and I have a small beef herd. I've owned and operated my business since 1999. In my adult life, I've dealt with at least 8 different tax assessors. As we all know, no two people are the same in their opinion. But with that being said, my tax assessment of the equipment, vehicles, property has generally only had small incremental changes, from person to person. In 2019, the town of Colebrook employed a new assessor, and my problems with the farm business started there. If you read my written transcript, it gives an idea of the constant back and forth that escalated into a Superior Court tax appeal. From the start of 2020 through late 2021, I received numerous inquiries about my business from the town assessor, questions ranging from my income, tools I had, properties I rent, where I acquired tractors, questions on what I do with my cows, if anyone gave me shovels, how I feed my cattle, what is a crop rotation, and on and on and on. I answered all the questions, provided documentation to further prove my legitimacy, and offered a site walk of my property, clear up any possible misconceptions of what I may or may not be doing. 2020 was a property reevaluation year for the town of Colebrook, so I understood that these questions were valid to a point. Another request from the assessor was to fill out a new Public Act 490 application for my farm property. My initial reaction was that I had one on file, so I believed an amended application was correct. I reached out to Joan Nichols at the Connecticut Farm Bureau to confirm my thoughts, and she agreed that amending the form was the correct way to update it. In October of 2020, I submitted that amended application for my 26-acre parcel consisting of tillable D, woodland, and swamp. My application was partially denied. The assessor added a building lot, denied my woodland, reduced the acreage for tillable D and swampland classifications. The result of the new assessment was $61,000, an increase of $39,000. I then filed a tax appeal to the Board of Assessment Appeals, which resulted in a denial. At that point, I had a gut-wrenching decision to make, accept the town assessor and the Board of Assessment Appeals, knowing darn well it was wrong, or hire an attorney and file an appeal in Superior Court that would likely cost me $5,000 to $10,000. I went on to do that. in January 2022, the town settled my tax appeal for the original amount.
Excuse me, sir. I'm sorry to interrupt. Your time has elapsed, so if you could just summarize the remainder of your testimony in a sentence or two, and I believe that you'll have at least a couple questions.
So the summarization is that I went to court, I fought it, the town settled with me. But there was no, for Public Act 490 forest, the state forester would have the final say. For farmland, there's not that. So we're kind of backed into a corner of either you take it to Superior Court or you lay down and take it. And I lay down for no one,
Well, we certainly appreciate that.
no doubt.
Madam Co-Chair, I believe,
Thank you, Mr. Chair. Good afternoon. Thank you for your testimony. If you don't mind, I think you might have just detailed this a little bit, and you don't have to answer this question if it makes you uncomfortable, but thank you for sharing your experience. You had to go to Superior Court. How much money did you have to spend?
So that was north of $8,500.
$8,500.
That's right. And the difference in the taxation for that year, to give this a little perspective, out-of-pocket cost was going to be around 2,500, right? So what's kind of told to you is reapply the following year. But let's hypothetically say you have a denial. Over the course of 10 years, that's a $25,000 hit.
Mhm.
Follow what I'm saying? There just needs to be a stopgap in there. Someone that, let me put it to you like this. When you look in this room, I think you'll find that most people are so far removed from agriculture that assessors included, you need another layer that's kind of more in tune with it. And that's kind of what this first part of this bill is presenting.
Great. Thank you. Thank you very much for your time and your testimony. Thank you, Mr. Chair.
thank you, Madam Chair, and thank you very much for your testimony. We appreciate the work you do, getting food to tables of people across the state and the country. And I agree. I think people are often far too removed from where their food comes from farming generally, from the fact that there's a lot of farming here in the state of Connecticut. So we appreciate you being a part of that industry and you bringing this bill to us.
Right
Your
on.
testimony to us. Thank you. Next up is Representative Gary Turco.
Good afternoon, State Representative Gary Turco, 27th District, Newington and New Britain. Hello, co-chairs Blumenthal and Flexer, and ranking member Mastro Francesco. Did I get that right? Okay, good. I'm Italian as well, but sometimes, our names could be a little tricky. But I'm testifying today in strong support of House Bill 5494. And I've submitted written testimony. You're going to hear from some members of the New Britain League of Women Voters who have been working tirelessly on this bill all throughout the summer and the fall since last session, when there was a version of this bill that passed out of this committee. They've improved on it. So they'll get to a lot of the technical aspects of the legislation. But I'll tell you why I think this is important for us to really think about. I thank the committee for raising it for the public hearing and hopefully pass a version of it this year, is because right now with municipal charter revisions to our Connecticut voters, there's not a lot of transparency. In both Newington and New Britain in 2022, when they had municipal charter changes, all it said was on the ballot is, do you approve the charter changes that were approved by the town or city council on such and such date? In Newington, for example, there were 16 distinct items included in that one ballot question. So for voters that weren't able to do their education before they go, and let's face it, not all of our voters, unfortunately, do the research before they vote. Once they're in their ballot box, they don't have a choice where they see a candidate's name and a party. They see a very generic question. And it's all or nothing. In Newington, there were voters that liked some aspects of those charter changes who had done all their research. There were others that didn't. So this legislation is trying to create a process to put clear language, just like with early voting, or just like this year with the no excuse absentee ballot voting. Voters will know exactly the language. There's ability to group certain things together. Let's say you have a whole bunch of changes that are just technical. There's a way to group those. And if there's a problem where the language gets presented to the voters, and they believe this language for this specific charter change isn't going to be clear, concise language, there's a petition process where then the Secretary of State's office will review and decide if this needs to be changed, it's approved, or it will be rejected. And I know Secretary of State Thomas, I just saw her outside. She's got to be really tired after the testifying here, which I'm sure you all are too. I believe submitted testimony with some concerns over, an added duty of the office. And that's something we can kind of work out with her if, there needs to be another, a staffer or some funding to assist with this. But we think, and the New Britain Register of Voters will testify that this will be really rare when there is a problem, because the way the language is written, it really creates a really well thought out process on how these questions should be stated. So thank you for the opportunity to testify. I welcome any questions.
Thank you, Representative. Questions from the committee? Representative Massafrancesco.
Thank you, Mr. Chairman. Very nice to see you, Representative.
Thank you.
So it's interesting. I certainly understand the frustration. We have it in our town too. They have a referendum question. There's one, nobody really knows the details of it. And it's frustrating. It's not really fair to the voters. We almost had, in my mind, I mean, how much detail do you need to give, right? Like here in Connecticut, we had the constitutional amendment for early voting. Shall the legislature, decide about early voting, but nobody really knows the details behind it. It really is a broad question, right? Because they don't know what's going on behind this, what's going to happen. The same thing with no excuse absentee voting. So here we are, we want to change it for municipalities for their ordinances, but yet we kind of do the same thing here. So, but I do think it begins somewhere because it is very frustrating. Did this stem from an incident that happened in the district? Is that how all this came about? I vaguely remember something happening. Can you just recap that for me?
Sure. No, thank you so much for your question. Yes, in New Britain and in Newington, I represent both municipalities. In both, there were charter changes that were passed by the local governing body, and they comprised numerous questions. I forget the exact amount for New Britain, but in Newington, it was 16 different charter changes, distinct changes. And then on the ballot, it just had the one question: will you approve or disapprove the charter changes? So there hadn't been in a number of years these type of charter changes where there were so many grouped in one. And it really raised a lot of concerns from constituents. They didn't think it's a transparent process. They didn't want to have to vote on all or nothing rather than having a choice, because some of them, technical, no problems. Some of them have real impact on how a municipality is governed, but they didn't have that choice. So that's why the league decided to take it up and is working really hard on it.
Thank you. Through you, Mr. Chairman. So the language in the bill as it written, would that also apply to a referendum question, maybe on a project that the town is doing, or maybe some bonding that they're going to spend that money for? Or is it just specific to an ordinance or into your, that kind of goes with your situation?
Sure. I believe from the League of Women Voters who are advocating in the language that they designed and they presented to the committee to include in this legislation, their intent was really, more of the policy changes and not budget approvals. I don't know though, when it was drafted now with LCO, if there has been any modifications to that. And I think when the League of Women Voters testifies later today, they'll be able to answer that more specifically.
Okay, good. Thank you. Thank you for coming in. I appreciate your testimony. Thank you.
Thank you.
Thank you, Representative. Further questions from the committee? Right. Well, thank you, Representative. We appreciate you bringing this bill to us. I can say personally, having seen a number of questions on charters, including in Stanford this past year, that often these questions don't really give the information the voter needs to make a decision. Sometimes they don't describe the exact changes being made. Sometimes they group a whole bunch of disparate questions together. Sometimes the question is quite argumentative in a way that either encourages or discourages voters from voting for it. And so I think adding clarity and transparency to this process will hopefully lead to better informed decisions by voters on their local governments. And also, obviously we want to make sure that whatever the process is workable for everyone involved. So we Look forward to continuing to communicate with you, the secretary, and anyone else who's a stakeholder on this one. So thank you.
Thank you so much.
Next up is David Super, followed by Representative Vincent Candelora, followed by Kim Jones. Is David Super with us? I believe he's on the Zoom. There he is.
Yes.
Whenever you're ready, you may begin, sir.
Yes, thank you very much, Representative Blumenthal, Senator Flexer, Representative Mastro Francesco, Senator Sampson, and other members. I very much appreciate your allowing me to testify today. I'm David Super, professor at law at Georgetown University, and I'm here to commend you for considering House Joint Resolution 230, which would rescind 2 half-century-old applications for a convention, federal convention under Article 5 to amend the Constitution. Passing this resolution is important to protect our nation's democracy. It's also important to protect this body's authority to speak for Connecticut in national affairs. An Article 5 convention at this time, with the country so sharply divided, would be a feeding frenzy for special interest groups. It's been criticized by the likes of former Chief Justice Berger, former Justice Goldberg, former Justice Scalia, as doing potentially great damage to our country. It's very difficult to imagine in our current state how this would be anything other than an attempt, a power play by one side or another, heavily influenced by special interests. We got some indication of what this would look like last summer when one of the groups advocating for such a convention held a mock convention in Williamsburg. This mock convention, designed to show that conventions would be safe, disregarded the limits on its scope, and made proposals that would render most major environmental laws and many civil rights laws unconstitutional. Connecticut has not supported any of the current efforts to call an Article 5 convention, but the proponents are in a desperate situation. They claim they have 28 states. You can see a path where they could get to 31, but the constitutional minimum is 34, and they have no honest path to get there. So they've been misrepresenting old state applications like yours. New York in 1789 said they wanted a convention to propose a Bill of Rights. Obviously, that's been taken care of. Kentucky in 1861 said they wanted a convention to prevent the Civil War. Obviously, that's been done. Washington State in 1903 wanted a convention for popular direct election of U.S. senators. That's been taken care of. And yet all 3 of these states are being misrepresented as supporting the current efforts to have an Article 5 convention. Connecticut could very easily be next to have its old applications misrepresented by people who are seeking to have a convention that could do real damage to our democracy. So I think it is most commendable that the committee is considering HJR, House Joint Resolution 230, and I would encourage you to move it forward. Thank you very much for your time.
Thank you very much, Professor. Other questions from the committee? Seeing none, we appreciate you being with us and sharing your insight and your testimony.
Thank you very much.
Next up is the House Minority Leader, Representative Candelora, if he's with us. I don't see him. Kim Jones, followed by John Mertens, followed by Ann Spire.
Is it on? Yeah. Good morning, committee, and thank you for letting me speak. My name is Kim Jones. I am the co-founder of ICONS, the Independent Council on Women's Sports, and one of the U.S. representatives on the International Consortium of Female Sport. I'm here today to speak on opposition to SJ4. ICONS is a network of thousands of Olympians and professional athletes, collegiate and high school athletes, and sports policy experts, all committed to ensuring women and girls have fair and safe competition at every level and in every sport. Sex is real. It is defined by gametes, and that is true in all mammals. The entire body is organized around the production of either sperm or ova. There is no system of the body that is not impacted by this from utero. There is no reboot, there is no undo, and no human can change sex. The effects of sex are permanent. The result of sex is that men and women are built differently in almost every way. We measure it in labs, in science, in performance, and its impacts are enormous for women across all cultures. A great example of this is the fact that a man's punch is 160% stronger than that of a woman. These sex differences mean that men hold the physical and sexual power over women in society. This has all become very clear to the public in recent years in sports, and I had a front row seat when my daughter raced against Leah Thomas. My daughter and her peers were marched into locker rooms where a man would be undressing and watching them undress. I saw the ramifications firsthand. I saw the tears, the struggle, and I watched as strong, confident young women became frightened and stopped believing that they could depend upon their leaders to protect them. The women were silenced. They were told to ignore their instinctive fear and discomfort. They were emotionally blackmailed and told that the feelings and well-being of a man were more important than their own, that his life depended upon their concession. This emotional blackmail is no different than the age-old threat that women have always faced when trying to leave abuse. If you leave, I will kill myself. If you don't do this for me, I will hurt you or hurt myself. Telling women that they are responsible for carrying the mental health burdens of another is wrong in every sense of the word. I have seen what happens when we put our women and girls through this, and I now help women and girls facing this all across the country, indeed the world. The stories, the numbers, and the impacts are heartbreaking, and they are staggering. When we tell our girls that they are more valuable as tools of affirmation or shields of protection for men, when we tell women that their accomplishments and their desire to win need to be set aside to make
Excuse me.
someone else feel better. we
Ma'am, I'm sorry to
damage them.
interrupt, but your time has elapsed. If you could summarize the remainder of your testimony in a sentence or two, please.
Sure. This issue is not complicated. It's very simple, but it is contentious because gender identity is in conflict with sex. When it comes to women's sex and man's gender identity, you cannot protect both. You have to choose. You can choose to respect the identity of a man in a woman's prison, or you can protect the woman's right not to be housed with male inmates. You can give women the right to consent to male nudity, or you can give men the right to expose themselves in women's spaces. You simply cannot do both. It has enormous impacts. I urge the committee to abandon this push to redefine sex in the law and instead draft legislation to protect the rights of women and girls in Connecticut.
As we indicated before, there are no demonstrations in this hearing room. We appreciate compliance with our rules. Thank you very much for your testimony. Are there questions from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Thank you so much for coming in. I appreciate it. Your testimony is very inspiring to me. This is one of these subjects that are very dear to my heart, and the protection of women. You know, we have come so long, decades, to get to where we are today. And I always worry that they're going to be hurt and opportunities are going to be taken from them. So I'm very passionate about this issue. I'm just curious, in the organization that you're in, how widespread is this problem? You know, because sometimes we just focus on, you know, one or two events. We hear about Leah Thomas, maybe we hear about somebody else. I don't know. I don't know if people realize how widespread this is. Would you know based on your organization?
Yes. There's not a sport that's not impacted. There's not an age group or a competition level that's not impacted. It is incredibly widespread. And I mean, I can tell you stories of women and girls suffering concussions around the country that these stories do not make it into the media. My organization hears from women, families, including whole teams of women calling us in tears and begging for help. I hear it on a weekly basis. I have meetings almost every month with women around the world fighting this. It is in middle schools, it is in high schools, it is in college, it is at every level of college, it is in masters, it is in the Olympic level, it is in the professional level. And I mean, there's not a state that's not impacted by it. There's not a woman in sports that's not impacted by it. And one male athlete impacts hundreds of women. It is not a one-for-one exchange.
Thank you. I agree because I've been doing a lot of research and I look often at that. And obviously this language put into this resolution is very, very concerning because that would really open the door for that. And I know that people are very hesitant about speaking out.
Yes.
It's unfortunate. Have the girls and the sports on the teams and so forth, have they been silenced? Have they tried to speak out?
Oh, yes.
Can you explain that to me based on your experience?
Oh, sure. The girls were marched into mandatory meetings in the Ivy League across the entire Ivy League and told not to speak, that there would be ramifications for them. And there were girls punished on some of the teams. But the girls that spoke out in support of men in women's sports were not punished. The threats and insinuations were clear. It was a frightening situation. It is women in USA fencing. We have 5 male athletes that have represented the US and winning national championships and competing under the United States banner in the women's category. The women in fencing have been reprimanded, threatened with expulsion from their sport. They're not allowed to speak on it at all. Coaches in cycling have been told they'll lose their position in the Olympic movement if they speak up on it. I mean, the silencing is outrageous.
Thank you. And through you, Mr. Chair, have they come forward at all? I mean,
Well,
I
so-
know it's hard if they're being silenced. They don't want to jeopardize losing any opportunities. But have they been able to come forward at all?
So I don't know if you're aware, but 16 female athletes have just filed a lawsuit, the state of Georgia in federal court against the NCAA. Women are, and we have many more women that want to join that lawsuit, but at the present moment are frightened. So women are speaking up. They're speaking up around the world. I work with international governing bodies of sport. We've changed, the policies have changed over the last year and a half in World Aquatics, World Athletics, the International Governing Body of Cycling, World Boxing, and World Rugby, all to protect the female category and recognize sex. There are several other international governing bodies that will be releasing new policies in the coming months that we've been working with. Women are speaking up and people are paying attention. It's pretty hard to ignore what's happening when you have women suffering career-ending injuries in some cases.
Yeah, thank you for that. I appreciate your advocacy and I'm not going to speak for your group there, but I would assume nobody has a problem with the way people identify, what they want to do in their personal life is
No.
fine. But when it impacts, when it gives an advantage over one person to another, it's very concerning. And certainly, as you mentioned, biologically, they're much stronger. We don't want to see any women get hurt by any means, or certainly lose out on opportunities. They work their whole life. They try to get scholarships, they train, and it could be taken away from them.
Yep, it's even just a place on a team. Just that last girl who makes the junior varsity team in high school deserves the access to her opportunity and not to be set aside for the benefit of a male's feelings or emotional well-being. She matters as much. And in many cases, a lot of the women that I work with that are suffering in these competitions, have overcome alcoholism, abuse, rape, all kinds of things. And their struggles in life are just as valid as anyone else's.
Yeah, I agree. I just shake my head on this issue. I got to be honest with you, because we have come such a long way for women and to protect women and for women to have his rights. And, I'm not that type of person that I'm out there, advocating for women's rights and so forth. I think everybody should be equal. But we've worked really, really hard. And I just feel like we're just being pushed aside and almost being erased and taking those opportunities. And I always wonder, where are the civil rights activists on this issue? I mean,
Well,
we need to protect our girls to make sure that they're safe, that they are having equal opportunity. And when somebody comes in that is much stronger, because we know that their biology doesn't change, they're still going to be strong. Those opportunities are going to be less when we're trying to give women more opportunities. So it's very, very concerning.
Yes, I'd like to, I mean, I think one of the things that sports is there are a lot of women who deserve to be treated fair. I mean, all women deserve to be treated fairly and with respect on the basis of their sex. But when it comes to sports, that is the public arena of the difference of the sexes. So when we celebrate and clap for women being abused or set aside for the benefits of a male, what we are doing is stripping women who are in the dark corners of society and behind hidden doors of any belief that they deserve to be treated fairly. How we hold up our champions and our successful women in life is, it's a remark on how we treat women in our culture.
Thank you. And, I certainly agree. It's a marginalization of women. And I certainly, your story is inspiring. Thank you for all that you do. And I think just educating people and letting them know what's going on. And, I always felt that perhaps maybe there should be a different sporting, maybe it's co-ed, or maybe there's a different class for people that identify a different way that they could all work together. At least they know what they're getting into, and women are not forced to compete at a disadvantage. I always think that is the way that it should be handled. But I appreciate your testimony today. Thank you very much for coming in. Thank you, Mr. Chairman.
Thank you, Representative. Are there further questions from the committee? Representative Hoxa.
Thank you, Mr. Chair. And through you, just a couple quick questions for you, Kim. Yes, sorry about that.
Okay.
Do you have a general understanding, or not even necessarily a general understanding, but are you aware of how widespread this is in the state of Connecticut, at least, issues similar to the ones that you faced with your daughter?
Yes, there are several male athletes competing in women's high school sports in Connecticut. There are several male athletes that have competed throughout different levels of sport in Connecticut. There are women in the professional ranks of sport in Connecticut that are competing against men in professional sports. It's incredibly widespread. Sorry, go ahead.
No, go ahead, finish.
Yeah, I mean, we had a male athlete. We've had obviously the girls in the state of Connecticut that lost in those track races
yeah.
a few years back. We've got another male athlete that just won the state high school championships in high jump just this last year. He's ranked 3rd in the country right now in women's high jump. My daughter obviously facing those issues when she's attending college. And then there are masters and other competition levels where I can't specify a name right now.
Right.
I don't think I should, but.
Yeah, no, and thank you for providing that information. In high school, I was a wrestler, and wrestling is one of those few sports that's co-ed. Both boys and girls can compete, and even against each other. But you brought up a very interesting concept and point earlier, which was that you can't have both. You can't have both boys choosing to wrestle girls and girls choosing to wrestle. Well, in the sense that you can't have the two things must be mutually consentable, right?
Really consentable. What I meant by that was saying you can either, if you're in a bathroom or a locker room, you either support the women who have the right to undress and use that space as a sex separated space, and who don't consent to having men around them, or you choose the man who gets to enter the women's space. You
can't have both.
do both.
You can't respect both.
They are in
rights in that
direct
situation.
conflict. Right.
And through you, Mr. Chair, if I could continue, well said. And in the case of wrestling, of high school wrestling, girls are choosing to enter a sport, a competition, which is predominantly male competitors.
Correct.
And so it's their choice to enter that field. It's not being imposed on them. It's not like there's a boys wrestling and a girls wrestling, and then the biological male is imposing himself on the girls team by choosing to wrestle in the girls category, right?
Correct.
So I guess the point that I'm trying to make here is that, you know, that I really just want to emphasize that point that you made, which was that you can't have it both ways. And on top of that, you're also caught in this difficult position where you're trying to make these points, but it seems like you're being shut out and silenced on an institutional level. Can you describe that a little bit more? Can you give us some examples of when you've been, either successfully or unsuccessfully silenced, attempted to be silenced or silenced at an institutional level, whether that was a board of education or or an athletic conference, or just something to that level?
Sure.
Through you, Mr. Chair.
So to address two things, I think. One is, yes, the way categories are created and the purpose of categories in sport are to be maximally inclusive. So we categorize sport across age, for that's youth and masters, as well as like in the main open areas. We categorize it for para, right? And weight classes. In some instances, boxing and wrestling would be one, rowing would be another. And then across all of those, we separate by sex. And that's how we include everyone. All of those distinctions are based on biological, objective reality, measurable standards. Competing up is always allowed. Competing down is not. So a woman competing against men in the men's division is at a disadvantage, and that's fine. It's like a youth making an Olympics team. We don't allow adults to compete against children. We don't allow doped athletes to compete against clean athletes. We don't allow men to compete against women because of the known advantages and disparities render the competition meaningless. They turn it into a joke. So that's the competition thing. As far as silencing, the perfect example is the NCAA. 45 Olympians and NCAA female athletes of the year, Olympic coaches, most decorated individuals out of various institutions, both at the University of Arizona and the University of Texas, wrote strong letters asking the NCAA to please respond and explain why they were doing this, that it was wrong to change the policies. No response. Nothing. Not one response. And in the Ivy League, the institutional response was, yeah, this is just the way it is. You don't argue with it. And the girls were told there will be ramifications. So inherent in that is an underlying threat. Harvard put this in writing. I have the letter. Penn put it in email form. Almost all the other schools just pulled the girls into mandatory meetings to say, you will not talk about this. Don't speak to the media. Don't respond. It doesn't matter what you're thinking right now. You need to let the men in charge decide your fate, even if you feel like you're being discriminated against. So the silencing of women was enormous. On an international federation level, USA Fencing, USA Boxing are both going through this right now. They are not listening to their constituency. They're unwilling to talk to women.
I'm sorry to interrupt. There's going to be more questioning, I'm sure, but I just want to caution us to stick to the language and the bill at hand here, or the resolution at hand. We're getting pretty far afield. This is not a resolution or a bill on women's sports generally. If there's an application of that issue to this specific resolution, we can explore that, but we're not handling that broader issue, and nor could we in our cognizance. So thank you. Representative Hoxley can continue.
Thank you, Mr. Chair. And Kim, thank you very much for bringing all that to light. I'm sure a lot of us in this room have been following to varying degrees this broader topic, as the chair pointed out. And one last question, and I'll wrap it up here. If you could just talk a little bit more about, because you brought this up, the safety aspect of all this. There's I did a little bit of boxing as well, actually, and you brought that up. And I came across this video where the world champion of women's boxing sparred a male who was ranked like 300 in the world, and the male knocked him out in one punch, knocked her out in one punch. And she went on Twitter and Facebook and was complaining about how, whatever. But that was consensual. Again, going back to this consensual sort of arrangement of, hey, you know, we're two adults here that are consenting to engage in this, the competition with each other. Have you heard of anything in relation to any physical harm being done to anyone as a result of the direction that this, policies that stem from amendments like this?
Yes.
Either here in Connecticut or anywhere else that we could use as an example to
Yes,
learn.
there are several young women in high school that have had career-ending concussions due to volleyball, male athletes in volleyball. I know of women who've had their ACLs torn in jujitsu, women who've had their wrists broken in other in fencing. I've had women who've had their teeth knocked out in field hockey. I've had women who've had their skulls fractured in combat sports. So, I mean, that I could go on all day. I'm not sure. So yes, there's an inherent physical risk to women, but even when physical risk isn't part of the deal, psychological risk is. Being told that as a woman that you need to step aside when a man wants your space, or when a man wants your language, or when a man wants access to a place where you are vulnerable is incredibly hard for women to bear. They are rendered mute if they're not able to say what's happening to me is wrong. The position I'm being placed in is wrong. It is what I went back to. You can't, when you tell women that their hard work and their efforts better serve the affirmation and desires and safety of a male who wants their place, you render women meaningless. They're just there to serve men. So we either value our women and we celebrate that there are differences between men and women, and we celebrate women as worthy and as respectful and as possible champions, or we don't. It's a yes or no question. We do or we don't.
Thank you, ma'am. I appreciate your testimony. That's all I have, Mr. Chair. Thank you.
Thank you, Representative. Further questions from the committee, Representative Bronco.
Thank you, Mr. Chair, and thank you, Kim, for your testimony today. You pretty much answered my last question there. I was just interested in your testimony. We usually think of this this issue from a fairness, equity standpoint, but bringing up the safety, I hadn't really thought of it in that way. So you did answer my question. So I won't take any more time. But thank you for being so articulate and well researched on this subject, and for coming here to share that with us today.
Sure. Thank you. Always welcome to talk.
Thank you, Representative. Representative Master-Francesco for a second time.
Thank you, Mr. Chairman. So the bill that is before us today, and I just want to just kind of clarify something. The bill before us today is changing the equal protection of the law. And just like the bill that we just talked about before, that talked about the referendum, the questions being very broad, nobody really knowing what's going on the back end. This actual language in here, it says, used in this section, discrimination in the exercise of enjoyment of civil or political rights because of sex includes, but is not limited to, discrimination in intent or effect based on pregnancy, including preventing, initiating, continuing, or terminating a pregnancy, sexual orientation, gender identity and expression, and related health care. So to the chairman's point, this absolutely, your topic absolutely has something to do with the question, with the bill that is before us.
100%.
Like many other things, it could be abortion, it could be its gender identity. All of these things come into play. So I appreciate my chairman's comments on that. I respectfully disagree. All these issues that we are going to talk today about are absolutely relevant to the language that is in the bill before us. So I just wanted to make that comment. I thank you again for coming in for your testimony. And I look forward to listening to the rest of the people today. Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Further questions from the committee? I had a couple quick questions. I appreciate your testimony. So you're here today to testify about women's sports. and protecting
I'm
women's
here to
sports?
testify today about redefining sex in law and the implications it has in society at large, including in women's sports.
Okay, so beyond women's sports, you're testifying?
Yeah, of course, every aspect, so every aspect of life where sex is redefined to not recognize women as members of the female sex with sex-based needs and a life-born female with all that that encompasses is separating women from protection under the law.
Okay.
And so we cannot, women, 51% of the population cannot afford to be redefined in law as an identity.
So
Equating that cannot work for us. We are not.
could you explain to me how you think that this language would allow women or prevent women from being protected against discrimination on the basis of sex?
As soon as you equate sex to gender identity, women are no longer protected on the basis of sex.
Why not?
Because women are not an identity. We are a biological reality. We are born female. There is no sense of self. There's no way we present ourselves or way we dress. There's nothing, has nothing to do with how we feel about ourselves or what we believe in. Our entire system, our entire body has evolved around the production of ova. Every single system of our body is that. It is why we are built the way we are. It's why we have the struggles we do. It's why sex-separated spaces and services are necessary for women.
Okay, and
And
So-
a male who infringes on those removes that as being recognized as sex-based needs and sex-based rights.
I'm a bit confused because I don't understand how this language would prevent women from being protected on the basis of their sex.
As soon as you say you can't discriminate or as soon as you say you have to be able to recognize someone's gender identity at the same value of sex, what you are saying is that you've got a conflict. You're going to recognize that a male is allowed, his beliefs, his sense of self is allowed to supersede or be equated to the value of the rights of a woman based on her sex. You can't, the two are inherently in conflict. So as soon as you say that I have to recognize a man as a woman in sport, in a prison, in a rape crisis center, in healthcare, in language, a woman no longer has representation and recognition as a member of the female sex.
Okay, we may have a different understanding of the law.
Would you like to explain to me what your understanding is?
Well, the sex has a number of meanings in the law. Sometimes it's biological, sometimes it's other.
What's other, what other
mechanisms.
meaning?
It depends on the law. We have definitions in every law about what words mean. So I guess I'm confused about how this measure protects people against discrimination on the basis of sex. I'm confused about how it would thereby prevent people from being prevented from being discriminated. I mean, we may have just differing understandings of how the law works in this area. I'm assuming you're not aware of the decision of, or I don't know if you are. I'm sorry, I don't mean to assume in any way, but Bostock versus Clayton
Oh,
County.
I'm well aware of Bostock, yes.
Okay, so
And that is specific to areas of employment. And it was very clear that that was specific to areas of employment. It was a narrow decision.
sure, but it had a understanding of sex that was not
No, it didn't
purely
have a different
biological, correct?
understanding. No, not sex. It was only gender identity. Sex is defined in law. Title IX was based on sex. Sex is, as we know in science, sex is based on the production of gametes. That is, it's what it is in all mammalian species. It is what it is in all species. It's mammalian species that do not ever change sex. So the definition of sex is not actually in law in any dispute. The Biden administration is trying to make it so. And this law, this rewrite would also call that into question. Women are protected on the basis of sex. As soon as you equate that to an identity, then you are no longer protecting women.
So me see if I understand this correctly. Are you saying that you cannot protect transgender individuals against discrimination while simultaneously protecting women against discrimination?
Correct.
Okay, all right, well, at least that resolves that.
In the spaces where sex is relevant.
Okay,
I disagree that so I would say anyone, I think you have to protect people's right to believe whatever they want to, but you can't protect those beliefs in law and have them supersede reality. So in other words, if someone is religious, they are entitled to believe whatever they would like to believe, but I can't mandate that everyone else support that belief or uphold that belief in law. They can be free to believe what they want to and practice what they want to. You can't mandate that everyone else adhere to their beliefs. You can't protect someone's self-expression or self-belief in law and also support objective reality.
okay. I'm not sure that I understand exactly the distinction you're making, but I appreciate your testimony. I have one more question, which was, in the sports area in particular, if people were, whether in a athletic circumstance or some other circumstance, the state were making a distinction on the basis of physical strength, speed, other physical characteristics, wouldn't they be able to make that sort of distinction without reference to sex?
No, because while it's entirely true that the best men in the world or the best in any division will beat the best women. I mean, boys beat women's world records at age 14 and 15. Thousands of boys every year run faster than the fastest women in the world. So all you're doing is you're taking two normalized distribution curves for men and women, and you're saying, I'm going to take some of the weakest men out of here and I'm going to put them against the women who are the best. You're not recognizing the unique attributes that women have and that women's skills have. You're not you would be saying, in essence, that it's women's fault that they're not strong enough, that they're not mental, that they're just not trying hard enough. We recognize that male and female are two distinct categories because that gives women a chance to succeed, to be champions, to have full teams. As soon as the men's teams are full of men, there's no women in the men's NBA or the men's NFL because women aren't trying hard enough. It's because we're female. And if I can guarantee you that if when women injected testosterone, we all of a sudden became some sort of superhuman man, that the men would be crying, this is illegal, this is drug use, get them out of here. When men have a massive advantage of 10 to 160%, depending upon the activity, when margins of victory are determined by less than 1%, less than 0.1% in many cases, you cannot grant someone that advantage and try to normalize for sex things that are part of sex: strength, speed, height, agility, reaction time, injury rate, longevity of a career, bone density, qualitative and quantitative differences in muscles. If you normalize for those things, all you're doing is normalizing for sex. You're just taking sex out of the equation. You're just telling women that they are versions of weaker men instead of telling women that they are rightfully amazing in their own development.
Okay, well, I appreciate your testimony. One last question. I take it that you would continue to object to the proposed amendment, even if it accepted the athletic arena?
100% for locker rooms, rape crisis centers, prisons, anywhere that women are vulnerable and susceptible to men and need sex differentiated recognition.
And if it accepted sensitive areas or places in the law where people needed to take privacy or other things like that, that would,
Do I, what, are
Remove
you
the
asking
objection.
if I have an objection to gender non-conforming individuals? Absolutely not. They're my best friends in life and who I grew up with competing in professional sport.
I'm asking about the amendment, which is what we have before us.
Yes, so I'm trying to clarify, do I have any objection to people being, dressing, acting, behaving in any way they like? I do not, so long as it doesn't infringe upon the rights of others.
Okay. Would you have an objection to an amendment as indicated before us preventing discrimination against transgender or non-conforming individuals?
Just give me an
Putting
example
those
of what,
aside.
where that would be. So no, I don't think anyone should face discrimination.
Okay, that's
So is
all I'm
that- is
asking.
that
I mean, I
okay?
think
Yeah.
we've
But I
probably
think we
exhausted the
have to-
subject.
That's
but-
fine. I think we have to be willing to recognize sex and it's where it's relevant to women. But we also like within recognizing sex, there has to be an ability to recognize individuality. Meaning you can dress, act, behave, like you can be as masculine or as feminine as you need to be, but that doesn't give you the right to obfuscate your sex when it puts women at risk.
I'm still a bit confused about how it applies to the amendment, but I appreciate your testimony.
Just equating
And-
sex and gender identity doesn't work out for women. That's it.
I appreciate your testimony. The further questions from the committee? Senator Sampson.
Thank you, Mr. Chairman, and thank you so much for being here. I
Sure.
apologize that I missed the first part of your testimony, but I heard
Okay.
it was good. People even outside the room were suggesting there was a good debate going on in here, and
Okay.
I'm sad that I missed it. Unfortunately, we have a lot of other responsibilities sometimes and other meetings to be in and so forth. And I certainly appreciated what you just said. The big thing for me, aside from all of the other amazing points that you made, and I think you did a very good job of making the case, certainly in women's sports. But for me, it comes back to compelled speech in some respects. And also the notion that I think that a lot of women that advocate for transgender women in women's sports is this argument that transgender women is women.
Mhm.
And I'm worried that you put this into law, what might happen is if someone objects to that or disagrees with it, they might run afoul of this law. Or in order to participate in some sort of organized sport, you might have to acknowledge that transgender women is women. And I think that runs afoul of the First Amendment based on compelled speech. I'm just curious, since that's not a topic I think you guys covered, but I
Mhm.
think it's something you might have an
Very
opinion on.
relevant.
Yes, I figure you have an opinion.
Yes, I have. a
Please let us
question.
know.
The language that obfuscates the reality of sex and the lives of women around the world and in every little part of the world, in small groups, schools, wherever. Any language that obfuscates sex removes women's abilities to advocate for themselves and express their needs apart from men. So as soon as you confound the language of women and remove it from the ability to describe women's lives, what they're dealing with, how they are different from the things that face men, you remove women's ability to have a voice in life. So there are examples where women have been in a court of law expected to refer to their rapist as she. That is, I mean, that's incredibly traumatic for a woman to to speak about their rapist, a male rapist, as another. It's a gaslighting torture to expect a woman who's in prison to be locked in a cell with a man and be expected to call that man a woman, to defer to his feelings about himself when she is at risk in the most vulnerable place she can be. That is, I mean, this is egregious abuse of women. Egregious. Women have to have clear language and be able to articulate their lived experience, the life of being female, the struggles that has that are not part of men's lives, no matter what. Men have a male experience. Women have a female experience. We need words to be able to describe those. It impacts our statistics. It impacts our ability to craft good policy that defends women. It impacts our healthcare. It impacts our ability to discuss reproductive rights. It impacts our ability to celebrate women as equal champions in society. It impacts our ability to talk about the world as it is before our eyes. So suppressing women's speech and expecting them to hand over their language to men at demand is, I mean, it's so dystopian, it's hard to put into words.
Yeah, thank you very much for those very powerful comments. I really appreciate that. And through you, Madam Chairman, since I think you're in charge suddenly. I'm just thinking, letting some of what you just said sink in, and it's definitely very powerful. And I'm just always trying to put myself in the shoes of the person on the other side of these arguments. And I'm thinking about my colleague who unfortunately he just left the room, and I don't want to put words in his mouth either, but I get this impression from a lot of people advocating for this stuff, this type of policy. What's the big deal? You know, we're just recognizing someone else's freedom. And I'm like, you are very, very clear that you recognize someone's freedom to be able to live their life as they choose, as do I. I mean, the Declaration of Independence, the most important document to me, period. Pursuit of happiness. You want to do something, you should be able to, but it does have a limit. And that limit is when those freedoms interact with someone else's.
Going back to the language thing, I have to say, so this really became real to me when I watched what my daughter was being put through at school. It was shocking, but trying to express to friends, relatives, anyone, explaining what's going on in the locker room and why she's so upset, why the women are struggling, and saying about Leah Thomas, she doesn't belong in the locker room with the other girls. I sound like a jerk. I sound like I'm kicking another woman out of a space that she needs to change. As soon as I say he doesn't belong in the locker room changing with the girls, everyone's appalled. And when we remove women's ability to communicate clearly what they are seeing and advocate for themselves, especially when we strip that right when it comes to men, we put them in an impossible situation. They no longer have a way to communicate through images, through a mind, through an expression of what they're dealing with, an accurate portrayal of a plea for help.
Right. And as you pointed out several times, there is an objective reality, and you can't just sweep that under the rug as if it doesn't exist.
Yep. Thank you.
I really appreciate your testimony. It's very powerful. And I want to thank you for taking the time to be before the committee today, because I think a lot of us needed to hear with very sincere clarity just how important this issue is.
Thank you.
Very much. And thank you, Madam Chairman.
Thank you, Senator. Seeing no further comments or questions from members of the committee, thank you again for your time and your testimony. Next, we will hear from John Mertens, who will be followed by Ann Spire, who will be followed by Jamie Brennan and Joan Nichols. John, welcome. The floor is yours. John, I believe you're online.
There we go. Sorry, I had to unmute.
John, if you can, if possible, if you can turn your camera on, we would appreciate that.
It should be on. Oh, I see. Sorry about that.
Thank you.
Thank you. It's a pleasure to speak to you all. I'm here to talk about Bill 5498, specifically item 14 in the bill. I think it's lines 917 to 928 related to the independent party and the use of the word independent in party names. I teach engineering at Trinity College, and I teach people about unintended consequences. And I really appreciated some of the language that the Secretary of State used today about overcorrection and disenfranchising voters. We'll do that. This is a gross overcorrection to solve a very small problem. It's also unconstitutional. I think the same language was attempted in California and was vetoed by the governor because he knew it would be overturned as unconstitutional. I strongly urge you to remove item 14 from Bill 5498. A lot of things were said today earlier about Bill 5498 and the fact that it's nonpartisan. Item 14 in Bill 5498, honestly, I would say it is very partisan. It's the two major parties trying to eliminate the third largest party in Connecticut. The Independent Party is the third largest party in Connecticut with over 30,000 registered members of the party. The problem that the Secretary of State was describing was related to voters that were uninformed, who thought they were registered as unaffiliated and show up to try to vote in a primary. That you have to change your voter registration to Republican or Democrat to vote in that primary. And if you're unaffiliated, there's only a 1-day grace period or something like that. Whereas if you're already registered in a party, it's a 90-day grace period. I challenge the Secretary of State to quantify how big this problem is. I have a feeling it's tens of people that show up and are misinformed. I applaud the Secretary of State earlier by talking about the bad actor problem with absentee ballots as best solved through education. That is one way to solve a problem. This problem has another even additional and better solution, which is fixing the problem of our voter registration form. That's the problem here. Our voter registration form is poorly designed and it's easily fixed. It's been fixed in other states. And I applaud the Secretary of State by responding to Mr. Blumenthal when he said, "Are you open to other solutions?" And she said, "Absolutely." So as an engineer, you know, it's all about finding solutions to problems. The solution to this problem is fixing the voter registration form and continuing the continuous process of educating voters. You know, the voter rolls are constantly changing. New voters come on the roll. You have to constantly educate people, just like you're educating college students every 4 years. You have a completely new set of students on a college campus, so you're constantly teaching people the same thing over and over again. That is the job of the Secretary of State's office, is to continuously educate the voters so they understand that you're registering for a party when you write independent party on your voter registration form. The party has been around for 25 years. Connecticut should be proud of having probably the most successful third party in the country. The Independent Party has become the minority party in numerous cities in the state, including the most populous city, Waterbury. I've been involved since 2006. There
Mr.
are many
Martins, I'm sorry
passionate
to
people.
interrupt you, but your time has elapsed. Can you please summarize your testimony?
Just that item 14 in Bill 5498 should be removed from that bill for not just because it's unconstitutional, but out of fairness. It appears to be retaliation against the Independent Party because of what happened in Bridgeport. For 25 years, Independent Party's been fine. It's grown to the third largest party, and now all of a sudden there's a bill trying to make the use of to outlaw the Independent Party. I welcome any questions.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Senator Sampson.
Thank you, Madam Chairman. I just wanted to thank you for your testimony. I don't have any questions. I just want to let you know that I heard your testimony loud and clear, and that I will certainly be advocating that the language is adjusted to remove that language going forward. I'll certainly be advocating for that. I was as surprised as anyone to see it in the bill, and didn't really 100% understand what the purpose of what it was for until earlier today. But I agree that I don't think it's an appropriate mechanism based on the unfamiliarity that some Connecticut voters have with the party structure in the state. So I just want to thank you for your testimony. Thank you,
I
Madam Chair.
appreciate that. And I would strongly urge the committee to just craft a simple solution by fixing the voter registration form.
Thank you, Senator. Are there other comments or questions from members of the committee? Seeing none, thank you again for your time and your testimony. Next, we will hear from Ann Spire, who will be followed by Jamie Brennan and Joan Nichols, who will be followed by Muna Abbas. Ann, welcome.
Thank you.
The floor is yours.
Thank you. Good afternoon, ladies and gentlemen of the GAE. Thank you for hearing me. Excuse me, it's allergy time. I'm Ann Spire, Secretary of the New Britain Area League of Women Voters, which strongly supports HB 5494, the Charter Revision Ballot Question Bill. With me today is Patricia Rossi. She's co-president of the League of Women Voters of Connecticut, who also supports this bill. Municipal charter revision is too important to be on the ballot without clearly stated questions. Voters are frequently asked to choose yes or no on these questions. The question often reads, do you support the recommendations of the Charter Revision Commission? Most voters have little or no idea of what those changes are. The first time they become aware of the question is when they see the ballot. This has occurred throughout the state. You'll see testimony that's come in from other leagues and other people throughout Connecticut about it. This bill seeks to provide a safeguard on the language of these questions so voters know what they're voting on when their town seeks to change its charter. The New Britain League and League of Women Voters of Connecticut has been supporting this bill since last year. Before the 2022 election, we spoke to many, many voters, registering them, giving out information. We talked to them about the charter revision questions that would be on the ballot. Nearly every person we spoke to had no idea of what the changes would be. When they found out, they were angry that they were having such important and substantive questions hidden. Changes were hidden in the question and frustrated that disconnected issues were being lumped together. Very few voters knew anything about the ballot questions that they would first see at the voting booth. The generalized question on the ballot gave no information, and this is what needs to change. The League of Women Voters in New Britain area supported a similar bill last year. Its concept of clarity was well supported by many of you. We had hoped to offer changes to the section about reviews on this when it got to the Senate floor, but as happens frequently, time ran out. So we're back again. The sections on clarity and simplicity remain much the same. The new oversight process is designed to put little burden on the Secretary of State's office. As part of reworking the bill, our league committee met with Attorney Rosenberg of the Secretary of State's office, and we developed a simpler petition process. It is as follows. The Charter Revision Committee forms the questions. The authorizing body for us in New Britain, it's a common council, then votes on them. They're publicized, they're placed on the ballot. If 1% of registered voters has a problem with the wording of the questions, they may then petition the Secretary of State after the registrars of voters have confirmed their signatures. This process probably won't happen very often. Let me wrap up with about 4 sentences. It should not overburden the workload at the Secretary of State's office. It does provide an incentive for the process to be done right the first time. It does give the voters some method of redress that is less involved, less costly, and more timely than sending it to court. We believe HB 5494 will serve to safeguard the need of voters to be informed on referendum ballot questions and strongly urge its passage. I typed in there referendum ballot questions. That's my mistake. This bill only is written to apply for municipal charter questions. Okay.
Thank you.
Yes, that's its name on here.
Thank you. Thank you for your time and your testimony today. Are there questions or comments from members of the committee? Senator Sampson.
Thank you very much, Madam Chairman, and nice to see you. Thank you for being here today. Yeah, no, I'm very sympathetic to the argument that you made, and I know we had this bill in the past. And I'll just be upfront with you. My issue has always been the same thing, which is we're transferring the responsibility of coming up with the question from some folks at the local level who may not be doing a good job of drafting the question, and maybe transferring it to the Secretary of State's office to different people that may not do a good job coming up with the question. And I would use the questions that have appeared on our ballot in recent years regarding early voting and things like that. I don't think those have been well crafted questions at all and have been very misleading. That said, I'm supportive of the idea. There needs to be a way to make sure that more information appears in these questions so that we can make sure that the voters in those municipalities have a fair question in front of them so that they can answer it properly. The question is, I mean, how do we overcome that no matter what, we're going to have somebody who is an elected partisan person drafting the question.
Unless you go back to the courts, you're not going to. Because our whole governance structure is partisan structure. That's the American way. But these should be, if the law is written clearly enough as to what the standards are, I don't think they'll be all that hard to unearth and to figure out what is being required. I don't think that there'll be that much problem because it is being laid out to the charter commissions at the beginning of the process that you're going to have to come up with questions that meet these standards. There will be citizens who go and observe those hearings as the commissions work. I know I did it years ago and it goes on forever, but you can do it. They can too push, look, we want this thing to pass. We want this thing to get on the ballot. We need to have clear questions. So let's make sure we ask them this way. The whole structure for input should help with that. But yeah, you've got to have some sort of oversight. Our committee talked about this a lot. And we really concluded that if we left it just, well, you can always go to court, it is law, it becomes very cumbersome. It becomes drawn out in time. It becomes expensive for citizens who look at this and say, this thing's not clear. It becomes too difficult to administer. In order to keep it simpler, we came up with a process slightly borrowed from Maine in their petition process, only slightly, their petition for referendum oversight process. But we came up with a system so that people could afford to bring a challenge. It could get resolved quickly enough so that it could, A, go back to the Charter Revision Commission and be said, can you fix it this way? Because the Secretary of State may talk to them, may make recommendations. The Charter Revision can come back to them. It goes back to the council at that point, which votes on it and puts it on the ballot again. Hopefully hopefully it'll be done right the first time, as I said. But we always have to have a little carrot out there to guide people in the right direction. And the petition process is the carrot.
Through you, Madam Chairman, thank you so much. I mean, you
Yeah.
make a very compelling argument, and I'm pretty darn convinced, although I would love to find some alternative rather than just putting it in the hands of the Secretary of State. And I'll be thinking about that. If there's some mechanism that allows the minority to challenge the majority on the question or something like that. Be my guest.
I think there is actually, if you don't like the ruling of the Secretary of State, you can go to Superior Court. I believe that's in there. But then it becomes the long drawn out process.
Understood. Yeah, but I think at the end of the day, the court should be the final option if need be,
I
because we
believe
are
it's in
dealing
there.
with folks. Yeah, exactly.
Yeah,
So
I don't have somebody sitting over here to look at it, but I think I saw it. It was somewhere around page 5, maybe. I don't know. I saw it earlier
yeah, I'll
today.
take another look at the bill. I mean,
Yeah.
I didn't even look at it this year. I know it was this more or less the same bill from the last time.
Okay,
but-
except that, okay, one thing about this. Last year's bill.
And you're being very respectful. So I just want to make sure that we're clear. Everyone has to speak one at a time. Okay.
I'm sorry.
No, it's okay. You're
May I-
having a nice conversation. Go right ahead.
Okay. Last year's bill, every ballot question had to be reviewed by the Secretary of State's office. That was a mammoth job. That was not reasonable. This year's bill, it would only be if a group of 1% of the registered voters of that town petitions the Secretary of State. Then it might come in with a question to that office. But most charter revision questions should go through pretty smoothly.
Understood. Well, thank you very much, Ann. I really appreciate your testimony. I will look further at it and put on my thinking cap too to make sure if we adopt a process that it's the best one we can come up with. But I agree with you about the sentiment and the reason for it 100%. So I'm on your side as far as that goes. All right. Thank you so much. Thank you, Madam Chairman.
Thank you, Senator. Are there other questions or comments from members of the committee? Seeing none, thank you for your time and your testimony, and thank you for all of your work on this to get the proposal to this
There have been
point
about-
over the last year. We really appreciate it.
About
Thank you.
5 or 6 people have really worked on it.
Yeah,
So
thank you. Well, thank all of those folks too.
I will.
Okay, next we will hear from Jamie Brennan and Joan Nichols, who will be followed by Muna Abbas, who will be followed by Senator Kathy Austin. Welcome, Jamie and Joan. The floor will be yours as soon as you get to the chair and the desk and get to sit down. You can pull another chair over. Welcome.
All right, thanks. My name's James R. Brennan, for the record, also known as Jamie Brennan. In a housekeeping issue on your, because I have no cell phone or anything, I'm here today to speak on behalf of SB 435, Section 1. I'm here representing myself and my farm. Your docket, whatever you want to call the thing, says Farm Bureau. They enrolled me. I have no email. They put their email down, and that's how that got to that. So that we all know. Again, speaking in favor of SB 435, my name's James Brennan. I'm the owner and occupant of an 18th century farmstead. It's been in my family since 1872. I'm the 4th generation steward of the farm located in Seymour, Connecticut. The preservation of the family farm is an ongoing and emotionally painful subject for me. I chose to be here, though, so that my voice and story could motivate you to enact state oversight of municipal assessors' termination of farmland classified properties. This is paramount. Currently, the sole regulatory authority for investigating assessor misconduct is the municipality. I'll raise the question, who gets the additional revenue from farmland termination? Seems to me to be a clear example of the fox watching the hen house. I'll get to a resolution in a moment, but my history in this whole thing, I first became involved with farm classification and Public Act 490 in 1995, when I became the sole owner of the family farm. I've raised sheep, goats, many species and breeds of animals, trying to become profitable over the years. The farm itself was built, the house was built in 1760. As I've been in my family since 1872. In 1995, when I became the sole owner, I filed an application and received approval for farm classification. With that approval came a 10-year conveyance clause that states that for any time in the first 10 years, 10% of any sale of that property would have gone directly to the town. So there's the chart, the town is approving, the town is thing. Also, the first problem I had with farm classification from 95 to 2005, there was never an issue as to whether the farm was deserved classification. In 2005, when the conveyance clause ended, my farm classification was terminated by the town assessor. In 2005, I went to Zoning Board of Appeals. They overturned it. The higher authority overturned it and restored the farm classification. In 2010, the town of Seymour, same assessor, again terminated the farm classification. I went to Zoning Board of Appeals. In 2010, I'm learning more and more through the School of Hard Knocks as to how this all works. I went to the Commissioner of Agriculture and got an advisory opinion as to whether my farm met the state criteria for farm classification.
James, I'm sorry to interrupt you, but your time has elapsed and I appreciate that you're sharing with us the timeline of your story. So I will ask if you can briefly summarize that, and then we'll see if the committee has any questions, if that's okay.
It was overturned in 2010. I submitted a advisory opinion from the commissioner. My farm classification was restored by the Zoning Board of Appeals. 2015, the town of Seymour again tried to terminate my farm classification, the same assessor. I went to Zoning Board of Appeals, showed him the letter from 2011. they're familiar with town. I said, if you know my property, as per state statute, if you see no change of use, you have to vote to restore it. 2015, they restored it. 2020, the town, same assessor, again terminated my farm classification. And that was in October 1st, 2020. I am still in court. I've gone
Thank
through
you.
tens of thousands of dollars trying to preserve a family and a piece of town history.
Thank you. You can please stay. There may be questions from members of the committee. Thank you
Thought
for
my time was up.
your time is up, but we may have some questions that we might want to ask you. Thank you for summarizing. Thank you for your time and your testimony. Ms. Nichols, I don't know if you had anything you wanted to add just in summary.
Thank you. Joe Nichols, Executive Director, Connecticut Farm Bureau. In summary, what we're trying to do here is put a stopgap between the time that and I believe he's referring to the Board of Assessment Appeals, but a stopgap from the time that the Board of Assessment Appeals makes a ruling to before our farmers have to go before Superior Court. I can account in the last 10 years over $250,000 of money that farmers have spent to defend their 490 classification. These all had advisory opinions from the Commissioner of Agriculture, and those advisory opinions were ignored. What we'd like to put some teeth into the advisory opinion of the Commissioner of Agriculture so that they have final determination. We're not trying to usurp the authority of the assessors or the Board of Assessment Appeals, but we cannot have farmers spending tens, if not hundreds of thousands of dollars in court. Not to mention Jamie Brennan is good chance is going to lose the family farm. And we have had lengthy discussions with Commissioner Hurlburt on this, and he is in agreement with the language. He is equally as frustrated as have previous commissioners that they're spending state dollars, sending staff out to do their due diligence, issue these reports, issue the letters just to have them ignored. It is a small problem. The majority of the assessors in the state do a remarkable job. We have a tremendous amount of respect for the work that they do, but there is isolated problems that are small, but when they become problems, they're monumental for the Department of Agriculture spending their time, and most importantly for our farmers who are spending this money when they should be spending their time and money farming.
Thank you. Thank you. Thank you for your time and your testimony today. Are there questions or comments from members of the committee? Representative Hoxa.
Thank you, Madam Chair. And through you, just a couple questions for either one of you, whoever is better prepared to answer. First question's easy. I think you, Mr. Brennan, can answer this. Did you say that your farm or your property is in Seymour, Connecticut?
Yes.
Okay. And correct me if I'm wrong, but I'm understanding this, I'm understanding the timeline of events to be as such, that it was originally a farm, then that designation was taken away. You appealed, one appeal through Board of Assessment Appeals. And then at some point that title was taken away from the land. It was at some point after you won your case with Board of Assessment Appeals and 2010. At some point in that time period, the title was stripped. Is that correct?
Correct. The assessor has the opportunity to do that every 5 years at revaluation.
Thank you for reminding me of that. Yes, that's correct. So, when I'm assuming you need this done as soon as possible, the change back to a farm, correct?
It's probably well too late for me.
I'm sorry to hear that if that's the case. Would passage of this bill rectify any issue for you at this point?
For me, I'm just pending appellate court decision that was heard over 4 months ago that I've got no decision on yet.
And that can come at any time now?
Could come any day. Could come not for a year. To the best of my knowledge, I've not been able to find a timeline that they've got to make a decision. So I'm just treading water. But I would suggest easily, you know, as a previous person, that this could be referred to the Commissioner, Department of Agriculture, as the law now allows for an advisory opinion. If we apply state criteria and make it a declaratory decision, which would supersede an assessor's position, but as well to do something so that the assessor can't just, again, because he has some whatever reasoning, false reasoning, do it again in 5 years because he can, and there's no law that says he can't.
And do you have reason to believe that that the assessor, that only the assessor in your town would have seen your property as not worthy of having the farmland designation? Or do you think there's something fundamentally wrong with the way that they're judging these properties?
Well, let's look at the state statutes, you know, says once a property has farm classification, which I received in 1995, because it goes with the owner and not the land, that, I'm sorry, that's where I was, but advisory opinion, it can, and go to another statute, I believe it's 504H, School of Hard Knocks, to the fact that, it can, it says, once a property has farm classification shall remain so classified until there are either 1, a change of use, or 2, a change of ownership, because it goes with the owner of the land and not with the land. So unless there's a change of use, which has not occurred with everybody who's seen the property, anybody think this in 2020, the town of Seymour revamped the zoning commission. I lived in Seymour all my life. I didn't know one person on the zoning board of appeals.
And could
Thank
I-
you, Madam Chair. That's all I have.
Thank you, Representative. Are there other questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony today.
Thank you very much.
Thank you. Next up, we have Muna Abbas, followed by Kathy Austin, followed by Sue Larson.
Hello.
Whenever you're ready, you can begin.
Good afternoon, chairs, ranking members, and all esteemed members of the Government Administration and Elections Committee. My name is Muna Abbas, and I'm here in support of SB 433. I'm an Associate Commission Analyst at the Commission on Racial Equity and Public Health, a non-partisan legislative branch agency tasked with making policy recommendations to reduce disparities on matters affecting public health. In 2021, the legislature gave us the specific charge to report on best practices to reduce racial inequities within Connecticut's state government. This bill is similar to Senate Bill 413 in the Labor Committee, but is more broad in that it contains all the recommendations from our report, which was released in December 2023. The bill creates diversity, equity, and inclusion divisions to support state agencies as they operationalize equity work. This is an approach already in place in varying degrees in DCF, DDS, DOT, and DEMAS. The bill assigns these DI divisions with developing agency equity plans and examining proposed policies to ensure that they don't adversely affect underserved communities. These plans resemble what currently exists at DCF and among all federal government agencies. They can track whether underserved communities are faced with barriers to accessing services and are a useful tool to document and hold agencies accountable for goals they have or haven't achieved. Our report also focused on how to make hiring processes more equitable. It is important to note, however, that this bill will not mandate any quotas or particular outcomes of any hiring decisions. Rather, it concentrates on capturing data and incorporating a wider range of perspectives in the hiring process. First, the use of diverse hiring panels is a great way to include different viewpoints and backgrounds when interviewing candidates and minimize the effects of implicit bias. Following in the footsteps of the federal government, the bill also allows for the collection and retroactive analysis of anonymized applicant flow data to identify any demographic trends. The bills also take steps to introduce equity-related training for state employees that is effective and substantive. Modeled on the judicial branch, this training will allow employees to discuss and understand different backgrounds, confront implicit biases, and to dispel stereotypes. We hope this will help cultivate an inclusive culture within agency workforces and assist employees as they interact with underserved communities. To further equity work, the bill also underscores the need for community input and describes communication standards when engaging with those who are underserved. Finally, the bill contains provisions to ensure that the state's commitment extends to its contracting and procurement practices. This bill is part of a package which will be another step in efforts to cement equity in Connecticut state government, an endeavor the legislature committed to 3 years ago. Thank you for your time. I hope you can support this bill, and I'm happy to take any questions.
Thank you for your testimony. Ooh, that was quite loud. Questions from the committee? Senator Sampson.
Thank you, Mr. Chairman. And thank you so much for being here and sharing your testimony with us. I'm trying to wrap my head around this bill. I did see the bill that's in the Labor Committee, also as I serve as the ranking member of the Labor Committee as well. Maybe you could just, simplify and summarize what the bill actually requires. I know you mentioned that it will be creating DEI departments in more state agencies. How many people are going to be hired, and in what state agencies will they be placed through, Mr. Chairman?
Thank you, Senator Sampson. So in the bill, in the first section, it outlines exactly which state agencies that we would like these divisions to be created. However, it's also important to note that in some state agencies already, they have either this exact position or something that looks very similar. So some of them won't necessarily need to create these divisions because they already have a variation of existing current.
Thank you very much for that information. Yeah, and I'm looking at the list of the different departments that are itemized in section 1. And I guess it's your testimony that the state needs to create a DEI program for each of our state agencies, or is this not inclusive of all state agencies across the state government? Through you, Mr. Chairman.
So just to step back a bit, the point of the report and why it was initially created was that 3 years ago, in the aftermath of while we were dealing with the ramifications of the COVID-19 pandemic and the killing of George Floyd, the legislature really took a step to address racial disparities in public health, but also they also took that as an opportunity to look at the way that state government is set up and whether there's anything that's happening within the way that state agencies operate which might be contributing to any of those disparities that we have seen arise in our society. So what the bill does is it wants to make sure that state agencies are cognizant and look at all of whether it's their policies, their operations, the way that they conduct their hiring practices, to make sure that they are always conscious of equity and how that might impact, how their decisions might impact certain communities. Is there a different way of looking at things? Should we take into account X, Y, Z, or certain communities when we make these decisions? And the way that the report was written as well is we looked at national and local things that are being done across the country, which we could learn from as a state. So, and a big influence of that was actually the federal government and what President Biden calls the whole of government approach. And what he did is create a similar structure in the federal government, which kind of put equity work at the heart of everything that they did, so that they made sure that the way that government operates is that it doesn't harm any underserved communities and doesn't contribute to any inequities that might be taking place.
Yeah, thank you so much for that answer. And the reason why I asked through Mr. Chairman is I'm noticing all of the state agencies that are itemized here.
Yep.
And you were very clear about, how the legislature tasked your state agency with determining outcomes based on race in public health. But yet we have all these other state agencies, consumer protection. I don't know whether that has to do with public health, corrections. And maybe, maybe there is some overlap there depending on, the public health of inmates or even, people employed at the Department of Corrections, energy and environmental protection, motor vehicles, transportation. I'm not seeing a connection to public health with those state agencies. And I'm just curious whether or not this goes beyond the request that was in the legislation that you referred to.
So when our commission was created in 2021, in Public Act 2135, it did task us with looking at public health, and the definition of public health is quite broad. It looks at all social determinants of health, and that includes things such as the environment, such as criminal justice, housing, and education. But specifically, the legislation and the that was written for this report, which this bill is based on, actually tasks us with looking at all branches of state government. So it actually included the legislative and the judicial branch. But however, when writing this bill, we decided to narrow it down to the main state agencies in the executive branch.
Yeah, through Mr. Chairman. Thank you for that. I just, it always seems that when we do some sort of legislation that is relatively targeted, it ends up expanding into a lot of different areas. And just as someone who's an advocate for small government, I always have some reservations when we have policy that, particularly when it comes to creating, what I consider to be a very new system of hiring practices, that it's rolled out, in a kind of a systematic kind of way and not all at once across the entire state government. And I know I'm using broad terms. I'm certain it's not the entire state government, but it's a substantial number of agencies. I heard your testimony, and I've read the information that you provided. I have to be honest. I have a difficult time following some of the language that is associated with the DEI world. And I noticed that the bill does contain definitions of equity and implicit bias and so forth. You said that part of this is about the creation of agency equity plans. Can you tell me exactly what an agency equity plan might look like? Through you, Mr. Chairman.
Yes, so this section of the agency equity plans, when we looked at the best practices that are being carried out in Connecticut and around the country, we found that there was a common theme that was being done, both in the federal government, in the National Center for State Courts, which gives guidance to state court systems, so in the judicial branch, but also within our own agencies, where they created these plans which would look at data that is being collected, and see if there are any trends and outline any policies that they can do, and kind of lay out a path and a map for state agencies year on year as they annually update them to see, is there anything that we can spot here that is concerning, that we might need to look at. So for example, if you look at some of the federal agency equity plans, they give recommendations, or they list certain practices that they're going to introduce, or they also list out data that they have found to whether they have recognized any disparities that are occurring in separate places. And so these plans are a really good kind of inflection point that agencies can use to routinely look and track at what they're doing from an equity perspective, and what they can do year on year to improve that.
Through you, Mr. Chairman, thank you very much for that answer. I don't know if I really, I mean, I'm not saying you did not give a thorough answer because you most certainly did. I just don't know that I actually grasped it or have something concrete that I can hang on to. Again, I'm struggling with understanding the notion behind DEI and the policy behind it because maybe I just don't understand some of these words. I read the definition of equity that is in the bill, which says the consistent and systemic, fair, just, and impartial treatment of all individuals, which I think is fine, and it could just end there. But it goes on to say, including individuals who've been belong to underserved communities that have been denied such treatment. I think that makes an assumption that every person in certain communities is underserved. And I don't even know underserved in what way. And that's what I guess I'm trying to understand. And then I'm trying to figure out what is supposed to be done about that. And I'm looking, and I guess it's the creation of diverse hiring panels who will conduct interviews and apparently do a better job at hiring people. Is that the premise behind the legislation before us? Through you, Mr. Chairman.
Yes, so first of all, on the definition of equity, that has been lifted from the federal definition of equity in the federal government, President Biden's executive orders, which a lot of this bill is based upon. And the diverse hiring panels, that is focused around the principle that we want to encourage cognitive diversity and the inclusion of different perspectives in the hiring process. In the corporate world as well, it has been acknowledged that once you get a variety of people from different backgrounds in one room, they think differently, and when you put all of those perspectives together, you actually come up with better decision making, and whether that's for a corporation or in our case for government. So this doesn't necessarily, like I said in my oral testimony, doesn't mandate any outcomes in any way. It just allows for different perspectives to come into the interview room and look at candidates and hopefully pick the right person for the job.
Thank you for that answer. And through you, Mr. Chairman, I understand what you mean by cognitive diversity, and I like the sound of that. I think that's a very important aspect of any type of policy making period. And certainly it would extend to making sure that you have, well-rounded employees that have, the necessary skills to do their work. But the diverse hiring panels, are they members of those panels selected based on cognitive diversity, or are they selected based on other factors? Through you, Mr. Chairman.
So the way that we envisage these plans take place, and they are already in place in varying degrees in our government already, is that they just take into account the demographic backgrounds and age backgrounds. It doesn't it doesn't mean that you don't take into account someone's experience. They still need to be someone who is appropriate to interview a candidate. But you would want demographic diversity. So you would want, for example, a woman there. You would want someone who has a different racial background, people from different ages, or so putting all of those different people coming from different perspectives into the room.
Through you, Mr. Chairman, thank you for that answer. And that's kind of what I was looking for, because I'm reading the bill, and it says such hiring panels shall be comprised of current employees. So I assume that these folks will be selected among current employees of that agency in appropriate positions, which I don't know what that might be, but it says from varying backgrounds, including but not limited to race, ethnicity, gender, age, and sexual orientation. Just as you mentioned, you said you would want a woman there, and you would want someone of a different racial background and different ages. That's what you said. The problem I have with that is that, maybe the panel is not going to use some sort of quota to determine who will be hired for jobs, rather than what I would suggest is the proper way to hire someone and what has been traditional, in which we hire the person that is most qualified for the position, and we ignore those superficial characteristics, because to do so and to recognize them would be discrimination. It seems that the hiring panel is going to be selected in a way that involves discrimination. Do you have a comment about that to make me might feel better about how we're going to go and select people by race and color to make sure that we have a diverse hiring panel through you, Mr. Chairman?
No, I don't agree with that analysis. The way that the way that we envisage these hiring panels to take place is just to bring different perspectives into the room, and those different perspectives will not think in the same way, and it will not take away from how you assess someone and the grading rubric that you use. If you put a woman on a hiring panel, that doesn't mean that she's necessarily going to pick the woman for the job. All we want to do is introduce different perspectives because we see things differently. This will not involve discrimination in any way, and there is language in the bill to ensure that it's not if it's not possible, then that's okay as well. This is already a practice that is already used in varying degrees in state government, and at this point, it hasn't been something that has been problematic. We've not seen that it has caused any discrimination in any way, so I wouldn't agree with that analysis.
Through you, Mr. Chairman, I don't know what analysis you're referring to. Forgive me, because I didn't say anything other than what the bill says, and described what you had indicated was how the hiring panel was created. I'm not suggesting that somehow the hiring panel is going to use their makeup as a way to influence the way people are hired. I never went there. I just asked whether or not there was an issue with discriminating against or for people based on their inclusion in the hiring panel, because it seems to me that that's obviously what's happening. If you're suggesting we must create a hiring panel, and the bill says from different backgrounds, race, ethnicity, gender, age, and sexual orientation, and those were exactly the way you characterized the bill. I mean, that sounds to me like we're discriminating. Is there no preemption against discriminating in the creation of a hiring panel in our laws? Through you, Mr. Chairman?
No, I don't believe this is what the bill is doing. It's voluntary for people to take part in these hiring panels. The way that it's written is so broad that you can this and state government already, thankfully, is already quite diverse, that you're not going to be pulling people up or taking people disadvantageously from different places, or putting a burden on one community over another. So I don't think that that's what will happen.
Through you, Mr. Chairman, I appreciate the answer. Did you just say that the participation in the hiring panel is voluntary?
If an agency can make a diverse hiring panel, then they do not have to go ahead with it. They can just submit in writing that it wasn't possible or it wasn't appropriate for the role that it was needed. And of course, if someone is unable to or does not want to take part in the hiring panel, then that is also okay.
Thank you for that answer. So am I to understand that the agency commissioner would be in charge of determining who is on the panel, and they would be charged with selecting people based on lines 143 through 146 of the bill, which would be to select employees in appropriate positions from varying backgrounds, including but not limited to race, ethnicity, gender, age, and sexual orientation. That to me tells me that the commissioner has got to go out and actively select people who fall into these superficial categories and put them on a panel. And I have a lot more questions than just this, and I don't want to waste the time of this hearing going through a lot of it, but I figured that I would ask you directly, because this legislation is created by your agency, And I just wanted to hear it directly from the horse's mouth, so to speak, that what we're attempting to do here. And I'm not even necessarily opposed, but I have a little trouble with some of the terms here. And for an effort that's supposed to be condemning discrimination, particularly discrimination based on race and gender, ethnicity, and so forth, that it seems to actively engage in it. And I think that's a complaint a lot of people have with DEI programs, is that they put so much emphasis on people's differences that they don't recognize that there's only one race, the human race. And before I go any further, I just want to confirm that my understanding is correct, that that's the job of the agency commissioner, whoever he puts in charge. They've got to actively select people from these different superficial categories to assemble a hiring panel. Am I correct about that?
Right now, when you are hiring for a particular position and you put a panel together, we would hope that state agencies already create those panels with wanting to include people who can think of things from different perspectives. We want that to be part of that decision-making process when you form the panel, of how we can incorporate different viewpoints and different and people's experiences into that. This is about inclusion. I don't think it's about division. I think it's the opposite. It's about making people included into hiring processes, to make sure that they can offer different perspectives with who can be their different colleagues. Perhaps they can see things from a different lens. That's all this part of the bill purports to do.
Through you, Mr. Chairman. Thank you for that answer. You said we would hope that people would have different perspectives. And that may be true, although it doesn't seem like the most effective way to hire people to me. I mean, generally speaking, and certainly in the private sector, people hire people based on their ability and their experience. That's the reason why people are hired for different jobs. Not because we put together a room of people of different, appearance and backgrounds so that we could hear their perspective on the job. If they have something valuable to add, certainly. You mentioned cognitive diversity a couple of times, and I love that. Cognitive diversity is great. And if somebody has something to add to a position because their experience as, a man or a woman, or as of a specific race or religion, then yes. But there's nothing in here that says anything about cognitive diversity. That's only your commentary. And that I agree with. But this doesn't say cognitive diversity. This says diversity based on superficial characteristics, which is, for me, the thing we're trying to get away from. And we want to start treating people equally, not putting them into different boxes and suggesting that somehow because you fit into a box, you have some experience to lend to hiring a corrections officer or a psychologist at the Mental Health and Addiction Services, or a vehicle inspector at the Department of Motor Vehicles, or someone who reads contracts at Consumer Protection. Wouldn't we suggest that our agency leaders choose employees and hire them based on their qualifications and experience, more so than whether or not a panel of people that look differently, that fit some sort of suggested rainbow of worldviews, can put their blessing on a person? Through you, Madam Chairman.
I'm glad that you like the use of the term cognitive diversity. If that's something that language that you want to suggest, if and when the bill is amended, then I'd be happy to look at how we can incorporate that. I think it's important to note that you're absolutely right in that you always want to hire the best person for the job. The unfortunate thing is, though, however, is that from data that we've seen of how a lot of decisions are made, whether they're hiring decisions or just the way that we operate as humans, is that there is implicit bias baked in. And we all have that, and there's nothing wrong with that. And it's just the part of the way that how we are created and how we are conditioned to think and believe things about people from different backgrounds. To eliminate the implicit bias from kind of creeping into the decisions that we're making, including possibly hiring ones, and maybe subconsciously we're making decisions based on the way that people talk or what they look like without us even knowing it. Having more people in the room who have different perspectives can actually help eliminate that, to actually make sure that you are hiring the best person for the job, that it is based on merit. And there is a lot of data in the private sector that actually just show that when you put when you have a more diverse workforce, they actually come up with better decision making, and that is a model that we hope to bring into state government, and it's kind of the spirit of what this section of the bill looks at incorporating as well.
Through you, Madam Chairman, I see we've swapped chairman again. I'm staying on top of it, though. Thank you very much for that answer, and I appreciate that we have an agreement on the notion of cognitive diversity. I'll stop trying to debate the bill with you. I'm really trying to get down to where the proponents of this legislation are coming from, so that I can have that perspective when this bill does come up for debate in this committee. But I'll just leave you with this, that I'm somewhat offended by the bill, because I don't believe in discrimination. I don't believe in treating anyone differently based on their race, gender, religious background, and so forth. I believe that we should judge people on merit and solely on merit and their qualifications. And if I was on a hiring panel, I would not be looking at the the gender, race, or anything of the applicant. I'd be looking at their qualifications, whether they could do the job. And I would certainly take into consideration other factors like their life experience, and how that might play into the role that they have, and their ability to work in such a role. And that's what we should expect from anyone. But if we're going to promote policies that say that we're going to create a hiring panel and it's got to have a makeup that says, oh, well, you gotta have a woman on there, and we've got to have someone of this ethnic background and someone with this background. That's discrimination right from the get-go. And when you're asking those people to have input into the hiring practice, and that's their level of expertise, is that they actually meet some superficial qualification, not that they know anything about the responsibilities for the job. If I was supposed to assemble a hiring panel as a state agency leader, the hiring panel I would put together would be people that have experience in the job that we're hiring for. That's it. And to do anything else, I think, is discrimination. And I know there's a lot of people that feel like I do. And I think that, while across the country, I think people are certainly open to policies that claim to want to end discrimination. I think that people are becoming wise to what actually does end or promote discrimination. And I don't think that DEI programs are going to last much longer as a result, because I think people are recognizing that they don't actually eliminate discrimination. They actually, on their face, engage in it. And those are all the comments I have. Thank you, Madam Chairman.
Thank you, Senator. Are there other questions or comments from members of the committee? Seeing none, thank you for your time and your testimony today. Next, we will hear from Senator Kathy Austin, who will be followed by Sue Larson, who will be followed by Jameem Davis. Welcome, Senator Austin. The floor is yours.
Okay, I have to tell you, Madam Chairwoman, that I've never testified in front of GAE until this year. And here I am again. So I really appreciate all of you for taking up a bill that I will be talking about in a second. But I wanted to talk one very short minute on Senate Bill number 435, in particular, Section 1 that Mr. Brennan brought up, and say that this is not a single issue that has come up. This has happened to Hillendale, which has chicken coops all over eastern Connecticut, the largest egg producer east of the Mississippi. And they have had to fight for this. And the assessor in question said that they did not believe that chicken coops were agriculture. And I don't know anything else that chicken coops are, but agriculture. And so I wanted to make sure that you knew that this was not just something simply for one person. And I find what happened to Mr. Brennan to just be nothing short of despicable. To take somebody's long-term land away from them is just not right. But I'm here today to talk about an act concerning the designation of Mount Decatur as an historic site. And Mount Decatur is recognized as the only site left that recognizes the War of 1812. The community is broadly concerned that the site will be destroyed and we will lose our last remaining designated War of 1812 site. It is located in Gales Ferry on the former Dow Chemical site, now owned by a company called Cashman. And they are doing a lot of work on the site. It's always been, for years, been an industrial site. I would say that I am also a member of Preservation CT. And as a member of Preservation CT, talked to the executive director to see if they could walk the site, and they have, welcomed by the current owner. Unfortunately, that was when I broke my leg, and I have not been able to walk the site much. The site itself, Mount Decatur, is well known in the community as being a part of the War of 1812. And the owner of the property has done 2 site reviews, one initial site review and one broader site review that has not yet been released. I'm being told by the owner that they will release it, and they are interested in coming up with a way to recognize this site. The community is still very concerned because one of the things that was going to be done on the site was a quarry that permit has since been pulled. But whatever you can do to recognize Mount Decatur as what it is a site, the only site left recognizing the War of 1812. I'd be happy to answer any questions.
Thank you. Thank you for your time and your testimony. Are there questions from members of the committee?
I'm going to come all the time because you never ask me any questions. And I am so excited. Thank you very much.
Thank you. Next, we will hear from Sue Larson, who will be followed by Jameem Davis, who will be followed by Michelle Jacqueline. Welcome, Sue. The floor is yours.
Thank you. Senator Flexer and members of the GAE committee, my name is Sue Larson, and I'm the chairman of the Rovac Legislative Committee. I'm here to speak on 2 bills, SB 441. I'll talk to that one real quick because you have my written testimony, so I'm just going to summarize real quick. We're in favor of the concept bill of SB 441, but there has to be a lot more detail added to it in order to make this a really good, strong bill. One of the areas we feel that has to be stronger in is to make sure that everybody on this panel has election experience. And we're recommending for registrars that they have at least 5 years experience, making sure they've gone through municipal and state elections. Also, we'd like definitions of what the tiers are, because we want to make sure that each tier has every registrar and every poll worker that may be involved in this is aware of what is a tier 1, what is a tier 2, what is a tier 3. You know, simple things like the Secretary of the State mentioned earlier this morning, a complaint from an elector that the registrar wasn't in the office at the time, and it simply was they went out for 5 minutes or whatever and should have put a sign up there, but forgot to do it because they were in a hurry or whatever. But basically, that's not something that should be going under a board like this. There needs to be more depth to the complaint to come to a board like this. So that's why we're asking for a better definition. The other bill is 5498, and I kind of did my presentation, my testimony, based on the statement of purpose. So I went through that and I said, okay, under number 5, we use ERIC all the time. It's a good way of doing an NCOA, finding out people moving between states, between towns, within your own town. But what we're finding is that fewer and fewer states are participating in it because of privacy issues with the rolls. So we want to make sure that anybody who's got that we're sharing data with and that we have their data, we're protecting it as well as our own voter rolls. And we think that's really important. The second one was number 7. We do think that it should be mandatory that town clerks use the absentee ballot system in CVRS for many reasons. One being very, to the registrars, it is so time consuming to sit there, have to check the typo on the absentee ballot. I'll be real quick. Typo, juniors, seniors, everything, if that's done right off the voter rolls, we've got all of that straightened out. It cuts the absentee ballot checkoff time in half or more. Number 9 was early voting and same-day registration, 75-foot signs for candidates. Same thing for polling places, just put the wording right in there for early voting, same-day registration.
Thank you, Sue. I need you to summarize your testimony or perhaps wait for a question that might elicit the response you want to give right now.
Okay. Remove permanent absentee requirements for the town clerk and registrars, and then change the audit selection days.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee?
Okay.
Thank you for your time and your testimony.
No problem.
Next, we will hear from Jameem Davis, who will be followed by Michelle Jacqueline, who will be followed by Aisha Clark. Welcome, Jameem. The floor is yours.
Good afternoon, co-chairs, Senator Flexer, Senator Sampson, Representative Mastro Francesco, and the entire GAE committee. My name is Jameem Davis, and I'm the co-director of Bridgeport Generation Now, a grassroots organization fighting to end systemic corruption and building and to build the Bridgeport we know is possible. I am testifying in support of SB 441 and HB 5498 with some very important changes. We have come before this committee for 4 years since 2019, alerting you all to the absentee ballot abuse in Bridgeport and how it works. Political operatives sign out hundreds of absentee ballot applications a year before the election. They lie to voters about the qualifications to vote AB. They forge voters' absentee ballot applications, and they take voters' ballots, all for the purpose of controlling the outcome of our elections. And they target voters who are most vulnerable to manipulation, intimidation, and abuse. Our elderly, disabled, low-income, and Spanish-speaking voters. Sadly, the abuse in Bridgeport has now made international news. In December, the Connecticut Mirror published an investigative story into how absentee ballots define the outcome of Bridgeport's 2023 primary for mayor. Documents showed that Wanda Jeter Pataky and others who were caught on video stuffing ballots into the drop box assisted voters with at least 537 absentee ballot applications ahead of the September election, which was decided by only 251 votes. The Mirror also reported that campaign workers were so persistent that at least 370 Bridgeport residents eventually had 2 or more absentee ballot applications submitted in their names. 22% of all votes cast in the 2023 primary for mayor were absentee ballots, by far the highest in the state. Finally, it was reported that Jeter Pataky, who backed Ganem and other candidates endorsed by the local Democratic Party, assisted more people in filling out absentee ballot applications than anyone else. She signed at least 12% of all applications that were submitted, despite the fact that the records indicate she never registered to distribute those forms as state law requires. It is because of this behavior, it is because of behavior like this that in 2019, Judge Stevens directed the state legislature to take up major reforms to address the illegal and disturbing behavior that came to light after the 2019 mayoral primary during the Lazar v. Ganem trial. In particular, Judge Stevens called for prohibitions against party workers circulating absentee ballot applications. While HB 5498 is comprehensive, it currently states that no one is allowed, I'll be done in just a minute, more than 5 absentee ballot applications at a time earlier than 90 days prior to the first day of issuance of absentee voting sets. This means that in the year leading up to an election, political operatives will still be able to take out hundreds of applications. They'll just do it 5 at a time. It also means that 90 days prior to absentee ballots being issued, we're right back to the reality we face now, that anyone can walk into the town clerk's office and walk out with hundreds of applications. This will not solve the issues in Bridgeport. And I'll
Thank you.
submit it as written.
Thank you. Thank you for your time and your testimony. I'm going to indulge myself for just a moment and ask you quickly, I know there will be questions from members of the committee, but I want to ask you if the language with regard to the 5 days that you just talked about, if it was, with the 5 applications, if it was just once during the cycle, would that give you a little bit more comfort or no?
We don't believe political operatives need to be in the process of absentee ballot distribution at all. Campaigns don't need to be involved. The way someone votes should be between them and the administrators of the election, period. If people need an absentee ballot, we have lots of ways for people to get them. And if they need to get them for family members, then allowing someone to take out 5 is fine. But political operatives don't need to be in the middle of this process.
Thank you. Thank you for that answer. Are there other questions or comments from members of the committee? Senator Sampson.
Thank you very much, Madam Chairman, and thank you very much, Jimmy, for being here today. I really appreciated your testimony more than you know. I'm sitting here nodding my head wildly. Basic question. Do you think that the situation in Bridgeport or anywhere else has gotten worse since 2020 when it became the custom in Connecticut to make everyone eligible for an absentee ballot?
I actually don't think it's gotten worse. I think has been revealed. I think that in 2019, we saw this exact same problem when Senator Marilyn Moore ran for mayor, except that this year, in 2023, we had video from the drop boxes. In 2019, they simply put the absentee ballot or in the mail.
Right. And do you think that if we start to add more security to the drop boxes, as the bill that's before us, 5498 does, with the video requirement, do you think that that is going to have any impact on stopping that activity?
I think that the video is helpful because what we saw during the 2023 primary is that they got caught, right? So they went to those drop boxes and they got caught. Unfortunately, when it came around to the general election, they just went back to putting them in the mailbox. So yes, I think video is good and I think we should keep it and I think we should keep the drop boxes. But really the only thing that's going to deter people from abusing the system, well, there's a couple things. One is we have to enforce the laws that we already have. So we have laws on the books already, but they're not being enforced. We still haven't seen anyone get arrested in Bridgeport. And I just want to add that Wanda Jeter is not the only person. I know her name has been used here a lot today, but there are several individuals who were on video, and there's been questionable behavior by them. But we need to enforce the laws that we already have on the books, and we need to, like Judge Stevens suggested in 2019, remove political operatives from this process. That will help Bridgeport.
Yeah, through you, Madam Chairman, thank you for that. That's excellent testimony. And I certainly do agree that there are a number of different folks that have been identified, even in Bridgeport. It's not just that one individual. It's just that unfortunately for her and for the rest of us, that was publicized across the airwaves, and people identify that situation with that person. But yeah, no, I appreciate your testimony very, very much. And to me, that's you brought up the key ingredient, which I think is political operatives being involved in the process. You might disagree with me about this. I'm against any mass distribution of ballot applications at all. I think that if you wish to vote, you can either go in person, and if you can't go in person, it should still be your responsibility to ask for the ballot application directly. At least that way, we know that only that one person is asking for that ballot application. But are you suggesting that we should simply eliminate political candidates and their operatives from being able to participate in the absentee ballot practice, but maybe allow municipalities or the Secretary of State? Through you, Madam Chairman.
Yes, that is what I'm saying. I do believe that in 2020, what we saw during the pandemic was that when people were enfranchised to vote, so people were afraid to go to the polls, afraid of sickness and all the things like that, and everyone was enfranchised at the same level. People chose whether they felt comfortable going to the polls, and they chose whether they wanted to use an absentee. And that process, I think, worked beautifully. I think people chose, they got the application, nobody knocked on their, they weren't relying on people knocking on their door and saying, fill this out or anything like that. People could just choose what they wanted to do. And I think enfranchising people to vote whichever way they choose is the best thing we can do for our democracy. It will increase participation.
Yeah, through you, Madam Chairman, I don't disagree with you. I just have different objections to that process. Mainly, the things I discussed with the Secretary of State, the quality of our voter rolls, and basically the expense of having the state government, mail out absentee ballot applications to every voter. When you figure many voters are still perfectly capable and willing of voting in person, it doesn't make a lot of sense to me to be using that kind of taxpayer money to be sending out those ballot applications. But I agree with you. I think we were on the same page as far as wanting a process that we can rely on that allows people the most access possible, but doesn't allow bad actors to get involved in the process and interfere. I really appreciate your testimony. It means a lot to have you here today, and thank you very much for coming forward.
Thank you.
Thank you, Madam Chairman.
Thank you, Senator. Are there other questions or comments from members of the committee? Representative Mastrofrancesco.
Thank you, Madam Chair. Thank you so much for coming in. I appreciate your testimony. What organization did you say you represent? I didn't see any testimony online for you.
Bridgeport Generation Now. I'll have to submit it online.
Okay, thank you. You mentioned that you had a couple suggestions on changes that you would like to see on the bill. Obviously, I know one of them was the solicitation of absentee ballot applications. Was there anything else?
We did send the panel a letter, and not the panel, we'll send your committee. We sent your committee a letter with some suggestions in it. I'll make sure that you get that. But one key thing that we're really we're asking for is that political operatives not be allowed to distribute absentee ballot applications, and that the time frame that applications are available is in line with what the Secretary of State did during our special election, which was to limit it to 30 days before the election, and to limit the number of applications that people are allowed to take. So if I'm living in a household and I have a family member and we're going away on vacation, me, my mother, my father, you know, I can go and take out 3, I can go and take out 5 if I need. But we should be limiting the amount.
That you can take, yes, I certainly agree. This is always an ongoing problem in Bridgeport, not only Bridgeport, but I see it in other cities as well. Over the years, what has your organization done to try to, during election time? You know, sometimes you got to take matters into your own hand and kind of get creative, say, look, we know people are going to do this. What are we going to do to combat it? What can we do to lessen, you know, to mitigate it and make it so it doesn't happen? What have you guys done? Any examples you can give me?
Yes, we've tried everything. So we have gone into our senior buildings to educate them on the laws around absentee. We've gone into low income housing to try and educate people on what is an absentee ballot, why you would use one, what the laws are. We hold a yearly Civics 101 workshop where we talk about all things like city government and state government. In the last election, we actually sent voters, we sent about, oh my goodness, I can't think of it right now, but somewhere's around 17,000 primary voters. We sent them a letter with all of the information on if you need to use an absentee, this is how you do it. Contact the town clerk's office. We sent them an application so that they didn't have to rely on somebody else giving them one. And we did not at all chase them, you know. So what people do in these situations, what campaigns normally do is they give someone an application, then they go knock on their door and they say, did you fill it out or give it back to me and so forth. But we didn't do any of that. We sent an application, we sent the rules, and we said, if you want one, this is what you do.
Thank you. Through you, Madam Chair. So the political operatives that you're talking about, they basically do the same thing, right? They'll go out there and they'll just send out a mass mailing of absentee ballot applications so people could do it.
No.
No? Is that
No,
not
they
what's
go to
happening?
the town clerk's office, they sign out hundreds of applications at a time, and they go door to door, and they have people sign them up, or they will fill out those applications themselves, and they will sign them, and they people will get applications, people will get ballots without even requesting one.
Okay, so I guess what I'm trying to figure out is the difference, because you mentioned that you would want to get the political operatives out of the equation. Would that include them, like you guys have done, just not mailing them at all? So
Yes, it
apply
would
to you gu-
definitely
it would apply
include
to you
us.
as well.
Yes, it would definitely include us.
Okay, that's all I wanted to know.
Yeah.
Thank you for coming in and thank you for your testimony. I completely agree with you. I think those applications is the heart of the problem. And until that is resolved, I think we're going to continue to have bad actors, as what we've been saying all day today. Thank you for coming in. I appreciate it. Thank you, Madam Chair.
Thank you, Representative. Representative Moore and Bello.
Hi.
Hi.
Excuse me, through you. Part of your testimony, you said that you would like to limit the amount of time that people can obtain an absentee ballot. Is that correct?
Yes,
The application?
the application, yes.
Okay. Don't you think that that would hinder our youth from being able to vote by absentee ballot? I have 3 daughters that are in school, they're not, you know, in Weathersfield when 2 of them are not in Weathersfield at the time of voting. They usually go down to the town clerk's office in August before they head back to school to get their application to then go vote, you know, for the voting in November. So do you see that may impact or disenfranchise some of our newer voters, our college students who aren't living in the state or living in their communities?
No, I don't think it will disenfranchise them. I think that if everyone is apprised of the rules, then we can make allowances for them. So if your daughters, you know, we suggest 30 days, but you all may, you know, come up with 60, you know, but certainly what happens in Bridgeport, and I'm sure in other cities, is that when we have a primary in September, we have political operatives taking out applications in January. and and I'm talking about 100, 200, 500 in January for a primary that they don't even know who's going to be on the ballot. So if there's a time limit of 30 days, your daughters can very easily, when they're at school, go online and download an absentee ballot application. They don't have to walk down to the town clerk's office to get it before leaving school.
Through you. And that's great, but not everybody has the access to the printers and on and on. So I know that in our community, a lot of the students do go down before, prior to leaving for college. So I would be concerned with limiting times to 30 days or even 60 days because students go back prior to November and prior to those kinds of dates.
I have two nephews and a niece who are all in college, and everyone has access to a printer. You don't have to even have one in your room. You could go to the library, you could go, or your parents can do it for you. There's so many ways that people can access getting an absentee ballot application. And I think frankly, that's an excuse to have such a long period of time because getting one online, if your children can go online to register, to research something or do their homework or what have you, they can go online to print out an application.
Thank you, Representative. Are there other questions or comments from members of the committee? Jamim, I do have a few questions for you, if that's
Sure.
okay. You talked a little bit about the experience that your organization has seen of voters in Bridgeport. And I wonder if you could speak to that a little bit more, help us create a fuller picture of what is happening on the ground and what the kinds of approaches that voters are faced with in Bridgeport. And if you could also, if you don't mind in your response, connect that to some of the provisions in this bill, the provisions that you support and how it might impact that kind of behavior in the future.
Mm-hmm. Well, in Bridgeport, what happens during an election cycle, there's a, for lack of a better word, like a frenzy, right? And campaigns, they swarm into elderly, like senior citizen, like apartment buildings. They swarm into places where, into neighborhoods where there's mostly Spanish speaking people, and they bring stacks. They have stacks of absentee ballots and they say, sign up, or they say, what can I help you with? There's a lot of manipulation there. There's a lot of, we've heard stories of people who are on do rentals rebate, and people are being manipulated saying that if you don't sign up this way, then your renter's rebate may be in jeopardy. We've had stories of people in senior buildings who are hungry and needed groceries, and people coming to their door saying, I'll get you groceries. We've heard stories of someone saying that they would buy, someone a mattress. And so there's lots of people just swarming into these places where there's vulnerable populations, and they are manipulating them into using an absentee ballot. And we also know that people are filling out these absentee ballot applications without the consent of the voter. And that has created in Bridgeport really a culture of corruption around our elections, where there's so many absentee ballot applications out there. There's pages upon pages on reports that come out every single week. And people have dehumanized voters. And so it's not even about convincing or voters to vote for me because I'm with you on this issue, this issue, this issue. Campaigns are just focused on how many ABs they can get. So people are really being dehumanized. And the will of the people who actually show up to the polls is being defrauded. right? Because people will overwhelmingly go to the polls and vote for, let's say, candidate A, but candidate B will win on ABs, and and it's been a pattern for a really long time. So what we know also is that the administration of our elections are rife with irregularities. So in 2019, the Connecticut Post did an investigative story and found that there were a lot of administrative errors. And so this combination of administrative errors along with the abuse, manipulation, and fraud have really left Bridgeport like just regular folks disenfranchised, and people no longer trust our elections. That is just where we are in Bridgeport. It's very sad, but people don't believe in our democracy, and they are resigned to not voting because it doesn't matter. And it's very hard for organizations like mine and other organizations that are committed to our democracy to convince people otherwise when they see that there is no accountability. So these bills, in particular, the board that would be formed, can do a lot to help Bridgeport, regular Bridgeport people have trust in our election cycle, in our elections, because we don't trust anyone. You know, it's so sad. It's really sad, but people don't trust the town clerk. They don't trust the registrar. They think everything is rigged. And when things like 2019 and 2023 happen, what are we going to tell them? So these bills are moving in the right direction, but I really do have to stress that this access to absentee ballot applications is just not enough, and it actually does nothing for Bridgeport. And believe me, they will be out there getting 100 and 200 and 300 absentee ballot applications, 5 at a time. They'll send like 20 people in and they'll do 5 at a time for 30 days, and they'll get them, and that's the way they'll do them. And you know, some of the people whose names were associated with 2023 have said online and in person, I'll do it again. Just recently at the Democratic Town Committee meeting, a woman stood up and said, I do the work and I'll do it again.
Thank you. Thank you for that. And it's my understanding that some of these practices, while the disenfranchisement that many voters in Bridgeport seem to feel as you're expressing, that some of these practices have gone back for as long as 4 decades. Is that accurate?
Yes.
Okay. And in recent years, it's come to light more and more. And I was interested earlier when you talked about how in the past, what would happen is that these ballots would have a stamp put on them, and these applications would have a stamp put on them by the political operatives and just dropped in the mailbox. That's what you said, correct?
Correct.
And so, and mailboxes don't have cameras on them,
Correct.
unlike these drop boxes.
Correct.
And so this is certainly a moment of reckoning because the ballot boxes existed and because there was that video footage that was retained. You also spoke earlier in the questioning with my colleagues on the committee about increased access to absentee ballots and how that would improve the process. Can you just talk about that a little bit more?
Yeah. So in Connecticut, we have a lot of restrictive rules around who can use absentee ballots. And it sets people up really to break the law. You know, some people unwittingly, you know, because they don't know what the rules are. And so they are only going by what someone comes to their door and like tells them. And that needs to change. I really do believe that no excuse absentee voting, I want mail-in voting, but no excuse absentee voting should be the way that we move forward. It's one piece, it's not the be-all, end-all, but it's one piece that would help protect voters from manipulation, and it will also give them equal access to the ballot. I understand that, I like to go in and vote. Like my mother would take me to the polls with her and I would go. So I like to walk in and vote, but I have the privilege to do that because I have a job that will allow me to do that. But a few years ago, I was commuting back and forth to New York City and I was working in retail and I was working a lot of long hours. And sometimes I would leave my house at 6 in the morning and I wouldn't get home until 11:30 at night. And so in a case like that where people have a job or an illness or something like that that prevents them from going to the polls, we need to just let people vote how they need to without having to fill out an application and swear that you're not going to be in town or what have you. Those things are barriers to voting. And so I think we really need to just open it up, take the political operatives out, and let everyone participate in the way that works best for them.
Thank you. Thank you for your time and your testimony today.
You're welcome. Thank you.
Next, we will hear from Michelle Jacklin, who will be followed by Aisha Clark, who will be followed by Catherine Saris. Welcome, Michelle. The floor is yours.
Thank you. Good afternoon, Senator Flexer, Representative Blumenthal, Ranking Members Sampson and Mastro Francesco, and honorable members of the GAE Committee. My name is Michelle Jacklin, and I am Legislative Co-Chair of the Connecticut Council on Freedom of Information. I've submitted written testimony on two bills, SB 436 and HB 5498. I am not going to have time this afternoon to discuss 5498, but I would ask you to read my written testimony, particularly with reference to Section 9, subsection 2, which deals with voter registration files, because CCFOI believes that some of the language is vague and could be easily clarified. So today I would like to address my testimony primarily to SB 436. Advocates of government transparency and the public's right to know have testified several times in recent years about the absurdity and futility of efforts to shield the residential addresses of public employees, whether they be federal, state, or local. Just last week, I testified on HB 5447 and HB 5448, stating that the bills continued the unceasing assault on the Freedom of Information Act. I noted that the bills created a false sense of security and were nothing more than window dressing. As CCFOI has testified over the years, the addresses of virtually all state residents are readily available on the internet. This bill, SB 436, as with the others, does nothing to afford public employees privacy or protect them from identity theft. Cyber attacks have become routine. Last Wednesday, I noted that I had been the victim of data breaches 3 times in the past year, 2 of them involving major healthcare systems. Ironically, on that same day, when I opened the mail, I received a letter from TIAA-CREF, the financial institution that handles retirement accounts for those employed in Connecticut's public institutions of higher learning. My husband had 3 tours of duty with public universities in this state, 2 with UConn and 1 with Central Connecticut State University. This letter from TIAA, dated March 7th, said that a, quote, cybersecurity incident had occurred on November 2nd, 3 months prior, at one of TIAA's administrative support services providers. An unauthorized party gained access to certain data. The letter goes on to say, and I quote, "The types of data that could be impacted varies by individual and could include some of the following: name, social security number, date of birth," I'll be finished in a minute, "life insurance policy number, annuity contract number, financial account number, and medical information that you may have provided to TIAA. As a result of this cybersecurity incident, tens of thousands of current and former state employees and their family members may be affected. And yet you think by hiding the residential addresses of these same employees, you are somehow protecting them, when in fact you are doing nothing more than larding the FOIA with yet another unnecessary exemption. I
I'm
will
sorry.
conclude by saying, in this age of the internet, the horse is out of the barn and the barn door has closed shut. This bill will do nothing to put the horse back in the barn, and it will do nothing to protect public employees. Thank you.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Seeing none, thank you for your time and your testimony.
Thank you.
Next, we will hear from Aisha Clark, who will be followed by Catherine Saris, who will be followed by Samuel Rodebush. Aisha, welcome. The floor is yours.
Thank you so much. Dear Chair, Senator Flexer, Representative Blumenthal, Vice Chair Senator Slapp, Representative Morin-Bello, Ranking Member Senator Sampson, Representative Mastro Francesco, and esteemed members of the Government Administration and Elections Committee. Thank you for accepting this testimony in support of SB 433, an act of implementation of the Commission on Racial Equity and Public Health. On behalf of Health Equity Solutions, a nonprofit organization with a statewide focus on advancing health equity through anti-racist policies and practices. Also, I am the co-chair of the Commission of Racial Equity and Public Health. We respectfully urge the Government Administration and Elections Committee to support SB 433, an act implementing the recommendations of the Commission on Racial Equity and Public Health in its entirety. In Connecticut, our state government agencies play a critical role in setting the tone for diversity, equity, and inclusion within our society. Each of the 9 recommendations would ensure that our state follows precedents already being implemented by all federal government agencies in states such as Oregon. Specifically, the passage would ensure that our state agencies are supported in developing and implementing policies and initiatives aimed at eliminating discrimination and promoting equity within their organizational structures. This includes addressing disparities in hiring, promotion, access to services, and ensuring that policies and practices are inclusive and accessible to all. Many communities in our state and are continuously marginalized and disproportionately impacted by systemic inequities and discrimination. All of the recommendations encompassed within SB 433 would support work to identify and address these underlying issues by implementing a federal loop from employees to DEI divisions to inform policy and programming priorities and develop targeted strategies to promote equity and opportunities for all. We acknowledge that in many cases, state agencies are already required by law or regulation to promote diversity, equity, and inclusion in their operations and services. However, the establishment of DEI divisions will help ensure that practices are streamlined in the compliance with these legal and ethical standards and reducing the risk of litigation, sanctions, and harm. It is important to note that the proposed recommendations were crafted after thorough research and intentional collaboration by a task force. For example, in its inception in 2021, the Commission has consulted with state agencies, studied nationwide resources and strategies, and spoken and taught with thought leaders to explore what is being done within Connecticut and around the country to infuse equity within state infrastructures. Many agencies and institutions reviewed our following a landscape analysis of the innovative ideas that should be implemented across the state's government agencies. It was also without reservation that HES believes that the passage of SB 433 would help build trust and confidence among citizens, employees, and community stakeholders, leading for greater engagement, collaboration, and support for government initiatives. Thank you for the opportunity to testify in support of SB 433 and act of implementation of the Commission on Racial Equity and Public Health. The passage of this bill will help cement practices and principles of equity at all levels by fostering diversity, equity, and inclusion within government institutions so that we can build a stronger, more effective, and more equitable communities for all Connecticut residents. Thank you so much.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you.
Next, we will hear from Catherine Saris, who will be followed by Dr. Samuel Rodebush, who will be followed by Sally Fink. Welcome, Catherine. The floor is yours.
Thank you. Sorry. Haven't talked for however many hours. Honorable members and ranking members of the Administration and Elections Committee, thank you very much for hearing my testimony in opposition of SJ4. My name is Catherine Saris, and I am a full-time performing artist and educator. In the performing arts community, there is a large percentage of persons who identify as LGBTQI or A, and I myself, for many years, addressed myself as I identified as an A in that acronym. As a teenager and a preteen, I would likely have chosen to accept puberty-blocking drugs because I had an intense shame and confusion surrounding the issues of growing up and becoming a woman, and this included suicidal ideation, etc. These feelings of shame had their inception during my early childhood when I was frequently traumatized by unwanted sexually aggressive acts by other children in my neighborhood and social circles. Most of these attacks were from boys. This spawned within me a hatred and a fear of boys and of men. And my fear caused me not to want to be a woman. I didn't want to be a man because I despised them, but I also didn't want to be a woman. However, during my teen and young adult years, I was so fortunate to be able to get help and experience healing of my self-hatred and self-rejection. And as a result of those different people that took time to talk to me, to counsel me, to help me, I am grateful to be standing here today, so happy as a strong, confident, and independent woman who knows who I was created to be and who I am. However, my story is not the typical story, unfortunately. And especially because I work in the performing arts and I spend so much time with children as I teach, I know that this is true. I had a supportive yet uncompromising community that helped me to recognize how I was created and enabled me to eventually trade self-shame for self-worth. But many young children and people today are told that if they experience shame or confusion over their gender or their sexuality, that they can just change it. However, as the United Kingdom has just announced, puberty blockers and trans drugs are still, quote, too experimental to be legal and accessible, particularly to minors. I'm so grateful that my story is not one of the many tragic ones that I have heard so frequently from my coworkers, colleagues, bosses, and others. Children who were given access to puberty-blocking drugs that are now young adults and wish they could go back in time and change, like Oli London or Isabella Ayala, who have now been in the news. Many young women likely are never able to bear children because during their formative years, they took puberty blockers and endured surgeries that they experienced. I see this bill, SJ4, as unfortunately such a terrible way of taking away the distinctions between men and women and blocking for us this idea that we have, and I'm sorry, I'm summarizing now the end here. I really echo the words of the wonderful woman who testified earlier regarding women's sports. You cannot redefine sex under the law without marginalizing and mutilating women. Thank you.
Thank you. Thank you for your time and your testimony. Are there comments or questions from members of the committee? Representative Mastro Francesco.
Thank you. Thank you very much for coming in. Your story is very moving. I certainly sympathize with you. In the beginning, you talked about LGBTQ. I'm not sure the rest of
I or A.
A. Can you tell me what A is?
It can stand for a number of things. In my case, it was asexual, but it can also stand for androgynous.
Okay, thank you. So, and this part of the bill that we're talking about, the Constitution, enshrining it into our Constitution, does affect, obviously, a lot of people. And the transition that some people go to from male to female and so forth at a very young age is very concerning. That's why this part of the language, we're having a lot of discussion today on it, as maybe some people don't think it is relevant. It clearly, obviously is. So you were able to get help at a very young age. How old were you, through you, Mr. Chairman, when this happened?
Which part?
The part where you said you didn't want to be a boy, you didn't want to feel like you were a woman. You didn't want it to be you didn't want to be either of those. At what point in your life did that happen?
Mostly, I would say probably between the ages of 9 and 15 or 16 years old.
Wow, it's a long time. And you were able to get help and speak with someone, maybe go through some therapy and just kind of figure it out where you are, where do you stand, what does your body, what does your mind say that you are?
Yes, and I'm really grateful because in my family and in my church community and in the counselor that I spoke to, who was a wonderful woman, the theme that was constant was that you are created as special and unique and individual, and the way that you're created is not a mistake. And I think that's really important for people to realize that the way that we're created is not a mistake. And by offering gender affirming care, it doesn't actually affirm who they are. It affirms this self-hatred.
Yeah, I see, and actually read a lot of, we all go through phases in our life. When you're young, you're very vulnerable.
Yes.
You think you're everything, right? You think you know more than your parents. We go through a lot, and at some point in our life, we realize, and we don't ever want to look back and regret any mistakes that we have made. So I think your testimony is very, very, very moving, and I appreciate you coming in today. Thank you.
Thank you, Representative. Are there other questions or comments from members of the committee? Senator Sampson.
Thank you, Madam Chairman. Catherine, thank you for being here today. I enjoyed your testimony also, and I apologize that I was not in the room for the first couple of minutes. I was running an errand very quickly. I certainly appreciate, I read your written testimony also, and you cover a lot of different parts of this bill. But just to follow up on Representative Mastrofrancesco's questions, I guess what I'm driving at is you only had a couple of minutes to summarize. So is it your thought that the concern of this bill is that maybe it would further drive confused young people into making a decision they may regret, where in a lot of cases, I think people given time and the opportunity to work it out themselves, find help, etc., they might have a perfectly fine result otherwise.
That is very, very accurate, what I'm trying to say, because I hear so many stories, or I have friends who, their mother pulled them into the bathroom when they were 5 years old, cut off their hair and told them, "I wish you were a boy." Well, if they're offered puberty blockers and transitioning, surgeries, then they're going to take them because they want to please that parent who unfortunately did that to them. Or you have so many cases where people, how many of us didn't have trouble in middle school? The world is turning upside down. Your body is changing. Nobody knows what's right or wrong. And if you're told, "Oh, it's fine, you can just change who you are," then we're unfortunately exposing ourselves to really having a lot of regrets. And we see these stories in the news now of people who are detransitioning, and they're, especially the women, are unable to reverse these effects in many cases. Recently in the news was Isabella Ayala, or otherwise known as, I think, Gemini, and she can't probably ever have a child. And it's just heartbreaking to see this sort of thing going on, where there's so much money being made in this industry that is trying so hard to make women, I think in particular, but also boys, unsatisfied with who they are. And so they put social media pictures out there to try to make them feel inferior, and then they profit off of that. And unfortunately, it's quite a business.
Right. And I know exactly what we're talking about. And you also see more and more news stories about people describing very young children in very sexual terms about their gender identity. And I'm like, when you're 4 or 5 years old, I don't know that you have a really deep understanding of what the difference between men and women is. So that surprises me. And we have people testifying even on our agenda today that I think are going through the detransitioning process. So I know that's definitely a factor. I've heard from a number of constituents that are in that circumstance, and those folks, they don't want to come forward in a lot of cases. And I completely understand that as well. Was there any other part of the bill outside of the gender transitioning discussion that you wanted to draw additional attention to?
Yeah, absolutely. I'm strongly pro-life, and the reason that I'm pro-life is because I believe that life begins at conception, and that, you know, if any woman who's pregnant, you go through, first off, being a woman, you get to be pregnant. That's not something that anybody can do who's not a woman. That's one of our special things that we can do. And so that's really amazing and beautiful and powerful. But then when you remember that any woman who goes through the issue of being pregnant, having a child, they know it's a living human being inside of them. I mean, this is the most pro-life generation, this next generation that's coming up. And I believe there's going to be a time when we are going to look back at the horror of abortion the same way that we look back at slavery. We're going to realize how inhumane and horrible it was, and we're going to be ashamed of ourselves.
Yeah, thank you very much for that. I appreciate those words very much. Final question. I know that there are some folks that are in favor of this legislation, and you know, when I've talked to them, I try and, you know, press for what's really behind it. And I think there's a lot of things there. I think there is certainly when it comes to the gender identity part of the bill, I think it's about affirmation. I think that if they want to find acceptance, they want other people to be encouraged towards acceptance. And I think that's leads to this feeling that somehow people that don't support this legislation are somehow bigoted towards these groups. And I don't get that from you. And
No,
I'd love to hear what you have to say about that too, because that's my frustration. You know, when I deal with advocates for this type of legislation, and I say, no, I mean, I'm not in favor of compelled speech about pronouns and things like that. You were entitled to live your life as you choose. But that doesn't mean that I have to be part of your fantasy or your alternate version of reality. And maybe that's not the most polite way to put it, but that's kind of how I feel. But what's your reaction to that feeling that somehow if you don't support this, you're somehow intolerant of other people?
Well, I think unfortunately there is the reality that a lot of people are intolerant of other people. And there's a period of time when I was living in Kansas City and I would walk down the street and see signs that said, you know, if you're a fag, go to hell or whatever. And that was really difficult for me because that was never the way that I approached this question and this issue. And all of my friends in the LGBTQIA community will tell you that I love them so dearly and I would give my life for any one of them at any moment. And so, you know, if you, I have so many of them because that's who my friends are. That's who my world is. But I think the difficulty is that many of these people are really suffering, unfortunately. And no one seems to be spending the money and the time that we are. We're talking about all this, like trying to respect them and trying to make the world a more equal place. And I'm all for that. But what about mental health care? What about, especially for young people who are going through these massive transitions and changes and questions in who they are and why they're here? Why aren't we helping them navigate that instead of just shoving a bunch of drugs in their faces and telling them that they can just be whatever they want to be? And most people that are dealing with a question that pushes them towards LGBTQI or A, it's oftentimes because of traumatic childhood experiences. They won't realize that or recognize that, but once I start to just talk, I can't even tell you the stories I've heard.
If I can just interrupt for one moment, I appreciate what you're attempting to say, but if we could just try to refrain from using certain words that can be really offensive to people and maybe aren't words that you would use.
I'm sorry.
It's okay.
What did I say?
There was a word that started with the letter F. If you could try to
Yes,
refrain
I'm
from
sorry.
using that word.
That was my horror at
Thank
seeing
you.
that on a sign.
Thank you.
I just want to clarify for the record that I am horrified by that word.
I appreciate that. Thank you. Thank you, Senator. Thank you. Seeing no further questions. Oh, Representative Mastro Francesco for the second time.
Thank you, Madam Chair. I apologize. If I can't for a moment, you had mentioned the abortion issue, that you were very much pro-life. And when I read this language here in this bill to change our constitution, it does talk about initiating, continuing, or terminating a pregnancy. And we talked a little bit about today how language is very vague and it's not really detailed. I keep going back to this today. In your mind, I know that it is in my mind, should this amendment pass at some point, would that allow an abortion up to birth on demand?
It seems to allow it even past that possibly.
So there's nothing in here that tells you that it doesn't or it does, correct?
And there's
It's
also
just-
nothing in here that says, pardon me for interrupting. There's also nothing in here that says that there's an age limit, you know, so if I'm 12 or 15 and I somehow get pregnant or am raped or whatever, there's nothing that I can do. I can just go, you know, it's like so problematic. Children are not given, we don't give kids the right to vote until they're 18. We don't give them a driver's license until they're 16 or 17. Why in the world would we give them the choice? It boggles my mind.
Yeah. I agree, but what's really concerning is here, and just the question, that the language itself, it is saying that you can terminate a pregnancy on demand up to birth. And I think it's important that people know that. And thank you for mentioning that. I appreciate it. Thank you, Madam Chair. I have no more questions. Thank you.
Thank you for your time and your testimony.
Thank you.
Next, we will hear from Dr. Samuel T. Rodebush, who will be followed by Sally Fink, who will be followed by Stefan Danzig. Dr. Rodebush? Are you here? I don't see you online. Okay, we're going to move on to Sally Fink, who will be followed by Stefan Danzig, who will be followed by Mark Bernacki.
All right, can everyone hear me?
Yes, Sally, the floor is yours.
Okay, good afternoon. I am here in opposition to Senate or the SJ4. I will say that while each person is created in the unchanging image of God, our culture says that that image is changeable, and that following a largely social contagion of taking cross-sex hormones and risky surgeries will somehow solve ongoing mental anguish. The broad language in this amendment implies that anyone trying to warn against permanent damage is arbitrarily discriminating against that person. I'll say that we have a lot of positive rights instead of negative rights. So we're indulging a lot of things that are based on feelings at the expense of reason. 3 points that I'll make about this particular amendment. The first is that it actually helps a population implosion. Connecticut has a lower birth rate than the national average. And when you factor in things like unrestricted abortion and young adults who are just allowed to mutilate their bodies, it's not going to encourage replacement population. The second point is, while that it seeks to prevent sex discrimination, proposals like this, I think, have very broad language and will conflate discrimination with mere disagreement or careful discernment, or even a simple refusal to normalize every behavior. And the third point is that I don't think related healthcare is going to include, as others have mentioned, young adults who may regret their gender surgeries, or women who are injured by biological men on their sports teams. And I will see if I can wrap up here. I think the people who drafted this are not thinking about the long-term consequences. I think this amendment will further shrink our workforce, ignore injured people, and readily permit life-threatening harm. So please oppose this dangerous amendment, and thank you for your time.
Thank you for your testimony. Questions from the committee? Seeing none, we appreciate you being with us this afternoon.
Thank you.
Next up is Stefan Danzig, followed by Mark Bernacki, followed by Aaron Everett.
Greetings, members of the Government Administration and Elections Committee. Thank you for the time today. My name is Stefan Danzig with Preservation Connecticut. We are the statewide nonprofit historic preservation organization, originally called Connecticut Trust for Historic Preservation, established by a special act of the Connecticut General Assembly in 1975. We preserve, protect, and promote the buildings, sites, and landscapes that contribute to the heritage and vitality of Connecticut's municipalities. I'm here before you to clarify written testimony that I'd submitted in support of SB 442, an act concerning the designation of Mount Decatur as a historic site. While we do support the designation of Mount Decatur as a historic site, we are opposed to the methods that are outlined in this bill. The nomination process to the National Register of Historic Places has federal regulation that is conducted through the State Historic Preservation Office. And nomination of any property to the National Register requires owner consent to the nomination. While it is fantastic that the state is interested in the recognition of such a significant site of history, Preservation Connecticut urges the procedure to be followed for the preservation of this site. That's all I have to say. So thank you very much.
Thank you for your testimony. Are there any questions from the committee? Seeing none, appreciate you being here.
Have a great day.
You too. Next up is Mark Bernacki, followed by Aaron Everett, followed by Patty Spruance.
Good afternoon, Chairman Blumenthal and distinguished members of the committee. My name is Mark Bernacki. I'm the New Britain Town and City Clerk and also the legislative co-chair of the Town Clerks Association Legislative and Elections Committee. I'm here to speak on House Bill 5498. You have my written testimony. Believe me, I cannot get through 48 pages in 3 minutes, so I'll try to do my best that I can. To begin with, it really broke my heart to hear some of the testimony today from the representative from Bridgeport, because it's the town clerks, registrar of voters, and our election officials that are basically the defenders of our elections. And we hope that a lot of the items that are in this bill will better the process to make sure that we run the most efficient, accurate, transparent, and bring integrity to all of our elections, whether they're in Bridgeport or the other 168 towns. In regard to Section 1, we support the section with changes within the Dropbox. Currently, the legislation proposes for 30 days. Just know that drop boxes don't open always at 30 days. It's 30 days during a general election, but primaries are under a different schedule. So if you can make it conform to when we open up the drop boxes, that would be a better adjustment for you. Section 2, we support the integrity of tracking the source of it. Unfortunately, we're working with the older CVRS system that does not allow us to track by Dropbox, but supposedly the new system is going to be able to put that in. We are strongly opposed to us having to either hand stamp or hand write on these returned envelopes, which would significantly slow down the process if we're already scanning them into the system that would identify it by Dropbox. So we're looking for you to strike that particular language. Section 3, we support the fact that we only give additional ballot applications to the voter. In my town, I could probably count on two hands how many times I've issued an additional ballot in 10 years that I've been in the office. We basically just give it to the electors, but obviously in other towns that doesn't happen. So we strongly support that. In Section 5, just know that town clerks are pack rats. We keep all of the forms to try to save money. Just know there'll be a tremendous bonfire if we have to burn or dispose of all of the absentee ballot applications because we have to put a particular year on it, but we support whatever documents you folks are going to give us or the Secretary of State's going to give us. So we support that. In Section 6, there was a lot of discussion with the prior speakers about either 90 days or 60 days in terms of when people can be given the absentee ballot application. That hard number is in addition to the 30 days that we have in, say, the general election. So it'd be 30 days for the general election before we can do that, plus the 60 or the 90 days. And if you look at this election cycle, we have town committee election rapidly followed by the presidential preference and then the August primary and then the November election. So we're looking to make sure that we can bring that tighter in. So if you pick 60 days, it's 60 days. I won't wrap up other to say you can read our testimony and I'll entertain any questions. Thank you.
Thank you very much, sir. I'm looking at your testimony now. We'll definitely be digging through it and talking to you all about it. Any questions from the committee? Let me just check the Zoom. Seeing none, we appreciate you being here today and your comments on the bill. I'm sure we'll be in touch to talk with you further about it.
Thank you. And hopefully, unfortunately, I'm not the last speaker, but best wishes.
Thank you.
tonight.
Far from the last. But at least your time with us for you is over. Next up is Aaron Everett, followed by Patty Spruance, followed by David George.
Dear committee members, I am a former trans kid. I started identifying as a boy in first grade after a brutal sexual assault. If I had known about puberty blockers and cross-sex hormones, I have no doubt I would have done everything I could to obtain them, including threatening suicide. In the short term, I might have felt better. Testosterone is a controlled substance. Like other steroids, it would have boosted my confidence and increased my energy but in the short term. However, in the long term, it would have reinforced the mistaken belief I had that caused me to develop gender dysphoria in the first place, that it was too dangerous to be a girl. It would have profoundly damaged my body and my long-term mental health. Leaked documents from the World Professional Association on Transgender Health reveal how dangerous and experimental medically transitioning children is. It's a horrible disservice to encourage vulnerable children to run away from their feelings and take drugs that will permanently damage their bodies. It is natural for children to do what they can to shut down difficult feelings, which is why we work hard to stop children from using drugs and alcohol. We know that encouraging children to run away from their pain and struggles is not the solution, even if that makes them feel better in the short term. It is our job as adults to give children the message that no matter how intense and how difficult their feelings are, they can work through them without dissociating from themselves to become a different person. Even though I was insistent, consistent, and persistent about being a boy, I wasn't a boy. It only takes one story like mine to show that children can develop gender dysphoria as a coping mechanism. We are still suffering from the consequences of the opioid epidemic, where doctors were told by pharmaceutical companies that treating pain was dangerous and addictive opioids was safe and effective. How many thousands of people died because doctors were following guidelines for pain management written by those who were profiting from the sale of opioids? How many people have wrestled with serious addiction after well-meaning doctors prescribed medications that they were told were safe and effective, only to find out later they were misled by pharmaceutical companies willing to put dollars ahead of human lives? Children struggling with confusion about their identity should never be told that they are inherently flawed. Instead, they need love and support as they grapple with their difficult feelings. Please vote no on SJ4. Thank you very much for your time.
Thank you. Are there any questions from the committee? Seeing none, we appreciate you being with us. Next up is Patty Spruance, followed by David George, followed by RJ Priest.
Good afternoon, Senator Flexer, Representative Blumenthal, Senator Sampson, and Representative Master Francesco, and members of the GAE committee. My name is Patty Spruance, and I'm the president of the Connecticut Town Clerk Association, as well as the town clerk for the town of Wyndham. I'm here to comment on HB 5494, which institutes standards for proposed charter and home rule ordinance amendments and establishes criteria for simplistic and concise ballot questions. Currently, Connecticut General Statute 7-191 addresses the process and timelines for charters, charter amendments, and home rule ordinance amendments. This House bill reduces the percentage of qualified signatures on a petition currently set in state statute from 10% to 1%. Public Act 81-451 reduced the percentage of electors necessary to force a referendum from 15% to 10%. As currently stated in our statutes, the petition is filed for the town clerk, and the town clerk qualifies and certifies the petition signatures and notifies the appointing authority. Sections 1 and 2 of this proposed bill outlines that the petition be presented to the Registrar of Voters and requires that the Registrar of Voters have not later than 5 days to validate the petition. Our association requests sections 1 and 2 be amended to reflect those petitions be presented to town clerks for verification rather than the Registrar of Voters. Multiple Registrar of Voters offices are only open for business a minimal number of hours per week and may make the 5-day filing requirement difficult. The town clerk is already deeply involved with many other statutory requirements regarding charter, home rule ordinance amendments, and ballot questions, and is familiar and well-versed in qualifying and in certifying petitions. The CTCA believes the continuity of presenting, qualifying, certifying, and filing of the petitions with the town clerk would make for a more efficient process. While the CTCA supports the spirit of the bill, we would like to support this bill with a suggested change that was brought forth. I thank you for giving me the opportunity to speak on behalf of the CTCA, and I'll entertain any questions.
Thank you very much for being with us. Any questions from the committee? Seeing none, we appreciate you being with us and look forward to consulting you further on this legislation.
Thank you.
Next up is David George, followed by RJ Priest, followed by Lisa Brinton.
Thank you for having me here today. I'm a historic preservation professional and owner of Heritage Consultants, a firm specializing in cultural resources management. I appreciate this opportunity to submit testimony on Senate Bill 442. Over the last 30 years, I've been engaged in projects that identify and assess the historical significance of buildings, archaeological sites, structures, districts, and objects that comprise Connecticut's cultural heritage. During the last 2 years, Heritage Consultants has spent considerable time researching and evaluating the archaeological deposits and above-ground features on Mount Decatur as they relate to the War of 1812 and Commodore Stephen Decatur. Our work has included historical research, archaeological excavations, and consultation with the State Historic Preservation Office, also known as the SHPO. All of these efforts have been undertaken with the goal of determining the significance of the property, applying the National Register criteria for evaluation, as well as assessing the integrity and spatial extent of the site. Our ongoing efforts have revealed that Fort Decatur, which is located on the summit of Mount Decatur, constitutes a significant property that is eligible for listing on the National Register. This statement of eligibility has been confirmed by SHPO, and all parties agree that Fort Decatur is a significant historical asset. The proposed statute does not contribute to this statement of fact, but imposes a directive that is in conflict with federal procedures, and which creates an unfunded mandate requiring the preparation of a nomination to the National Register. The National Register program was established through the National Historic Preservation Act and is implemented through the procedures outlined in the Code of Federal Regulations, Title 36, Part 800, Section 60. Senate Bill number 442 is not consistent with these procedures. According to the federal procedures, nominations to the National Register of privately owned properties are completed under the supervision of the SHPO, not the State Review Board. I defer to the SHPO to describe the details of their internal process, but federal procedures described in 36 CFR 60.6 Parts B and C require the state to notify the property owner in writing of the state's intent to nominate a property, and the owner of a property must be provided with, quote, an opportunity to concur in or object to the listing, unquote. The statute as written bypasses this very important step in the federal process. In addition, the proposed statute confers a duty on the State Review Board, a volunteer organization with no operating budget. The review board is required by federal legislation, and the responsibility is limited to reviewing National Register nominations. They do not prepare National Register nominations as requested in the proposed statute. If the bill passes, it will place an unfunded burden on a volunteer state board. In summary, Senate Bill number 442 is neither consistent with existing federal law, nor is a funded mandate. For these reasons, I submit opposition to it. Thank you for your time and consideration.
Thank you very much. Are there any questions from the committee? Seeing none, we appreciate you being with us and sharing your testimony. Next up is RJ Priest, followed by Lisa Brinton, followed by Christina Mitchell.
Hello. Am I on?
You are. We can hear you.
Okay,
loud and clear. You
I
can
can't see me.
whenever you're ready.
Thanks. Hello, my name is RJ Priest. I grew up in Central Connecticut. I'm a gay man and I'm an independent policy consultant. I've been asked to testify by LGBTS United, partly based in Connecticut. I am deeply alarmed by current developments affecting likely gay and autistic kids. I oppose Senate Joint Resolution 4. I also call on the Connecticut House and Senate to initiate an independent investigation into the trans medical market, its range of support services and actions as it affects the state. Many parallels to the previous opioid scandal we see are all in front of us, but add a new powerful ideology. Point one, aren't you familiar with the International Trans Queer Legal Advisory? I'll refer to it. It's best to embed important legal steps into wider laws. Okay, so here, box ticked. Also, keep it quiet and out of the media and move as quickly as possible. Okay, double ticked. A copy of their legal advisory is attached to my written testimony. Tell us, from where are these proposed changes in Connecticut law coming from exactly, and how is this enabled? As Connecticut is overly Dem with very weak opposition media, the state is known as well a soft touch. Other elements with documentation in my written testimony include 2, one estimated cost of puberty blockers is $38,000 per patient per year. If 50,000 kids in America are on them, that's $1.9 billion per year alone. 3, many European countries are rolling back transmedical back. Last week, the National Health Service in England announced a ban on puberty blockers out of medical concerns, reported internationally. Shockingly, even formerly trusted mainstream media reported the story as well, even into regional left media channels, but not in Hearst Papers and the Hartford Courant, of course. 4, 2 weeks ago, the WPATH scandal began with shocking leaked documentation. Lawyers and AGs have been alerted. This was reported internationally, some mainstream media and some regional left media, but not in soft touch Connecticut. WPATH members are operating in the state. What does membership mean? How about orgs referring to their so-called standards of care? This discredited org is even listed as a resource on the CT government website. Visitors are one click away learning about the new eunuch gender. Have eunuchs been surgically created in Connecticut yet? More scandals are already slated to crash into mainstream media finally to alert more parents and patients about this horror show. It's time to investigate. It's time to vote for decency, not the radical trans activists, not the spin doctors, and not those profiting off vulnerable kids. My friends and I were just like them.
Thank you, sir, for your testimony. Any questions from the committee? Seeing none, we thank you for your time and your testimony.
Thank you.
Next up is Lisa Brinton, followed by Christina Mitchell, followed by Jeff Cleghorn. Ms. Brinton, I'm sorry, you're muted. You're still muted.
There we go.
You're unmuted. Good job.
Sorry about that.
Whenever you're ready.
Thank you, Mr. Chairman, for the opportunity to address the committee. How do you try to save your party in 3 minutes over Zoom with a severe head cold and a sty in your eye? But I will try, and I'm grateful for the opportunity. My name is Lisa Brinton, and I am the Norwalk Town Chair of the Independent Party. I speak in strong opposition to the discriminatory and anti-democratic proposal in Section 27 in House Bill 5498 to bar our party from using the word independent. I support the initiatives directed at restoring election confidence, but of all the reforms proposed to protect democracy, who knew the term independent was the greatest threat? The term independent has meaning to the average voter. One Webster definition aptly reflects these partisan times, defining independent as not affiliated with a larger controlling unit. But how ironic that Democrats and Republicans might destroy a minor party in Connecticut just as we strengthen our name recognition. Political junkies will recall during Jefferson's era that the Republican Party was once called the Democratic Republican Party before splitting in two. How would our founding fathers view the two parties now legislating the elimination of a third? With over 100 ballot lines across the state, we resurrected the independent line in Norwalk in 2021, formed a town committee, and ran 24 candidates. We have 2 elected officials and more on local boards. As a municipal and statewide party, we run our own candidates and cross-endorse reform-minded Democrat and Republican candidates. We advocate for something currently lost with the two-party system, moderation in an increasingly polarized world. Norwalk's history with the independent has been around for a while. Our first female mayor, Jenny Cave, was elected as an independent in 1975. Folklore has it that the best governance Norwalk ever had was when we had 5 Democrats, 5 Republicans, and 5 independents on our city council in the 80s and the 90s. Arguing the term independent is confusing with regard to voter registration is disingenuous. It can easily be remedied by adding the term party to Democrat, Republican, and Independent, as well as the term unaffiliated voter to the registration rolls. Currently, the registration form says Democratic or Republican or other. The rest of us are just others. As mentioned earlier by my colleague John Merton, California's legislature tried to do what you're proposing to do in the name of voter confusion. And in 2019, Governor Newsom vetoed it, saying he couldn't sign a bill that impacted only one group. Minor state parties across the US use the term independent without issue. The two major parties might wrongly identify the independent party as a threat because of unrest in some of your own membership, but the real threat is removing choice from the ballot, leaving voters more disaffected. Recently, we supported reform-minded Democrats in Bridgeport with our ballot line, and Mr. Gomes received 40% of the vote. Stanford's Democrat mayoral candidate Simmons sought the independent party in 21 and benefited from our additional line. Republican candidates in Norwalk and across the state benefit from the votes on our line, and killing a recognized name and making a start all over is punitive. It's the wrong message at the wrong time and likely unconstitutional, violating freedom of speech and freedom of assembly under the First Amendment. I argue a clerical fix to the voter registration form is more appropriate than legislating a third party, the third largest party out of existence. I strongly urge you to remove clause 27 from this bill, and I thank you very much.
Thank you for your testimony and for playing through pain today. I had one question. You've kind of answered it already. And the question was, I'm sure you heard earlier, or maybe you did, maybe you didn't, but the secretary indicated that the rationale behind this provision was that people were being confused and accidentally signing up for a party when they meant to be unaffiliated. And it sounds like, based on your testimony, while you certainly agree with the provision that's currently in the bill that would eliminate your use of the name independent, you would be amenable to an alternative measure that would reduce confusion, like changing the form or something like that.
Absolutely. Absolutely. I've discussed this in Norwalk with our own register of voters, because we as an independent party are out there trying to convince unaffiliates to come and become independents and have a role in a voice on the ballot, in the ballot box. But I think this is a clerical error and a clerical thing that could be fixed, rather than basically eliminating a party that's been around for 20 years, at least statewide, in the form that we're in right now. But in terms of Norwalk's history, we go back to 1975. So I think it's kind of a sledgehammer for what is a confusing situation. But I would like to know how many instances that's happened. Without data, again, it just seems like a sledgehammer for a clerical form change. So I was appreciative that the Secretary of State seemed to be amenable to that, and I appreciate you bringing that up as an option.
Great. Well, thank you for your testimony, for being with us today.
Thank you very much.
Next up, we have Christina Mitchell, followed by Jeff Claghorn, followed by Colleen Murphy.
Chairpersons and members of the committee, my name is Christy Mitchell, and I'm here to speak in opposition to SJ4. As the mother of 3 female athletes, my testimony today will focus on how this amendment would move Connecticut in the wrong direction on the issue of allowing boys to compete in girls' sports. In 2017, my middle daughter, Chelsea, had to compete against a male in the finals of the 100-meter dash at the Connecticut State Open. For her entire high school career, 2 male athletes were allowed to dominate girls' track. Chelsea raced against them dozens of times and faced them in nearly every state and regional championship race. Over and over again, she lost podium spots, awards, media recognition, and eventually she lost 4 state championship titles. During those years, 2 males were allowed to take home 15 girls' state championships and wipe away 17 girls' meet records. Hundreds of girls in Connecticut were denied fair competition and advancement opportunities by the unelected officials at the CIAC, who recklessly ignored biological reality in order to affirm the identity beliefs of boys. Back then, I spoke with several people in our state government, and many of them agreed it was a problem, but it was always someone else's problem to fix. Nobody has stepped up to make it right. The CIAC policy remains outdated and discriminatory, and the girls in Connecticut continue to be harmed. Just a few weeks ago, we watched another male athlete take the top girl's spot on the podium at the New England Championship in high jump. News reports explained how the family moved from Georgia, a state that does not allow males to compete in the female category, to Connecticut, where we welcome males in our girls' sports. It's hard to believe that my youngest daughter must also compete against a male athlete in her best event, but that's exactly what's happened. It's been 4 years now since my middle daughter, Chelsea, along with 3 other girls, filed the first federal lawsuit in the nation to protect female athletes. She wanted to fix it for the girls who were coming up behind her, including her younger sister. It is a disgrace that despite her best efforts, it's happening again. How many girls' championships, how many records, how many spots in finals, how many opportunities will be lost before someone with the power to fix this will step up and say enough? 24 states have passed laws to protect their female athletes. Others do so with regulations. Many governing bodies of sport have reversed their testosterone suppression policies and are moving back towards a protected category. Those with integrity can no longer ignore the scientific studies that very clearly show that the male sports advantage exists from the youngest ages and cannot be undone with surgeries and drugs. It's time for our state to change course too. Connecticut added gender identity to the anti-discrimination statutes back in 2011. This resulted in a CIAC policy that said sex doesn't matter in sports, only one's beliefs about identity. This caused a great deal of harm. Don't make the same mistake again. Abandon this plan to redefine sex in the law and focus instead on passing legislation that ensures women and girls in Connecticut will have a protected female category in sports going forward. Thank you.
Thank you. Any questions from the committee? Seeing none, appreciate you being with us for your testimony.
Thank you.
Next up is Jeff Cleghorn, followed by Colleen Murphy, followed by Walter Nagel. Jeff Cleghorn with us? Not seeing him. Colleen Murphy?
Yes, good evening, Senator Flexer, Representative Blumenthal, and members of the GAE Committee. I'm Colleen Murphy, the Executive Director of the FOI Commission. Thanks for the opportunity to testify very briefly on 3 bills. We've submitted written testimony in much more detail. I'll start with Raised Bill 431, and that bill is a bill that the FOIC staff has worked closely with the Connecticut Police Chiefs Association to find a fair, balanced, and reasonable approach to charging fees when a police department makes redactions to body and dash cam videos based upon exemptions that are in the law. The bill's proponents have incorporated many recommendations to narrow the scope of the fees, including a fee cap. The commission urges one clarification regarding the fees to be charged to involved persons, as 2 sections of the proposal appear to conflict. The commission advocates for the approach in lines 295 to 296 that says that no fees will be charged to an involved person. And last, the commission has some concerns over the addition of exemptions to disclosure that are in the bill and weren't part of what we had originally negotiated with the Police Chiefs Association. We'd ask that you take a look at that and at least attempt to narrow those. Next is Raised Bill 436, and that bill I essentially testified on last week when you had House Bill 5447 and 5448 regarding address exemptions, and we had a robust discussion about that, so I won't revisit that, but again, we submitted testimony on that front. And the last bill is Raised Bill 5498, an act concerning election security and transparency. And with regard to that, the commission just objects to section 9A2 only of the proposal as written for the same reasons it objected to language in a similar bill back in 2020, which was Senate Bill 234. The bill restricts who can obtain access to voter registration information and for what purposes. The section lacks a definition for prohibited commercial use or harassment and raises some constitutional issues because it restricts how and to whom the public information can be disseminated. Also, the proposal lists but doesn't define the uses that are permitted, namely election-related, scholarly, journalistic, political, or governmental purposes. We'd ask you to look at potentially defining those. Finally, the determination regarding all those uses and whether someone is entitled to voter information is left to the discretion of a single elected individual, which opens it up to potential abuse. For these reasons, the commission asks you to reject or to narrow section 9A2 of Raised Bill 5498. And I thank you. That concludes my testimony.
Thank you. Any questions from the committee? Seeing none, appreciate you being with us.
Okay, thank you.
Next up is Walter Nagel, followed by Ashley Aguilera, followed by Denelli Rhodes.
Dear members of of the committee, my name is Reverend Walter Nagel, and so thank you for the opportunity to speak today. I'm speaking to express my opposition to SJ4. I'm writing as a priest, as the director of pro-life activities for the Diocese of Norwich. I'm also speaking as a concerned citizen who's alarmed by what I see in this amendment, a grave threat to human dignity. Under the pretext of claiming to prevent discrimination, the amendment as it is currently written would exclude unborn children. Life is beautiful and must be cherished, nurtured, and protected at every stage of development, from the moment of conception to natural death. Ending discrimination is a good thing. Now, we've heard today about giving people a voice and disenfranchisement. But writing into the state constitution laws that deliberately exclude other human beings is not. The purpose of the state government is to serve the common good. This amendment does not, it affects the religious liberty of those in the state who value the dignity of human life. There is no conscience protection for those who would be forced by law to perform abortions. What we have here is a crisis of truth. In the name of tolerance, the most vulnerable, the unborn, do not have a voice. And I sit here today to give a voice to the voiceless. Thank you again. I've been sitting here all day. It's been a very impressive process. So thank you.
Thank you for your testimony. Any questions for the committee? Seeing none, we appreciate you sticking it out and being with us today.
Yes, thank you.
Next up is Ashley Aguilera, followed by Denelli Rhodes, followed by Nicole Perot.
Hello, Co-Chair Senator Flexer, Representative Blumenthal, Ranking Members Senator Sampson, Representative Master Francesco, and all the distinguished members of the GAE Committee. My name is Ashley Aguilera, and I'm a proud Bridgeporter. I'm passionate about election integrity, and it's one of the main pillars of our democracy. I'm also a member of Bridgeport Generation Now. We're a local grassroots organization fighting to strengthen and increase civic engagement and education so we can end the systemic corruption that plagues our city. I'm testifying in strong support of Senate Bill 441 and House Bill 5498 with some very critical changes to these bills. Living in a democratic state means that our elections are a reflection of the will of the people. However, living in the largest city in Connecticut, it's become increasingly clear that most, if not all of them, are won through absentee ballot fraud, abuse, manipulation from political actors. This is an unfortunate fact that this history precedes even my existence in this world, dating back over 4 decades. In the wake of our 3rd and 4th election in Bridgeport, so many people my age felt voter fatigue. In talking with friends and family, many felt frustrated this is what our democracy has come to in Connecticut's largest city. Can you imagine a number of voters in their 20s feeling disenfranchised and defrauded due to the systemic corruption of absentee ballot abuse? It sadly discourages them from participating in our local elections ever again. Absentee ballot abuse is very real, and so long as we uphold this culture due to a technicality in the law, the same issue will persist, the same court cases will begin, and the same news headlines that highlight Bridgeport's voter manipulation will be highlighted. Like I said before, this issue is older than I am, and I don't want to have to vote a 3rd or 4th time because political operatives are able to do what they want due to a technicality in the law. This issue and these bills must be a top priority for the state legislature, as it affects voters and our elected officials' integrity to hold public office. I'll also be bold to add that a handful of your colleagues benefit from this absentee ballot abuse and manipulation by being elected by using this process. SB 441 and HB 5498 are a step in the right direction, but they don't address the main issue in Bridgeport, which is that political operatives have full access to absentee ballot applications. There's no reason why campaigns need to be able to walk into the town clerk and walk out circulating them throughout town, whether it's using 5 applications at a time or during the 90 days before an election. The legislature must make absentee voting a process that is strictly between voters and election officials. All Connecticut voters deserve a chance to cast their votes free from political harassment, targeting, manipulation, and fraud. This is especially true for voters who are most vulnerable to this abuse: our elderly, disabled, low-income, and monolingual Spanish-speaking voters. No one, especially political operatives, should come between us and our ability to cast our votes. I will thank you when action is taken on this issue. Have a happy Monday.
Thank you for your testimony. Any questions from the committee? Seeing none, we appreciate you being with us today. Next up, Donnelly Rhodes, and I hope I pronounced that correctly now 3 times. If not, please correct me, followed by Nicole Perot, followed by Gregory Doyle.
That is not the correct pronunciation. It's fine. I'm used to that. I'm not sensitive to it. My name is Donnell Rhodes. Donnell.
I'm
yeah.
sorry about that.
That's okay. It's fine. My sisters called me Nellie and my brothers called me Danny because my name is just too confusing for everyone. So it's fine. I'll answer anything. Anyway, well, hello and thank you. And you know more about me than I was prepared to disclose today. Notes to my siblings. But anyhow, I'm with the Foundation Against Intolerance and Racism, and we're a civil rights organization. We have multiple chapters across the country, and I'm the Connecticut chapter leader. And we'd like to propose some amendments to to Senate Joint Resolution number 4. We oppose it in its current form, but specifically, I think if you make these changes, everyone in the room would be very happy. So we'll see about that. Anyway, this amendment creates a right to access related healthcare. And we're concerned that unless specifically excluded, this will be interpreted by courts to include gender-affirming care, hormone therapy, and surgery for minors over the objection of parents. The Supreme Court's recognized, of course, that the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the duty, to recognize and prepare him for future obligations. So what we're proposing is an amendment that reflects the Supreme Court's interpretation of due process rights that include the sanctity of parental rights. We call for the inclusion of explicit recognition of those parental rights. The next one is it's critical to ensure people are not exposed to experimental health care without informed consent. Informed consent includes disclosure of material information, disclosure of alternate models of care, and assessment of capacity to consent. Minors lack the capacity to consent to life-altering decisions, and that is why specifically they have the protection of parents. We propose replacing related healthcare services on line 15 with evidence-based medicine with informed consent. We agree that gender identity should be protected. We also acknowledge that all rights have limitations. Gender identity is protected as a subset of sex, but is not the same as sex or on par with sex. To treat sex and gender identity as the same or on par creates a conflict with sex-based rights, very specifically. We must be careful not to ignore or violate the rights of women, which I believe this will do unless we change it. Women's rights are sex-based rights and must be respected, obviously. The broad language in this amendment expanding the inclusion of sex and gender identity in the same category is of great concern. Sex is a stable category, while gender identity is an expression. They should not be treated as the same category. To avoid confusion and conflation of categories, and by extension, those rights afforded to those categories, we call for an amendment that explicitly clarifies the difference between sex and gender identity or expression. Thank you for consideration on these vital amendments today.
Thank you very much.
Sure.
Any questions from the committee? Seeing none, appreciate you being with us. Next up is Nicole Perot, followed by Gregory Doyle, followed by Alex Knopp.
Good afternoon. Thank you for having me. You pronounced my name right, which was amazing. So way to go.
My name is Nicole Perot, and I oppose Senate Joint Resolution number 4. Thank you for this opportunity to speak. Growing up in Connecticut, all I ever heard was that abortion is a simple way to end a pregnancy and that it is every woman's right. So when I became pregnant at 15, I immediately decided to have an abortion. I firmly believed that I was just removing a bit of tissue and afterward my life would return to normal. But instead, I experienced post-abortion depression, anxiety, panic attacks, and other symptoms of PTSD, as well as emptiness and grief. Only I didn't understand what was happening because as far as I knew, abortion solved problems. It didn't create them. When I became pregnant again at 18, I was excited to finally have a baby to fill that unexplained void. But powerful people in my life began to pressure and coerce me into having an abortion I didn't want. When I told the Planned Parenthood staff member that I didn't want the abortion, that I couldn't handle another one, she just shrugged and said, "That's normal." And then she proceeded to pressure me to abort as well. Feeling desperate and alone, I put my hand on my belly and apologized to my baby over and over. "I'm so sorry I'm not strong enough. I'm so sorry I'm not brave enough." And 32 years ago, this month to be exact, I aborted my second child. Those 2 abortions nearly crushed me. But the director of a local pro-life pregnancy center taught me to heal. Every week for years, Debbie met with me completely free of charge. She helped me receive the love and mercy of God so that I could learn to live again. Today, I am part of the international organization Deeper Still, where we help men and women receive healing from the trauma of abortion, because abortion is trauma, and abortions in the 2nd and 3rd trimester are among the most traumatic experiences a woman will endure. Why don't you hear from more of us, you wonder? In part because we are silenced and shamed by abortion advocates who insist we don't exist or that we are a tiny minority. But that is simply not true. A recent study by the Charlotte Lozier Institute showed that 70% of abortions are coerced, unwanted, or inconsistent with the woman's preferences. Is it really about choice if women believe they have no other choice? You may support abortion because you believe it helps women, but abortion harms women. You may believe that abortion frees women, their communities, and even the state from the burden of so-called unwanted children. But the opposite is true. When struggling mothers are offered abortion instead of the support they need to raise their children, they bear the burden of the people and communities who have failed them. And that burden is the physical, emotional, and spiritual trauma of abortion. That burden is the weight of an empty grave. This proposed amendment will undoubtedly—
Excuse me, ma'am, I'm sorry to interrupt, but
I'm almost done. This proposed amendment will
Please summarize the
undoubtedly
text.
increase the pressure society puts on vulnerable women to abort their children if they conceive in anything less than ideal circumstances. Women deserve better than abortion.
Thank you. Any questions from the committee?
I would also say that people who sit here all day and wait to testify deserve better than people talking and laughing while we're talking. Thank you very much.
All right, well, there are 100 people set to testify, and they only get to testify if everyone is respectful of the rules, especially around demonstrations and around speaking only when recognized. Thank you for your testimony. And next up, we will have Gregory Doyle, followed by Alex Knott, followed by Susan Zabahansky. I do not see Gregory Doyle. So Alex, go ahead whenever you're ready.
Thank you, Senator Flexer, Representative Blumenthal. Before I make a few remarks on HJ Res 230, let me thank you for giving a favorable JS on Friday to the bill that would ban foreign donations to ballot referenda in Connecticut. I'm here today to testify in support of HJ Res 230 to avoid the unintended consequence of convening a national constitutional convention that might amend the United States Constitution and threaten all of our constitutional rights and civil liberties. Let me say, when I was co-chair of this committee, I had no idea that Connecticut had passed two resolutions in the 1940s and 1950s calling for an Article 5 constitutional convention. So I salute the historical research that went into producing HJ Res 230, which cites those two prior ancient resolutions. And because they are ancient resolutions, I think it's the reason why I urge you to adopt HJ Res 230, because those resolutions no longer reflect the concerns of people in Connecticut about constitutional reform or about good governance. As I say in my written testimony, these two antique resolutions from the 40s and 50s have languished, buried in our state's legislative history like unexploded bombs from the 1940s and 1950s. But now that you have unearthed them, they ought to be dismantled by the General Assembly by approving HJ Res 230 to prevent unintended explosive damage to our national Constitution. I also want to praise and urge you to regard closely the testimony earlier today of Professor David Suber at Georgetown University, who has submitted very scholarly remarks about the Article 5 convention issue. I had the privilege to know him when we were both visiting adjuncts at Yale Law School, and I would urge you to give his testimony close reading. Thank you very much. I appreciate your attention and urge you again to adopt HJ Res 230. I noticed that earlier today, Minority Leader Candelora, for other reasons, also supported adopting the resolution, and therefore it will have a very positive bipartisan message and support. So thank you very much. I appreciate your attention.
Thank you. Any questions from the committee? Seeing none, we appreciate you being with us again.
Thank you.
Next up is Susan Zabahansky, followed by Amy Spallino, followed by Jane Endy.
Hi, members of the committee. There have been so many people in front of me who have done a superb job in speaking in opposition of SJ4. And I am here today to also join my voices with them. Under the resolution, biological boys or men would be permitted to share locker rooms with biological girls or women, defy interscholastic athletics, the policies, and participate in girls' organized team sports. This resolution is designed to push, in my opinion, a progressive agenda, political agenda, by adding multiple identity markers to create further division. This is not how the equal protection provision was designed, and therefore I stand in strong opposition of it. I also stand in opposition of SB 433, the commission, on racial equity in public health. Again, we're trying to speak about equity. We're often speaking about equity in our current proposed legislation, yet SJ4 kind of takes away equity from women. You're creating inequities when you have women having to have biological men in their spaces, and forcing that upon them. As many others have said, I'm in opposition to both of these bills, and we'll just end it at that.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, we appreciate you being with us today.
Thank you.
Next up is Jane Endy. I'm sorry if I mispronounced your name. Followed by Brian Geddix, followed by Patricia Smith. Is Jane with us? Let's see. Looks like no. Is Brian Geddix with us? Whenever you're ready, you can begin.
the constitutional amendment proposed in Senate Joint Resolution number 4. First, the reservation. It appears that the object of SR number 4 is to essentially codify the central holding of the U.S. Supreme Court's Bostock decision as part of the Connecticut Constitution's Equal Rights Amendment, redefining the word sex to include sexual orientation and gender identity and expression, and expanding it to include access to abortion on the basis of gender equality or gender justice. Yet the state already has very robust and deeply ensconced legal protections in place for LGBTQ plus persons, gender affirming care, as well as reproductive rights, marriage equality, and other related rights, making this proposed constitutional amendment wholly unnecessary. In May 2022, Connecticut was rated among the top 5 states with the most legislation that protects trans youth by the Transgender Law Center. In the wake of the U.S. Supreme Court's 2023 decision in 303 Creative versus Alanis, Attorney General Tong offered a press release reaffirming that Connecticut's strong anti-discrimination laws continue to protect LGBTQ plus rights in Connecticut, indicating that Connecticut's anti-discrimination laws protecting LGBTQ plus persons are untouched by this decision. The Connecticut law has protected protected abortion access since 1990. Just last year, Governor Lamont signed a series of new laws further building upon and expanding reproductive rights in Connecticut. There is no indication that these rights and other related rights are at risk in Connecticut or that current law in Connecticut is ineffective. In fact, Connecticut is already recognized as a national leader on these and other related issues. Simply put, this amendment is not necessary for the protection of the rights it claims to protect, as those rights are already long established and protected in law in Connecticut. Amending our state constitution is an extraordinary action. Changing the state constitution is not easy. It's not meant to be easy. More important, it is not always necessary, and it has not been made clear why it is necessary to take this extraordinary step in Connecticut at this time, which brings me to the concern, which is a grave one. Although SR number 4 is not necessary to secure a series of rights that are already long established in Connecticut, which have been further reinforced in recent legislation, the proposed amendment would have the collateral, foreseeable, unconstitutional effect of basically eliminating any future opposition on any of these issues in civil society, perhaps even any discussion of alternative viewpoints, including those from long-established faith traditions. In other words, this legislation presents as an effort by some legislators to suppress the free speech and free exercise rights of Connecticut residents on these matters. My concern is the same concern raised by Connecticut political commentator Chris Powell in his March 9th column. The real rationale for the legislation is to stamp out contrary consciences and religious beliefs. Just to sum up, because it is unnecessary to secure the already long established and well-ensconced legal rights it purports to protect, and because of its foreseeable and probable chilling effect upon the free exercise rights of, if not outright active discrimination against Connecticut persons of faith and their institutions based upon their sincerely held religious beliefs, I strongly urge you to vote no on Senate Joint Resolution number 4. Thank you.
Thank you very much, sir. Any questions from the committee? Seeing none, appreciate you being with us today. Next up, Patricia Smith, followed by Michael Van Blenderen, followed by Melissa Mannion. Patricia, I see you on the Zoom, and you can begin whenever you're ready.
Great, thank you so much. Madam Chair, Mr. Chair, and members of the committee, my name is Patricia Smith, and I live in Storrs, Connecticut. I am testifying in support of SB 435. Specifically the section regarding the Connecticut Entity Transaction Act, or CETA. Before proceeding with my testimony, I just want to note that the CETA language in SB 435 was developed by the business law section of the Connecticut Bar Association, and this morning the attorney who drafted the language emailed us a correction. 34608A subsection 12, nonprofit or not-for-profit corporations, that section should be struck. I'm the general manager of the Willimantic Food Co-op. The co-op is a consumer-owned grocery store in downtown Willimantic. We employ 40 people and do over $7 million in sales annually. We've operated as a cooperative serving the people of Willimantic and the surrounding area for 45 years, but we are incorporated as a non-stock corporation rather than as a cooperative corporation. This discrepancy between our business model and our corporate status prevents us from fully realizing our cooperative identity and creating the full scope of benefits for members in our community that a true cooperative, that is one incorporated as such under state law, could do. In 2019, with the support of Senators Austin and Flexer and Representative Johnson, Connecticut's Cooperative Statute, Chapter 595, was updated to make it more feasible and friendly for cooperatives to incorporate here in the state. With the support of our legislators, Willimantic Food Co-op, Fiddleheads Food Co-op in New London, and others worked hard to make this happen so that the cooperative model could become more visible and available to those wanting to start businesses in Connecticut. However, the Connecticut Entity Transaction Act is currently preventing our co-op from reincorporating as a cooperative here in Connecticut. Our next best option, if we want to legally become a cooperative, is to incorporate in another state. However, we would much rather be a Connecticut cooperative. The language in SB 435 would remove the statutory barrier to our reincorporation and allow us and other co-ops in the state to avail ourselves of Chapter 595. The cooperative model is one that centers people and generates profit, contributing tax revenue, high-quality employment, and necessary goods and services to our communities. I urge you to support this bill so that we can continue to build strong communities in Connecticut by growing more cooperative businesses. Thank you for your time.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, appreciate you being with us. Next up is Michael Van Vlenderen, followed by Melissa Mannion, followed by Thomas Barrel.
You didn't even hesitate on the name. Well done. My name is Michael Van Vlenderen. I'm here to speak in support of Senate Bill 432, an act concerning state contracts with nonprofit human service providers. I think I've been here just about all day except for a couple of breaks, and I think I might be the first one to speak on this bill. Specifically, I want to draw attention to Section 1B that states the Secretary of the Office of Policy and Management shall, in consultation with representatives of nonprofit human services providers, complete a review of the state purchase of service contracts with nonprofit human services providers to determine whether the rates such providers are paid to deliver health and human services pursuant to such contracts adequately compensate such providers for providing the level of services expected by the state agency contracting with such provider. And I can tell you that is not the case. Nonprofits throughout the state of Connecticut are not adequately compensated. Starting in 2007 through 2017, nonprofits have been flat funded, which means we've all lost ground to cost of living and the CPI. The Consumer Price Index has gone up 45% since that time, whereas nonprofits across the state, which means about 115,000 of our residents and your voters, have seen a decline in their ability to pay for needs of their homes, their automobiles, their taxes, sending their kids to school, anything that goes with living a life here in Connecticut. To me, the section is a little broad in terms of who gets to determine what is adequately funded, but I can tell you as of right now, it is not the case by any standard. Many of my colleagues have had the opportunity to speak this year and in years past before the Appropriations Committee and Health and Human Service Committee. So it's always nice to come before new faces and discuss the plight of nonprofit agencies. I think this bill is a good start. Like I say, some of the language could be given a little bit more teeth, but anything that sheds light on the plight of the nonprofits, which have been going on in our state since 2007, is a step in the right direction. So, excuse me, I'm happy to answer any questions. Before I do that, I should point out that I work for Reliance Health Inc. in Norwich, and we have about 250 staff serving about 1,500 members. Our primary funding is through Department of Mental Health and Addiction Services and DDS. And we have seen some headway in the last couple of years, but it doesn't even begin to address how far the hole has been dug. So.
Thank you very much for your testimony.
Yeah.
So let me just check the Zoom. Are there any questions from the committee? Oh, yes. Madam.
Thank you, Mr. Chair. Good evening. Thank you for your testimony. I just wondered if you could share any specific examples from either Reliance Health or other organizations you're familiar with. I've certainly heard of them in Eastern Connecticut myself, of the impact of when an organization is promised a certain amount of state money and then it's slow to come in.
Yeah, though that's another part of the bill, isn't it? The timeliness. We've been awarded through appropriations sort of increases in contracts over the last 2 years, and it's been 6 months or more before we've seen those increases. We at our agency, we have been able to grow through new funding opportunities that are slated to start, for instance, the state fiscal year of July 1, and we're expected to start on July 1. And sometimes we don't even see the startup costs until well into the fall. And we're on statewide meetings asking how we're doing and providing services for services we haven't even been funded for yet. Now, we do it in good faith. But I can tell you there have been years, and 2017 was one where we were asked to actually cut services, where we were asked to potentially cut 10% off of our entire budget. And we were asked systematically over a period of months to lop off 2.5% at a clip. And we would have to submit what we were going to do to the legislature or to the department heads. And after 2 cycles of that, where we cut 5% of our budget, then the state was allowed to level its funding. But that speaks to the point of there are mechanisms in place that if money needs to be clawed back, it can be clawed back. So there shouldn't be any issue with properly funding nonprofits, because tying things to out years, which I know sometimes can be a concern if you're a legislature, there is a mechanism in place to take the money back if you want to.
Thank you. Thank you for that. And thank you again for your testimony.
Yeah,
thank you,
thank
Mr.
you.
Chair.
Thank you very much for your testimony today. Are there further questions from the committee? Seeing none, we
Thank you.
appreciate you sticking around. Next up, Melissa Mannion, followed by Thomas Barrell, followed by Renell Swaggerty. Sorry, I interrupt. If you could just make sure that your microphone is turned on, there should be a button at the base right there. Great. And just make sure you say your name towards the beginning of your testimony.
Yep. Chairman, Chairwoman, and members of the committee. My name is Melissa Mannion. I'm a mother of 4 and a resident of Enfield, Connecticut. I thank you for the opportunity to testify against SJ4. The first sentence of the proposition states, "No person shall be denied the equal protection of the law, nor be subjected to segregation or discrimination in the exercise, employment of his or her civil or political rights because of religion, race, color, ancestry, national origin, sex, or physical or mental disability." It is very interesting to me how the last sentence reads, "including preventing, initiating, continuing, or terminating a pregnancy." I ask you, who is this proposed amendment to our Constitution here to protect? It is most surely not trying to protect the person in the womb. It is also not trying to protect the young girls who have worked hard their entire adolescence to secure scholarships and placement on sports teams and universities in order to secure for themselves a solid future. It is also not here to protect the young children barely out of elementary school from being exposed to things of explicit sexual nature by means of school assignments asking what their sexual preferences are.
The state of Connecticut has chosen time and time again to pride itself on the destruction of the nuclear family, something of which I never got to experience, but I advocate strongly for. As far as I and many other conservative residents feel, as adults, you may choose whomever you want to be and whomever you want to love. I am not trying to stop any adult from engaging in any consensual acts with another consenting adult. It is the non-consenting persons I am deeply concerned for. The baby, the female athlete, and the young vulnerable children of our state. This proposed amendment is devious and deceptive. It is absolutely targeting minors, women, and the persons in the womb. No one is being fooled. We live in a state where abortion is celebrated and paid for by taxpayers, even for undocumented citizens. Our state allows minors to receive abortions without any notification from their parents. Meanwhile, I had to be present and consent to my 16-year-old getting a tattoo. Our state holds highly the title of an abortion sanctuary state, taking those considered less fortunate whose states do not allow the killing of their most innocent. I'm not sure who anyone thinks they're fooling. This bill is meant to enshrine abortion into our state constitution, and I truly cannot understand the obsession that some Connecticut lawmakers have with codifying the right to kill our most innocent. How can you sleep with this blood on your hands? We have one of the highest abortion rates in the country. We boast about abortion up until birth for almost any reason. That is the goal here, and that is disgusting. You claim this is about human rights, human dignity, and respect. Yet all the while, instead of fostering programs and progress for the women of our state, you want to tell them that men can be women and killing their babies is what's best. May God have mercy on us for these atrocities.
Thank you for your testimony. Any questions from the committee? Seeing none, we appreciate you being here today. Next up is Thomas Barrell, followed by Ronell Swaggerty, followed by Richard Legg.
Okay, GAE Committee Chair and GA Committee. My name is Tom Barrell. I'm here from the Institute of Connecticut History, and I'm here to oppose the spirit of SJ4. And as a man of God and a man of faith, I'm here to make God the issue. For many generations in Connecticut, an artificially induced abortion and the mutilation of minors was unheard of and unthinkable. When Connecticut State Representative Noah Webster wrote the first American dictionary in 1828, he defined the word abortion as the miscarrying of a fetus before it is perfectly formed. There was no mention of a medical procedure. It did not exist. The Connecticut colony was created in the 17th century by courageous and intelligent men and women of faith. The historical record proves they believed the only way to live was to put God first, as prescribed in the sacred scriptures. The fundamental orders, Connecticut's original constitution, declared in its preamble that the purpose of government is to, quote, maintain and preserve the liberty and the purity of the gospel of our Lord Jesus, which we now profess, unquote. Throughout the 19th and 20th centuries, there developed a slow and sinister force that put God second, then third, then dead last. In the second half of the 20th century, the God of the Bible was aborted from government, education, and the public square. How could this have happened? There is an eternal maxim that does not allow for a spiritual vacuum. If God is put away, that void must be filled with an opposite reality. We have sown the wind, and now we have reaped a whirlwind of spiritual insanity. This could only happen in a culture where God has been aborted from the hearts and minds of its occupants. The sin of abortion is rooted in a much deeper and tenacious sin to which the unsearching mind is blinded. This sin is putting something other than God first in our life. How often does that sin have to be practiced in a society to create a culture where the physical sin of abortion is accepted as a positive good by its government? SJ4 represents the ultimate rejection and destruction of God in Connecticut. If this resolution becomes part of our Constitution, the spiritual consequences to our state will be dreadful. Your responsibility for it will follow you beyond the grave. You will be held responsible in God's court. It is a fearful thing to fall into the hands of the living God. In that day, you will cry out, "Why didn't somebody tell me? Why didn't somebody warn me?" In the gospel of our Lord Jesus, which we yet profess, it is written, "It is better to have a millstone tied about your neck and cast yourself into the sea rather than to hurt God's innocence." Consider yourself warned.
Thank you for your testimony. Any questions from the committee? Seeing none, we appreciate your testimony. Next up is Renelle Swaggerty, followed by Richard Legg, followed by Lisa Otto.
Can you all hear me?
Yes, we can.
Awesome. Hello, co-chairs, ranking members, and all distinguished members of the Government Administration and Elections Committee. My name is Ronelle Swaggerty, and I'm a Bridgeport resident. I am testifying this evening in support of SB 441 and HB 5498 with changes because I care passionately about an individual's right to vote with integrity, and I care that our vote has fidelity. Voters should have confidence that our elections are a reflection of the will of the people. Yet that is not the case in Bridgeport, the state's largest city, which is now internationally known for absentee ballot fraud, abuse, and manipulation. Sadly, this abuse of Bridgeport voters is not new. It goes back decades. I am also a member of the Greater Bridgeport Ed Gomes Black Democratic Club, a political action committee that advocates for the Black community by identifying, electing, and holding accountable candidates who will ensure justice, equity, and parity for the greater good. Sadly, this work is compromised by systemic corruption in Bridgeport's elections, particularly in the area of absentee ballot abuse. Thus, I am testifying in support of SB 441 and HB 5498, which are a step in the right direction, but fall short because they don't address Bridgeport's abuse of absentee ballot applications by political operatives. They have become expert at collecting countless stacks of absentee ballot applications by targeting the elderly, disabled, low income, and Spanish speakers, and then using the absentee ballots to steal elections. This has disenfranchised all voters and suppressed voter turnout in Bridgeport. Voter apathy in Bridgeport is palpable. I strongly recommend that the legislature make absentee voting a process that is strictly between voters and election officials. Campaigns can educate voters on how to vote as an absentee, but they don't need to be able to circulate and fill out the application for them. This is a common sense reform that is done in other states, including Massachusetts. All Connecticut voters deserve to cast a vote, whether in person or through the absentee ballot process, free from political harassment, targeting, manipulation, and fraud. This is especially true for our voters who are most vulnerable to abuse, the elderly, disabled, low-income, and Spanish-speaking voters. Removing the ability for partisan actors to sign out hundreds of applications will give all voters confidence that our votes are between us and elected officials. No one, especially politically motivated actors, should come between us and our ability to cast our votes. Thank you for hearing me out on my support of SB 441 and HB 5498 with the noted changes.
Thank you for your time and your testimony. Are there any questions from the committee? Seeing none. Oh, sorry. Co-chair.
Thank you, Mr. Chair. Just very briefly, thank you for your testimony. I just wanted to ask Renelle, just about your organization. I see that it appears that it's named in honor of my former colleague, Senator Ed Gomes, God rest his soul. And I just wondered when your organization took on that name in his honor.
So this is 2024, 2022, I want to say, not long after his death, 21 or 22. I'm horrible with dates. That's probably the worst question you could ask me, but right after his death, not long after his death.
Okay, well, we remember him very fondly here, and as I'm
Yes.
sure thousands of people in Bridgeport do as well. So how nice that
Indeed.
your club took on his name and in his honor. So thank you very much. Thank you, Mr. Chair.
Thank you.
Thank you, Madam Chair. Further questions from the committee? Seeing none, we thank you for your testimony and being with us this evening.
You're welcome.
Next up is Richard Legg, followed by Lisa Otto, followed by Vicky Harrison. We have Richard Legg. See you on the Zoom. If you could unmute and turn on your video whenever you're ready, you can begin your testimony. Okay, Richard Legg doesn't appear to, oh, there we go.
Can you hear me?
We can. If you can turn on your video if possible, that would be terrific. And then you can begin your testimony. Perfect. Go ahead.
Video on?
Yes, it is. Looking good.
Thank you. Mr. Chairman, members of the G&A Committee, my name is Richard Legg. I live in Ansonia, Connecticut. I've been a volunteer for the Convention of States since 2017, and I'm currently serving as the Coalition's Director for Connecticut. First, I'd like to say that I have no issue with the state deciding to archive the old Article 5 applications. I do find it interesting that two other states, New Jersey and New York, have received similar correspondence from the same source with the same arguments. There are several suppositions in the document supporting this action by the legislature that are questionable. The reason and the arguments used were published a few years ago by the John Birch Society and are well known and answered multiple times. For the record, the Convention of States has sponsored proposals in all states with varying results. 19 states have passed the resolution, a 20th is pending, and it is currently in play in 8 others. The New England states have not been very receptive. However, recently Massachusetts passed a crucial committee vote and the resolution is moving to the House floor. Under Article 5, the Congress has a single ministerial function, set a date and a location. Then they get to sit back and watch. I disagree with the contention that Article 5 is a grave threat to the Constitution. Rather, the resulting amendments after ratification by the 38 states will enable the Constitution to reflect needed corrections to sustain the USA. The discussion of a runaway convention is a false flag. The noted constitutional expert, Robert Nadelson, wrote The Law of Article 5, which is right here. And in the book, he codifies all law relating to the Article 5 convention. A runaway is not feasible or possible. Finally, the example that they gave in the letter of the 1787 convention, creation of the new articles against the mandate, is false. Their mandate was to do whatever is necessary to fix the demonstrably inadequate Articles of Confederation, which had failed miserably. Proposed Article 5 amendments need 34 states to agree and then send them and get 38 states to ratify. In conclusion, the Article 5 process is a time-consuming, difficult one, but with a purpose. It won't happen quickly, but it will happen. Thank you for your attention.
Thank you for your testimony. Are there any questions from the committee? Seeing none, we appreciate you being with us this evening.
Thank you.
Next up is Lisa Otto, followed by Vicky Harrison, followed by Peter Spinella. Ms. Otto, I see you on the Zoom. Whenever you are ready, you can begin.
Thank you.
Good evening, Mr. Chair, Madam Chair, and members of the committee. Thank you for the opportunity to testify in support of SB 432, an act concerning state contracts with nonprofit human service providers, specifically the component regarding OPM evaluating the adequacy of nonprofit compensation. My name is Lisa Otto, and I serve as the CEO of Child and Family Agency of Southeastern Connecticut. Child and Family Agency employs 260 staff to provide behavioral health, medical, and supportive services to over 10,000 children, families, and adults in New London, Middlesex, and Windham counties each year. We contract with the Department of Children and Families, Department of Public Health, Office of Early Childhood, and State Department of Education. While we appreciate that our partnership with these state agencies allows us to provide much-needed services to the residents of Eastern Connecticut, we struggle with the increasingly inadequate funding of our legacy contracts. For example, our outpatient psychiatric clinics for children in Groton, New London, Pawcatuck, and Westbrook have seen a staggering 56% increase in expenses since FY14. These increases, primarily driven by rising salaries, fringe benefits, and health insurance costs, have far outpaced the 11% increase in grant and fee revenue we have seen during the same period. Our clinics are enhanced care clinics, which serve as a crucial safety net for Medicaid-insured children. We receive an enhanced reimbursement rate in exchange for a guarantee of immediate access to outpatient mental health care. We see the life-changing impact of immediate access to care for youth in crisis, but also experience the financial bind this status creates. Although the funding is increasingly inadequate, we cannot reduce staffing or capacity without violating our ECC status. As a result, we're facing an anticipated deficit of $875,000 for those 4 clinics this year alone. To mitigate this shortfall, we've been forced to consider drastic measures, including selling off assets or closing this program, which served 1,195 children last year. Additionally, our Intimate Partner Violence Assessment, Intervention, and Response Program, which serves vulnerable DCF-involved families experiencing domestic violence in their homes, continuously operates at full capacity and has to turn away families. This program was forced to reduce staffing and capacity several months ago due to inadequate funding. Another aspect of the impact of increasingly inadequate funding is our growing inability to offer competitive salaries. As a result, we consistently have vacancies in programs such as functional family therapy, and as a result, a 6-month waitlist for this vital program for the most vulnerable teens and their families. At the start of this contract in 2003, we were able to offer competitive salaries and retain staff in the program for at least 2 years. This has shifted drastically as the state has not reviewed or increased the contract since, aside from occasional and insufficient COLA adjustments. I urge this committee to support SB 432. Thank you for your consideration.
Thank you for your testimony. Are there any questions from the committee? Seeing none, we appreciate you being with us this evening. Thank you for your testimony. Next up, we have Vicki Harrison, followed by Peter Spinella, followed by Mary O'Connor. Ms. Harrison, I see you on the Zoom. You can begin whenever you're ready.
Thank you so much. Good evening, distinguished Chair Senator Flexer and Representative Blumenthal, Vice Chair Senator Slapp and Representative Morin-Bello, Ranking Member Senator Sampson and Representative Mastro Francesco, and the honorable members of the Government Administration and Elections Committee. My name is Vicki Harrison, and I am the Director of Constitutional Convention and Protecting Dissent Programs at Common Cause. We are a nonpartisan grassroots organization dedicated to upholding the core values of American democracy. I'm here today in support of House Joint Resolution 230, the common sense resolution before you that will rescind the Connecticut General Assembly's previous applications for an Article 5 convention. Convening an Article 5 convention would be a disaster. Hosting one at this time would put our most esteemed civil liberties and system of government at risk. It would take place at a time of extreme political polarization and in an environment of unlimited political spending. Nothing in Article 5 outlines how a convention will take place, who will select states' delegates, or who defines what happens once it has begun. They could scrap the existing Constitution and write an entirely new document, as the 1787 Philadelphia Convention did. With nothing to limit the convention to a single issue once it is convened, the delegates could revoke any of our most cherished rights, like our right to peaceful protest, our right to privacy, or our right of freedom of religion. Our Constitution has been amended 27 times, but never through an Article 5 convention. Although states have passed resolutions calling for a convention, the number doing so on a single subject at any given time has not met the 2/3 threshold. Given the lack of progress of pro-convention advocates, we have seen efforts to combine plenary or generic calls for a convention with single subject applications in order to reach the 34-state threshold. That is why I'm here in support of rescission today to ensure that the Connecticut General Assembly can remove all past calls and not unintentionally be counted in efforts to hold a convention. 8 other states have rescinded their previous calls in the last several years, including last year in Oregon, where the bill passed unanimously in the Senate. There are too many unanswered questions regarding an Article 5 convention to risk a free-for-all rewrite of our most cherished document, our Constitution. That is why we ask that you support House Joint Resolution 230 and rescind your previous Article 5 convention calls. Thank you so much for your time today.
Thank you for yours. Are there any questions from the committee? Seeing none, we appreciate you being with us today and sharing your testimony. Next up is Peter Spinella, followed by Mary O'Connor, followed by Heather Gates. Is Peter Spinella with us? I do not see him. So Mary O'Connor, you're up.
Great.
Followed by Heather Gates, followed by Callie Heilman.
Thank you very much. Mr. Chair, members of the committee, I appreciate the opportunity to speak. I'm Dr. Mary O'Connor, Professor Emerita of Orthopedic Surgery at Mayo Clinic, past Professor of Orthopedics and Rehab at Yale School of Medicine, and I'm speaking in opposition to Joint Resolution 4, a resolution proposing a state constitutional amendment concerning discrimination on the basis of sex under the Equal Protection Clause Amendment. In this brief time, I'd like to focus my comments on fairness in athletic competition and the importance of recognizing sex, which is different from gender in medicine. So if there's one thing I'd like you to remember from my words, it's that human bodies and not gender identities compete in sport. And this is so critical. Every person has a gender identity, but every cell in a person is based on their sex. And sex cannot be changed. Males can't become females. And these sex differences, our sex differences, begin in utero and then explode during puberty. But sex differences, as I said, are really the dominant driver, the single most important determinant of athletic performance. Young boys run faster than girls. This happens even before puberty. Post-puberty, the male sports performance advantage can range from anywhere from 15 to over 50%, depending on the sport. Advocates for allowing males who identify as women to participate in women's sports say that the male sports performance advantage can be mitigated through testosterone suppression. This is not true. The best evidence that we have shows that the male performance advantage is retained even after 3 years of testosterone suppression. And this makes sense because every cell has a sex. And so the functions of a cell are driven by that, even regardless of the presence of testosterone or estrogen. So while sex hormones, estrogen and testosterone, strongly influence the body, it's really important to recognize that the sex differences that we have in many aspects are completely unrelated to the presence of testosterone or estrogen. So permitting males to compete in women's sports means that fairness in competition doesn't matter. I'll turn to sex in medicine. Women meaning females, have been historically underrepresented in clinical trials. We know that there are numerous health inequities and disparities. We also know that that drugs that are pulled off the market after complete FDA approval are most commonly pulled because of adverse side effects in women. Why? Because the drugs were not adequately researched, typically in women, before they came to market. So preserving the definition of sex, which means there are male patients, there are female patients, is critical in medicine, particularly for us to understand true sex differences, which impact a lot of diseases. Women, for example, have much more frequent different types of chest pain heralding a heart attack than males do. So I'll close with a short personal story. In 1976, when I was a first-year student at Yale University, I was a member of the women's crew team that went into the athletic director's office.
Doctor, if you could just summarize the remainder of your testimony. Your time has
I
elapsed.
protested in 1976 for the women to have a locker room at the Yale Boathouse in Derby because we didn't have one. And now I am back advocating again for fairness for women in sports. So please do not reverse the gains that we've made by equating gender identity with sex. Female athletes need to be protected with their own category. Thank you.
Thank you for your testimony. Other questions from the committee? Seeing none, we appreciate your time and your testimony this evening. Next up is Heather Gates, followed by Callie Hallman, followed by Danielle Pimentel. Heather Gates with us. I'm not seeing her. Callie Hallman, whenever you're ready, followed by Danielle Pimentel.
Hi, good evening. How are you? Good evening. It says good afternoon, but good evening, co-chair Senator Flexer, Representative Blumenthal, and all the distinguished members of the GAE committee. My name is Callie Heilman, and I'm the co-director of Bridgeport Generation Now. I'm testifying in support of SB 441 and HB 5498. Again, like my colleagues have said, with very important changes. I submitted written testimony, so there's more in my written testimony, but I just want to say that it's so important that the legislature meaningfully address the issues in Bridgeport and protect all Connecticut voters from the behavior that we see. At over 81,000 registered voters, Bridgeport has the largest voting bloc in the state, more than Stamford, New Haven, and Hartford. And if the elections in the largest city in Connecticut cannot be trusted, it calls into question the validity of statewide elections as well. Luckily, we have an example right next door in Massachusetts of state laws, of a state law that is simple, straightforward, and protects voters and campaign workers from unwittingly committing unnecessary felonies, which historically go unenforced anyways. In Massachusetts law, only the voter and the voter's family member has the authority to request an absentee ballot on behalf of voters. There's nothing in the state law that allows campaigns or other individuals to assist or circulate applications. Campaigns can educate and encourage voters to apply for an absentee ballot, but they don't fill out, file, handle, copy, or hold the applications themselves. Absentee voting is an administrative process that is between voters and election officials. In Connecticut, the online portal, the PDF download, calling the town clerk to request a ballot, and the ability to go to the town clerk's office and apply in person gives voters lots of easy ways to request a ballot. Mirroring Massachusetts state law is the ideal change to Connecticut state law, especially in advance of passing no excuse absentee voting, where hopefully every Connecticut voter will be allowed to request an absentee ballot. We can do away with the absentee ballot logs, the serial numbers, the hundreds of stacks of paper applications, and the encouragement to put campaigns and voters in violation of the law, and simply make the process a very easy one between voters and election officials. We also urge the legislature to make it clear that only the Secretary of the State and town clerks have the authority to mail absentee ballot applications, and to ideally fund, as Secretary Thomas testified this morning, to give her office a budget where she can mail For example, a statewide voter guide that might include an absentee ballot application so that all registered voters are receiving nonpartisan election information. Finally, in regards to SB 441, while we would welcome state oversight of the administration of our elections, our strongest concern is the way in which Bridgeport may be placed under the purview of this board, as it is vague and subjective. We already have an issue with the lack of political will to address the issues in Bridgeport. So how can this law be rewritten so that the may turns into a must? Thank you for your time and consideration today.
Thank you for your testimony. Are there any questions from the committee? Oh, Madam Chair.
That's okay. Thank you, Mr. Chair. Good afternoon. Thank you for your testimony. I'm trying to look into more information with regard to the Massachusetts law that you referenced. And what you're saying is that the statute in Massachusetts makes it really clear who can handle an application in addition to a ballot. Is that correct?
In fact, well, I emailed you both the statutes so you can read through
Which
them.
is what I'm reading.
Okay.
Sorry. I
So
didn't mean to put you on.
there's actually no reference in the statutes to the handling of an application at all. So that concept doesn't exist under Massachusetts state law. The law is as simple as the voter can request an absentee ballot, or a family member of the voter can request a ballot for them. The way in which that request happens in Massachusetts state law is, I believe, like through the town clerk's office, and it can be as simple as an email, like sent saying, I request an absentee ballot. So there's nothing in the statutes that say anything about paper applications and who can circulate them and who can't. It's just very simple. Like a voter communicates with their clerk, or a voter's family member communicates with the clerk.
Okay, thank you. We'll look at this more and consider what you've shared with us. Thank you again for your time and your testimony. Thank you, Mr. Chair.
Thank you, Madam Chair. Are there any further questions from the committee? If not, thank you very much for sticking with us today.
Thank you.
Next up is Danielle Pimentel, followed by Carrie Dyer, followed by Norman Patterson Jr. Danielle, I see
Good
you on.
evening.
Begin
Yes,
whenever
can
you're
you all
ready.
hear me? Can you all hear me all right?
Yes.
Oh, thank you. Thank you, Mr. Chair. My name is Danielle Pimentel, and I serve as Policy Counsel at Americans United for Life. And today I urge this committee to oppose SJ4, which will have devastating consequences for women, girls, and preborn children in this state if passed. This resolution is a radical measure that protects abortion up until a baby's birth date, and it does so by deceptively contriving constitutional protections for an unfettered right to terminate a pregnancy, or in other words, abortion. This resolution implicitly creates a right to abortion, and in doing so ensures that abortions are allowed for any reason up throughout all 9 months of pregnancy. And this unfortunately will increase the number of late-term abortions in this state. And we know that at least 10,000 abortions, late-term abortions, happen each year nationally. And authorizing abortion on demand will subject more women to numerous health and safety risks, as abortion procedures carry even higher risks when done later in pregnancy. In fact, when we look at studies, they showed the risk of maternal mortality increases by 38% for each additional week at higher gestations for women who obtain abortions. Not only will authorizing abortion on demand negatively impact women's physical health, but it also negatively impacts their mental health. Numerous studies demonstrate the psychological trauma women experience from abortion, including increased levels of depression, anxiety, and suicidal ideation. So by enshrining a right to abortion in Connecticut state constitution, the number of women and girls suffering from physical and psychological trauma of abortion will unfortunately increase. This resolution also threatens existing life-affirming laws that the state has and impedes the state's ability to enact future health and safety safeguards for women. If terminating a pregnancy is a right in the state, then any law limiting abortion in any manner may potentially be seen as discriminating that purported right. It will make it very difficult for Connecticut to maintain any current life-affirming laws, as well as enact any future common sense protections for women and girls. And lastly, I want to mention that by seeking to enshrine an unfettered right to abortion in the Constitution, the resolution furthers the false and anti-woman narrative that women need abortion in order to obtain equality and success in our nation. And scholarship actually shows that this kind of rhetoric leads to discriminatory treatment towards women because it creates a system that undervalues mothering, which in turn leads to resistance to accommodate motherhood in employment and other circumstances. And this is why discrimination on the basis of pregnancy and employment has succeeded discrimination on the basis of sex. And abortion neither resolves nor combats, neither resolves, nor combats the discrimination pregnant women face. If anything, it only furthers the discriminatory view of pregnancy and motherhood by perpetuating the lie that women cannot be mothers and thrive in American society. The women of Connecticut deserve better than to be subjected to the detrimental consequences of this resolution. And for these reasons I shared, I respectfully ask that you oppose this resolution. And thank you so much for your time. I know it's been a long hearing, so I appreciate you hearing my testimony.
Thank you. Are there any questions from the committee? Seeing none, we appreciate you being with us and sharing your testimony.
Thank you very much, Mr. Chair.
Next up is Carrie Dyer, followed by Norman Patterson Jr., followed by Tom Swan.
Good evening, remaining members of the committee. My name is Carrie Dyer. I am the CEO at Reliance Health. You heard earlier from my colleague, Mike Van. I'm here to speak in support of Bill 432 in reference to nonprofit agencies and having mechanisms in place to protect those agencies, the reporting that we have to do, the funding that we receive, and how that process is a collaborative process. This has been an interesting session that we've been here more than I care to admit. But it seems that there are a number of bills that are addressing this long-standing issue that we've had for nonprofit agencies. I've worked for this agency for just short of 30 years, and for half of that time, we've been flat funded. And when that initially started in 2007, we didn't have an explanation. We thought it was just the crash. That everyone was having, financial difficulties. So it was understandable that we weren't able to get an increase that year. But then it continued. And what came up in the Human Services Committee last week was that there was no mechanism. So the process, and none of us can really put our finger on what was the mechanism prior to 2007, except for the fact that there was compassion and logic and advocacy on our behalf. And that seemed to have stopped in 2007. And then, you fast forward to 2016 where we had the 5% cut. It does appear that there are things being put into place to recognize this and really have some respect for the nonprofit sector, but we need something with teeth. We need something that can actually mechanize a response to this, where we can be partners. That was referenced in the first section of this bill. I think that's really important. I think we have, myself 30 years, Mike has over 30 years of working in this field. So we have access to information that I think is really important to this process. So I think it's very important that all of these bills work in tandem to recognize the importance of nonprofits, recognize the funding requirements that we have as businesses, not thinking of us as charities, and not relying solely on a sort of whimsical approach to funding the nonprofit sector that is the safety net for this state. Thank you.
Well, thank you very much for your testimony. Certainly do not want to fund our nonprofits whimsically.
I agree.
Any questions from the committee? Seeing none, we appreciate you and your colleagues being with us here today to testify on these bills. Next up is Norman Patterson Jr., followed by Tom Swan, followed by Lydia Bennett. Mr. Patterson, I see you on Zoom, and you can begin your testimony whenever you're ready.
All right. Thank you so much. I appreciate you taking the testimonies and the time that you're taking for the testimonies. I'm speaking in opposition to SJ4. My name is Norman Harold Patterson Jr., and I represent the Connecticut Foundation to Abolish Abortion. I am a modern-day abolitionist, and that may sound odd to modern-day ears, but it is the abolitionists that will speak for those who have no voice. And that's one of the goals and jobs of an abolitionist, to educate people of the evils that is happening in our time, and that being the slaughter of unborn children, and also to work to change the laws that discriminate and allow the atrocities to happen upon the voiceless. And so as a abortion abolitionist, I and my organization is working for not the incremental decline of abortion, but the complete and total eradication legally of abortion in the state of Connecticut. I've often wondered how people in legislatures of the past could not only tolerate, but legally protect the right to enslave, abuse, and even legally murder a certain segment of humanity. But all I have to do is read the history, as I did today going through the state building. During the slavery times, they believed slaves were not fully human beings. So they passed laws that allowed the legislation of slavery. And in other countries, during various times, there were Holocausts where people were slaughtered, such as in Nazi Germany, where they passed laws to kill a segment of the population, the Jews, because they did not believe that they were human beings. And now we live in a time where we have the same delusion and madness happening in our state of Connecticut and throughout our country. And we have laws that protect the legal right to slaughter innocent human beings in the womb. This amendment is a very deceptive amendment. I could speak on many other aspects, but I'm going to speak particularly to the question about enshrining the right to kill innocent babies into our Constitution. If this is allowed to be an amendment added to the Constitution, it would enshrine abortion in our state constitution, making it much more difficult for those who want to save the lives of babies to advocate for this. It would also challenge future legislation. It would make it very difficult to change the laws when something like this becomes part of our Constitution. And it also has a broader the definition of discrimination. This amendment commits the fallacy of equivocation because it defines discrimination on one side about a trait that a person has, and then it changes the definition of discrimination to be a condition that a woman has.
Excuse me, Mr. Patterson. I'm
yes.
sorry to interrupt you, but your time has elapsed. If you could please
Okay.
summarize the remainder of your testimony in a couple of
Okay.
sentences.
Yes, abortion will eventually end in Connecticut, and it will happen, maybe not in my lifetime, maybe in my great-grandchildren's lifetime. But one of the first steps is for me to oppose SJ4. Thank you for hearing my testimony.
Thank you. Any questions from the committee? Seeing none, thank you for your testimony, for being with us this evening. Next up is Tom Swan, followed by Lydia Bennett, followed by John McNamara. See Mr. Swan on the Zoom, and if you could unmute, you can begin whenever ready.
Okay. Thank you very much. Representative Blumenthal, Senator Flexer, members of the GAE committee. My name's Tom Swan. I'm the executive director of the Connecticut Citizen Action Group. On behalf of our thousands of member families, I want to thank you for letting me comment on several items before you today and for your ongoing leadership in terms of protecting and expanding our democracy. You guys have been a really great team as chair of GAE, and we appreciate that. So the first bill I want to say, we applauded the legislature when it passed legislation in 2021, creating the Commission on Racial Equity in Public Health. And I'm very pleased to see the resulting Senate Bill 433, an act implementing the recommendations of the Commission. We enthusiastically urge its passage. Taking the proposed steps of building an equity infrastructure, having agencies develop plans regarding public policies, rule setting, hiring, and contracting can begin to redress the decades of institutional racism that continue to this day. We also applaud the emphasis on training, inclusion, and community engagement. And I want to give a side note. It's really great to see this being lifted up in Connecticut when so many states of the former or continued Confederacy are taking steps backwards in these regards. We're really proud of you here. CCAG also supports Senate Bill 441, an act concerning election administration oversight with some concerns. We support the concept of the Municipal Election Accountability Board and believe with some changes it will help us better handle controversies like what has transpired in Bridgeport. We think more work on the mechanisms of a MEAB needs to be done to ensure timely action, and worry that the board is too bill and recommending at least eliminating the representatives from the treasurer and controller's office as a start. CCAG also supports the twin bill here, 5498, an act concerning election security and transparency, and various other revisions related to election administration, again with some proposed changes. We think we can shorten the time that absentee ballot applications are available, that people who take 5 applications or more should be listed on a webpage that shares when what applications are taken out and how many in real time to improve the proposed legislation. Finally, CCAG also supports HB 230, HJ 230, the resolution memorizing Congress to rescind previous applications of the General Assembly, calling for an Article 5 convention to propose amendments to the Constitution. This is a common sense proposal. We urge its passage. Thank you. You guys are real troopers hanging in this long.
Thank you. Are there any questions from the committee? Seeing none, we appreciate you being with us today, your testimony, and your work
Okay.
at People of Connecticut.
Have a great night.
You too. Next up is Lydia Bennett, followed by John McNamara, followed by Lisa Jolie. I do not see Lisa Bennett. So, Mr. McNamara, you're up.
Thank you, Representative Blumenthal, Senator Flexer, members of the committee. My name is John McNamara from New Britain. I'm here to support HB 5494, providing accountability and transparency on ballot questions involving referendums on charter change. As Majority Leader and an Alderman from Ward 4 on the New Britain Common Council, I welcome a revised state election law establishing a plain language standard for questions sent to the voters. This bill calls for ballot questions to provide a precise and fair explanation of the change or changes. And when charter changes address multiple subjects, as they most often do, the legislation states each subject shall be submitted as a separate designation on the ballot. In accordance with the requirements of the election calendar and what I believe to be minimal costs, the bill provides for citizens via petition to object to the ballot language that may violate plain language provision in the proposed statute. It allows for timely appeals to the Secretary of State. I believe such petitions would be rare once common councils and local authorities are given a clear and concise requirement for the wording of the questions. As I have seen in New Britain and heard from other communities, the voters' right to know what they are voting on is too easily violated. Every year, referendums determine the way communities spend tax dollars or change governance in significant ways. At the very least, voters deserve clearness and specificity on the ballot. HB 594 sets an appropriate standard without infringing on local government's ability to make the necessary changes. There is a place for generic housekeeping questions, but on matters of substance, what's on the ballot needs to be clear to voters. Bonding, significant spending, or major organizational changes, as has happened in New Britain, the one-size-fits-all question is an insult. It disenfranchises residents from making an informed decision. I applaud the New Britain League and the Connecticut League of Women Voters for getting behind this. And just to conclude, I would say that the opposition to this, from what I understand, is not to the substance of the bill, but it is an attempt to make a technical knockout of it based on technicalities of the calendar or costs that can easily be overcome if we're interested in the voters' right to know. Thanks for your time.
Thanks for your testimony. Any questions from the committee? Seeing none, we appreciate your time and your testimony.
Thanks much.
Next up is Lisa Jolly, followed by Niels Heilman, followed by Mark Buchanan. Is Lisa Jolly with us? Not see her. Niels Heilman? No. Mark Buchanan? Ah, there you are. Great, we can see you, and whenever you're ready, you can begin.
Good evening. I'm grateful to the committee for the opportunity to speak in opposition to SR 4. My name is Mark Buchanan. I've been licensed as a physician in Connecticut for 30 years. In my retirement, I teach ethics to medical and dental students, and this forces me to follow trends in the care of gender dysphoric people. I've noted with alarm that advocates for gender-affirming care are rejecting the traditions of Hippocratic medicine, instead calling for a consumerist model that is exclusively patient-led. In my written testimony, I describe several scenarios in which this trend jeopardizes patient safety and inflicts collateral damage on the rest of society. Please focus on the language that ends the first paragraph of the proposed amendment: gender identity and expression and related healthcare. This language gives children and adolescents an absolute right, untrammeled by parental or professional concerns, to irreversibly restructure their bodies, leaving them vulnerable to the most extreme gender advocates. Consider the ideology of Andrea Long Chu. Chu first made the news in 2018 with the New York Times article, "My New Vagina Won't Make Me Happy and It Shouldn't Have to." There, Chu said the following about gender-affirming care: "I feel demonstrably worse since I started on hormones. I was not suicidal before hormones. Now I often am. My new vagina is what I want, but there's no guarantee it will make me happier. In fact, I don't expect it to. That shouldn't disqualify me from getting it." This is a complete rejection of the medical model and a demand for gender-affirming care as a civil right, even when it is self-destructive. Now, 5 years later, Chu is back in the news with an article in New York Magazine called "Freedom of Sex: The Moral Case for Letting Trans Kids Change Their Bodies." Chu rejects any distinction between children and adults, just as this amendment does. His article claims that children have the same right to medical intervention to change their sex as the adult Chu does, not because the treatment makes the child happy or less suicidal, but because the child wants it, period. This child-led treatment removes any protection by the parents. Parents are to have no say, and neither will a doctor who cautions caution and who prioritizes treating the depression, anxiety, PTSD, eating disorders, and autism so commonly seen in gender dysphoric youth. Chu's article is deeply disturbing to anyone who cares about children, but the proposed legislation will enable and enforce exactly what Chu calls for. Thank you. I'm happy to entertain any questions.
Thank you. Any questions from the committee? Seeing none, we appreciate you contributing your testimony this evening.
Thank you.
Next up is Neil Dreif, followed by LJ Fusaro, followed by Peter Wolfgang.
Good evening, Senator Flexer, Representative Blumenthal, ranking members Sampson and Mastrofrancesco, and honorable members of the GAE committee. I appear today to offer testimony in support of SB 431. The bill, as written, will provide relief to police departments struggling to manage the deluge of public records requests for video footage that police officers are required by law to record on body-worn and dashboard cameras. An additional provision of the bill will provide valuable protections to the privacy rights of Connecticut residents who call the police to their private residences. The Connecticut Freedom of Information Act provides valuable protections for residents seeking transparency in the operation of government by providing access to certain public records and meetings. Law enforcement records are subject to many exemptions aimed at protecting the privacy rights of an array of persons. Unfortunately, the provisions of the Freedom of Information Act have not kept up with the technology now mandated for use by police officers and the complexity involved in processing requests for these records. Many provisions of the FOIA harken back to the days when records of a law enforcement agency consisted of a dispatch record written on a 3x5 card with a timestamp, a handwritten police report, and in cases where an arrest was made, a mugshot. Redaction was accomplished with a black magic marker, and the fee of 50 cents per page for copies seemed about right. Today, records of a law enforcement agency can include hours of video and audio footage from multiple sources, even for a routine call for service. The process of reviewing and redacting that footage is complex and time-consuming. Some police departments have hired additional staff to manage that process. Others have assigned the task to existing sworn personnel at a time when many of our departments are short-staffed, taking time away from other duties or costing overtime. Charging $5 for the thumb drive onto which the footage is recorded is a fraction of the cost the police departments incur in preparing the footage. I also support the inclusion of language prohibiting the release of video footage recorded inside a private residence or that captures a person in a state of undress or nudity, subject to narrow exceptions. Anecdotally, my colleagues and I would deny a request for such a record on the grounds that it constituted an invasion of privacy. The denial may trigger a complaint to the FOI Commission, which would then review the circumstances on a case-by-case basis before issuing rulings that would provide us with some guidance on future requests. This is a burdensome process that the legislature can overcome by exempting such records from release. Allow me to state my support for the Freedom of Information Act and the right of Connecticut residents to have access to public records. My support for this bill is a request that the legislature take another look at the complexity of responding to public records requests in light of technological advances that the authors of the Freedom of Information Act did not and could not have foreseen. Thank you.
Thank you. Are there any questions from the committee? Seeing none, we appreciate you being with us this evening and submitting your testimony.
Thank you.
Next up is LJ Fusaro, followed by Peter Wolfgang, followed by David Pelchat. Is LJ Fusaro with us? Do not see him. That leads us to Peter Wolfgang, followed by David Pelchat, followed by Joanne Todd.
Members of the committee, good evening. My name is Peter Wolfgang. I am president of Family Institute of Connecticut Action, and I am testifying against SJ4, the resolution proposing a state constitutional amendment creating a right for abortion up to birth and gender transitions, even for minors without parental knowledge or consent. That, of course, is not the name you gave SJR, but that is what the amendment would do. The proposed amendment would create a right to post-viability abortion, removing even the fig leaf of a restriction on it in current Connecticut law. Late-term abortions are already legal in Connecticut for reasons of mental health, a loophole so big that you could drive a truck through it. So why put it in the state constitution? Even our state legislature's pro-abortion caucus and Planned Parenthood itself have told the press that this amendment is not needed and is not one of their priorities. So why do this? The proposed amendment will also allow minors to access so-called health care, such as puberty blockers, cross-sex hormones, permanent and mutilating surgery as a civil right, possibly without the consent or even the knowledge of their parents. It would create a civil right for biological boys to compete in girls-only sports in Connecticut, both in practice and competitions. This endangers our girls physically, emotionally, and financially through missed scholarship opportunities. It would put the mission of our Catholic health and school systems in jeopardy, violating free speech and freedom of religion. You may respond, where in the language does the amendment allow for these things? But where in the language is it stated that these things are not created by this amendment? This amendment is so vague that it will be open to whatever interpretation courts and administrative agencies choose to give to it. Absent language to the contrary, there is nothing stopping every radical consequence mentioned above from becoming a reality, and still more radical things that we cannot as yet even conceive of. Please do not open this Pandora's box of ill effects on our society, particularly when even the abortion providers themselves say it is unnecessary. Please vote no on SJ4. Thank you.
Thank you. Are there questions from the committee? Seeing none, we appreciate you submitting your testimony this evening.
Thank you.
Next up is David Pelchat, followed by Joanne Todd, followed by Scott Nugent. Do not see David. Next we have Joanne Todd. Are you with us? Sorry if I mispronounced your name. No. Okay. That brings us to Scott Nugent, followed by Angela Cassidy, followed by Lori Utzler. I see Scott Nugent on our Zoom. Not answering. Once, going twice. All right, we'll move to Angela Cassidy, followed by Lori Utzler, followed by Donna Lopiano. Okay. Lori Utzler. Yeah, all right. Donna Lopiano, you are with us on Zoom. And whenever you're ready, you can unmute yourself and begin your testimony.
Thank you. Thank you. I'm Donna Lopiano. I'm a sports management consultant and adjunct professor of sports management at Southern Connecticut State, former CEO of the Women's Sports Foundation. And I thank all of you for this opportunity to spend all afternoon with you. You are such troopers. And I just want to make really 3 points, most of them construction points. The state constitution should not include a statement that is untrue, a statement that is a pretense, or one that is poorly constructed. And SJ4 is all of these because it conflates sex, pregnancy, sexual orientation, and gender identity and expression. When it says sex includes discrimination based on pregnancy, sexual orientation, et cetera, et cetera. So it either erases biological sex or makes all the categories to be added equal to biological sex, a critical construction error, because these terms are not interchangeable, as you've heard from others who have given testimony. Let me make it clear, though, that each of these categories deserves protection, either through a general statute prohibiting discrimination, and maybe some through a constitutional statute. Second point, that the construction of the proposed amendment is inconsistent with both the existing Connecticut General Public Accommodations and Discrimination statute and Section 20 of the Constitution, which it intends to amend. So my point is that this amendment should have identical construction to Section 20 of the Constitution. No discrimination on the basis of race, comma, color, comma, all discrete categories, adding whatever new categories are appropriate with for protection, adding those categories with commas after each. But my last point is probably most important, that protecting all of these categories from discrimination is important, but it's also important to be clear that differences in treatment may be justifiable and permissible when they make common sense and they advance important social goods. And these examples have been mentioned. Separate sex public accommodations like bathrooms, changing areas, or prisons, advance privacy, and they safety concerns. Separate sex competitive sports advance fairness and safety concerns. It makes sense that UConn men's and women's teams are vying for national championships in the next 2 weeks, and that 50 years of Title IX athletics has benefited the health and confidence of millions of young women. And it really makes sense to allow sex differences in medical research, critical to advancing women's health. Our bodies are different. But the key is when there are conflicts, and this was the chairman's question earlier with Kim Jones' testimony, that legislatures and the courts must carefully examine the reasons for accommodations when there are conflicts between two categories, rather than blindly assuming that all different treatment is bad. And this is where the Connecticut legislature, I think, has really fallen down. To allow the CIAC rules to be
Ms.
unquestioned,
Lopiano, I'm
unstudied.
sorry to interrupt, but your time has elapsed. If you could please summarize the remainder of your testimony in a sentence or two.
I'm finished. I appreciate the opportunity.
Well, thank you very much for your testimony. Are there any questions from the committee? Seeing none, we appreciate you sticking around and giving us your testimony. Thanks very much. Next up, we had a technical difficulty earlier with Joanne Todd, we're going to have you go now if you're ready. Why don't we will go to Deborah Barrel. And then Joanne, if you can figure out your Zoom, you can go after Deborah.
Thank you, Chair members, for this opportunity to speak. I came here today in the hope of opening your hearts to the seriousness of what you're proposing in SJ4. There is an eternal law that says, do unto others as you would have them do unto you. And another eternal law that says, love your neighbor as yourself. Do you realize these children are your neighbors? Ask yourselves, why do I have such a passion to murder these innocents and mutilate minors? Why does that excite you so much to a point that you need to make laws to fulfill that fervor? Is it because you think you are God and you know what is best for everyone? Do we not know that God has 10 commandments to follow for our own good? By proposing this bill, you show that you hate God's commandments. From God's point of view, here are the commandments that Connecticut wants to live by and follow. Oppose and eliminate God. Worship everything that opposes a godly life. Use God's name to promote wickedness. Never rest, because there is no rest for the wicked. Dishonor and eliminate parents, fathers and mothers. Commit murder, commit adultery, take what is not yours, lie and be a false witness, be selfish and covet everything. These commandments that you are following will surely bring hell. God said through his prophet Isaiah, the wicked are like the troubled sea when it cannot rest, whose waters cast up mire and dirt. There is no peace, saith my God, to the wicked. The spiritual consequence of just proposing this bill will be dreadful for you. God is real. If you turn away from this folly and towards him, he is very merciful. Please, for the sake of your eternal souls and for the sake of Connecticut, turn from your wickedness. Thank you for your time.
Thank you for your testimony. Are there any questions from the committee? Seeing none, we appreciate your time and your testimony. Next up is, Ms. Todd, we see you have joined us. And so if you unmute, you can begin whenever you're ready.
Yes, thank you. And thanks for your patience with the technology. Madam Chair, Mr. Chair, and members of the committee. My name is Joanne Todd, and I live in Scotland, Connecticut. And I very much appreciate this opportunity to testify in support of SB 435. As a longtime member and treasurer of the Willimantic Food Co-op, I ask for your support of SB 435. The amendments to the Connecticut Entity Transactions Act, CETA, will allow the Willimantic Food Co-op in Willimantic, Connecticut to become a cooperative under Chapter 595. To give context, Chapter 595 was modernized in 2019 in an effort supported by cooperatives in Connecticut, including the Willimantic Food Co-op, which is currently a Connecticut non-stock corporation, who wanted to incorporate as a cooperative in their home state. They pursued modernizing the statute because of the onerous liability issues of the former cooperative statute. In 2023, the Willimantic Food Co-op filed to merge its current non-stock entity with and into a Chapter 595 cooperative. And the Secretary of State cited the Connecticut Entity Transaction Act in denying the merger. The CETA language in SB 435 was developed by the business law section of the Connecticut Bar Association. And the attorney who drafted the language just emailed us earlier this morning with a correction, 34-608A subsection 12, not nonprofit or not-for-profit corporations on page 22 should be struck. Getting back to the Wilmington Food Co-op, the amendments in SB 435 would remove the CETA prohibition to merging non-stock corporations into cooperatives and would allow the merger to proceed. Without this change, the Wilmington Food Co-op would not be able to realize their goal of becoming a Connecticut cooperative and would have to give serious consideration to incorporating outside of Connecticut. Why is being a real cooperative important, and why is it important that CETA be changed to make converting to a cooperative possible? Because the cooperative model is good for Connecticut. Cooperatives are owned by their members and provide a singular focus on the member owner value. It's that member ownership that is the foundation of cooperative sustainability, and enabling cooperatives is vital to maintaining a distinct ownership model that builds community and community wealth. Thank you for your consideration, and I'd be happy to answer any questions.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony.
Thank you.
Next is Leslie Wolfgang, followed by Travis Woodward, followed by Christine Rebstock. Welcome, Leslie. The floor is yours.
Good evening. My name is Leslie Wolfgang. I am the Director of Public Policy for the Family Institute of Connecticut. I am testifying against SJ4. This bill will be the first step in creating an amendment to the Connecticut Constitution. This amendment would prevent the state from restricting access to gender-affirming care for minors. It would be considered discrimination against gender identity and expression and related health care. The question at the bottom of the bill, included for this bill, for use on the ballot, excludes the word health care. This is a problem because the law will affect health care, and the question does not mention it. It is setting itself up for a legal challenge. The state should preserve the ability of the legislature to restrict gender-affirming care because the standard of care for minors is a topic of considerable debate. We need the moderating influence of the legislature to be able to regulate healthcare if necessary. Recent articles and studies are throwing into question puberty blockers and the cascading effect of gender-affirming treatments for youth. We can't leave to medical societies and the activists that influence them to determine exclusively what is a civil right in Connecticut. I mentioned that there is a debate. Last week, England's national health system banned regular use of puberty blockers for affirming children because it is not safe or effective. Former USPath president who identifies as a transgender woman, Dr. Erica Anderson, testified a few weeks ago against a bill in the Judiciary Committee, emphasizing that US medical associations have been unduly influenced by activists. According to one of the doctors who pioneered gender-affirming care for minors, there is a systemic silencing of physicians, researchers, academics, and writers who express concerns over gender-affirming care. The ones who have raised questions about gender-affirming care have been subjected to organized campaigns of vilification and threats to their careers. Activists, not doctors, are setting the standard of care for transgender youth, and they should, in turn, not be setting the standard for what is a civil right in Connecticut. You may be aware that there has been an expose of WPATH, the organization that underpins the standards of care for the US for transgender youth. The expose revealed indifference to children not being able to provide informed consent hormone-inducing cancer in children, inability to experience orgasm as adults, indifference to underlying mental health problems, and regular attempts to create bodies that don't exist in nature, such as persons with 2 sets of genitals, nipple removal or negation, and just plain no genitals at all. The legislature should preserve the right to regulate or even restrict it, not create a vague question for the ballot that ties its hands over something so critical to our Connecticut youth. Thank you.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Seeing none, thank you for your time and your testimony.
Thank you.
Next, we will hear from Travis Woodward, who will be followed by Christine Rebstock, who will be followed by Linda Brock. Welcome, Travis. The floor is yours.
Hi, good evening, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and members of the GAE committee. My name is Travis Woodward. I'm a resident of Hamden and an engineer for Connecticut Department of Transportation. I'm also the president of CSEA SCIU Local 2001, a labor union representing 25,000 state, municipal, Board of Ed, active and retired public and private sector workers. I offer the following testimony on behalf of CSEA, as well as all union locals in the State Employees Bargaining Agent Coalition, or CBAC, in support of Senate Bill 436. I first would like to thank the committee for raising SB 436. CSEA represents public employees throughout Connecticut, including paraeducators working for local school districts, people working at the municipal public works departments, environmental analysts working for the Department of Energy and Environmental Protection, and more. This is a piece of legislation that is very important to them and our whole union family. Public employees do critical work for the people of Connecticut, and I would never want that work to be put any of us, our families, or our coworkers at risk because someone abused the FOIA process. Even DOT engineers are at risk from harassment and even worse, from individuals with bad intent. Once, while rehabilitating a portion of highway in Fairfield County, a coworker of mine was verbally accosted near a project by a resident who was complaining about construction noise. This was not someone blowing off steam and then going about their day. This was a person who could reasonably be believed to want to take violent action against my coworker. Thankfully, in this specific case, the situation de-escalated. But my coworkers and I still think about what could have happened. Right now, there is nothing to stop this individual from using the Freedom of Information process to find my coworker's address and seek revenge at their residence. State, municipal, and Board of Ed workers want to be added to the list of people whose residential address is blocked from release through the FOIA request. Currently, there are people in 13 groups whose residential address is exempted. Those groups include police officers, firefighters, employees of the Department of Children and Families, members or employees of the Commission on Human Rights and Opportunities, and other people doing important work on behalf of the residents of Connecticut. The safety and security concerns that lead to these groups being exempted are also held by people working for the state, municipalities, boards of ed. We're not asking for special treatment or trying to hide our accountability, but like other people's whose addresses are exempted from release, we just want to keep ourselves and our families safe. SB 436 would not harm state, local, or Board of Ed operations or the ability of the public to hold our government accountable. It will, however, help protect the people who work tirelessly to make Connecticut a wonderful place to live and raise our children. Thank you for hearing my testimony, and I urge you to support SB 436.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from the members of the committee, thank you again. Next, we will hear from Christine Rebstock, followed by Linda Brock, followed by Jack Hennessy. And I don't believe Christine is here. So Linda Brock, welcome. The floor is yours.
Senator Flexer, Representative Blumenthal, and members of the committee, thank you for hearing from us today. My name is Linda Brock. I am a resident of Wyndham Center. I'm speaking in support of SB 435, specifically sections 15 through 25, amending the Connecticut Entity Transactions Act. I'm a member of the Willimantic Food Co-op, and I currently chair its board of directors. I encourage your support for SB 435 to strengthen Connecticut's business environment. The cooperative business model is one of the most successful and resilient. Cooperatives have a higher survival rate than most other types of businesses. This is a result of the values and principles central to many cooperatives. Their members have a direct and equal financial stake in the company. They have an equal voice in major decisions and its direction and in choosing representatives, and they have an explicit commitment to their community. Rather than maximizing profit for distant investors, Cooperatives operate for the direct benefit of those who use them, who are typically residents of the region or the immediate area. Cooperatives keep resources in and strengthen their communities. The change to Chapter 595 made in 2019 encourages the establishment of new cooperative businesses in the state, and we have in fact seen the establishment of Connecticut's only true food cooperative since that revision took effect. But without this SB 435 amendment, those businesses like ours, which have functioned from the outset as cooperatives but have not had that legal standing, will not have access to the same protections and benefits as the newly formed businesses. We're only one of a number of Connecticut businesses functioning as cooperatives now, but incorporated under other structures. I ask that you give companies like ours that have spent years bringing the value of cooperatives to our regions the ability to remain incorporated in Connecticut while gaining equal standing to those that can now form in the more favorable environment you recently created. Approval of SB 435 will permit this by removing the barrier to mergers between cooperatives and, in our case, non-stock corporations. Thank you for your consideration of this step.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Next, we will hear from Jack Hennessy, who will be followed by Ben Shaken, who will be followed by Christina Bennett. Welcome, Jack. The floor is yours.
Hello.
Hi, we can hear you. Please, if you can, turn on your camera and proceed. The floor is yours.
Oh, start video. Yes. Hello. Do you see me?
We sure do. Nice to see you.
Hello, Senator Flexer. I'm Jack Hennessy, former state representative for the 127th District in Bridgeport. And I am happy to take this opportunity to offer testimony in opposition to House Bill 5498. Specifically, I question why line 14 is inserted into this election reform bill. Line 14 seeks to prohibit the use of independent or any similar word in any party designation recorded with the Secretary of the State. In the parlance of the legislature, line 14 is a rat and is undemocratic. It's got nothing to do with addressing the election problems regarding absentee ballot harvesting in Bridgeport, and is simply a distraction while seeking to disenfranchise the state independent party members. The Independent Party of Connecticut has had statewide voting rights since 2008. There's never been an objection before for the name. Minor state parties across the United States use the term independent without issue. To say this is necessary to avoid confusion is gratuitous. This is illegal and a violation of our First Amendment rights. If there is needed education to teach the populace the difference between the independent party and the unaffiliated, there are other ways to remedy any confusion regarding unaffiliated versus independent. I also question the timing of this attempt at usurping a minor party's naming rights. Could this be a partisan retaliation for the embarrassment that top state Democratic Party leaders had to file into Bridgeport at the behest of DTC Chair Testa to endorse a certain incumbent Democratic mayor from the challenge of a cross-endorsed independent party candidate? Within the past 6 years, there's been a total of 4 court-ordered new Democratic primaries issued by 3 separate court judges for 1 municipality due to absentee ballot irregularities. If nothing is done to curtail this, this is going to continue. We're going to continue to have lawsuits with primaries overturned, and we need substantial election reform. Thank you for your consideration.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from members of the committee, thank you again. Next, we will hear from Ben Shaken, who will be followed by Christina Bennett, who will be followed by Meredith Remigio. Or no, Remigino. I'm going to get that right when they come up. I apologize. Welcome, Ben. The floor is yours.
Thank you, Madam Chair. Members of the committee, my name is Ben Shaken. I am the Director of Government Relations at the Connecticut Community Nonprofit Alliance. We are the statewide association that represents community nonprofits in Connecticut. Nonprofits to deliver essential services to more than 500,000 people in the state, and they employ 118,000 people in the state of Connecticut. I am here to testify in support of Senate Bill 432, an act concerning state contract for nonprofit human services providers. You heard from some of our members earlier. There may be some coming up after me as well. This is a priority for our organization. It takes several steps to improve the process and address some issues that nonprofits face when they contract with the state to deliver health and human services on behalf of the state of Connecticut. And that is how the state's health and human services system is delivered. Nonprofits work in contract with state government to provide those services primarily to people in the state. I want to focus on just a couple of sections of the bill. There's four main things that the bill does. First, just to touch on this sort of notion that the Office of Policy and Management should review what nonprofits are paid for services and make some kind of determination and then recommendation to the legislature about whether the rates are adequate. You know, the legislature has provided some increases through your budgeting process over the years, as my colleague Carrie Dyer talked about earlier. They've never been automatic. There's a bill in the Human Services Committee to change that. But the other thing that's never been automatic is any kind of review or systematic look at whether what the state is paying is actually adequate to get what they're asking for from nonprofits and what they're asking nonprofits to deliver. And in many cases, those rates outside of legislative intervention through the budget, through small cost of living increases, are not based on anything besides this is what we thought it cost when we issued the contract, sometimes several decades ago. And so the expectations on the contract stay the same or grow, but there's never any, hey, are we actually looking at what we're paying for and whether we're getting what we should be paying for this price. And we think having a review like that would help outside of the procurement process, look at whether the state is being realistic about what it's expecting for nonprofits at the rates that it's paying. Second, just because it came up earlier and there was a question, this idea about requiring payment for services within 30 days that the services are rendered. This varies by state agency. And so I think the question was asked from an agency that doesn't have significant issues with timely payment. But some providers don't receive payment for contracts from certain state agencies for months, like more than 6 months. They'll deliver a service and then 6 or 7 months later get paid for it. And that means that they're floating the cost of the service. They're making payroll off of their lines of credit, paying interest to banks on that while they're waiting for payment for services. As was said earlier, that happens in good faith, payment comes, but we think it could be sped up, particularly in some agencies where it is a sort of habitual and perpetual issue. And so we're grateful that the bill would mandate that on-time payment or payment within 30 days. And my time is up, so I will leave the rest of this to my written testimony, and I'm happy to answer any questions.
Thank you. Thank you for your time and your testimony. I see no comments or questions from members of the committee. So thank you again for your time and your testimony.
Have a wonderful evening. Thank you.
You too. Next, we will hear from Christina Bennett, who will be followed by Meredith Remigino, who will be followed by Douglas Schwartz. Christina, I don't believe Christina is here. Moving on, Meredith, is Meredith here? Nope, there's Christina. Christina, welcome. The floor is yours. Christina, you need to unmute yourself. We cannot hear you.
I'm sorry. Dear members of the committee, my name is Christina Bennett, and I am testifying as a liaison for the Family Institute of Connecticut, and I'm here to oppose SJ4. SJ4 seemingly seeks to address discrimination based on pregnancy, including preventing, initiating, continuing, or terminating a pregnancy. But what it does not do is define what that discrimination looks like or give evidence that is happening in the first place. That leaves us with many questions. Could pro-life pregnancy resource centers who offer alternatives to abortion be considered discriminatory because they don't offer abortion? Could Catholic hospitals who refrain from performing abortions be brought up on charges of discrimination? Could pro-life sidewalk counselors who peacefully stand outside of clinics and offer resources be accused of discrimination for their views on terminating a pregnancy? I would hope not, because there's many women like my mom who needed someone to talk to them in their decision-making process. And thankfully, my mom talked to a janitor at Mount Sinai Hospital in Hartford, which gave her the strength to walk out of her abortion appointment and save my life. It's important to note that the state of Connecticut already has extreme abortion laws. We don't require minors to notify their parents if they want a surgical or chemical abortion, even though 42 states do. And we do require parental consent for tattoos and piercing and tanning, but not abortion. Connecticut also allows for abortion up to 24 weeks. And after that, you can still continue to have one because of health or life at risks. Connecticut women and sadly children are not lacking access to abortion, and many are not hindered financially, as reports show up to 70% of abortions in Connecticut are paid for by taxpayer dollars. So what is the purpose or need for a constitutional amendment for abortion rights? Is this merely another way to enshrine abortion access into our state constitution? Who will this benefit? The abortion business could gain more revenue, but women in Connecticut struggle often because of lack of housing, lack of support, lack of resources to carry forth their pregnancies. The bill is vague, and I believe intentionally so, and the people of Connecticut deserve answers. I ask that SJ4 does not proceed any further and that clarification be given regarding what pregnancy discrimination is in the bill and who the bill attempts to accuse of doing it. Thank you.
Thank you. Thank you for your time and your testimony. Seeing no
Thank
questions
you.
or comments, thank you again. Next, we will hear from Meredith Remigino. I don't believe Meredith is here. So we'll move on to Douglas Schwartz, followed by Jess Zaccanino. Is Douglas here? Oh, welcome. The floor is yours. Mr. Schwartz, I'm sorry to interrupt you. There's a button in front of you. Great, thank you.
Okay, sorry. It's worthless. If anybody wants to protect the fort, they should take the initiative that is being worked on in the House with representatives from southeastern Connecticut to acquire it, either through donation, acquisition, or condemnation, and make it either a park or more likely probably an archaeological preserve. This is a nationally significant landmark which has attracted support for its preservation from the American Battlefield Trust, the National Trust. We saw Connecticut Preservation here, and the Archaeological Conservancy. The Ledyard citizens have unanimously opposed turning that mountain into a quarry. Senator Austin said that the submission for a zoning permit has been withdrawn, which is true, but we expect they're going to come back. So time is of the essence, and the sooner it's acquired by the state, which is the only way it will ever be permanently protected, the better. And this is long overdue. And Commodore Decatur was one of the great heroes of the American Revolution, well, the post-revolution, early American history, whose exploits are memorialized in the Marine hymn. Thank you.
Thank you. Thank you for your time and your testimony. I have two questions for you. Which line in the Marine Corps hymn?
From the halls of Mount Izuma to the shores of Tripoli. Jefferson sent him over to clean up the Barbary pirates. They're modern heirs of the Houthis who are doing the same thing. They're attacking American shipping.
Thank you. That's very informative. Thank you for that. And one more question. When you signed up to testify, the organization listed was CALU. Can you just tell me what that stands for?
I think it's Citizen Alliance for Land Use.
Great. Thank you very much. Thank you for your time and your testimony.
Okay.
Next, we will hear from Jess Zaccanino, followed by Amy Brown, followed by Gretchen Raffa. I don't see Jess, so Amy Brown, I do see. Welcome, Amy. The floor is yours.
Hi, good evening, Madam Chair and Mr. Chair, as well as the members of the committee. I am Amy Brown. I'm the controller at Ability Beyond. I've been there for 25 years. I'm testifying in support of Senate Bill 432, the act concerning state contracts with nonprofit human service providers. Ability Beyond is a nonprofit human service agency. We provide residential, day, transitional, mental health, and employment services to nearly 2,000 individuals in Connecticut. And we have contracts with 5 state agencies: DDS, DMIS, DSS, Aging and Disability Services, and the Office of Workforce Strategy. Additionally, we serve individuals in 20 intermediate care facilities funded by DSS. Our programs are located throughout Western Connecticut with offices in Bethel, Norwalk, Bristol, and Waterbury, and we have 1,000 staff members in Connecticut. Others have spoken to the insufficient rates. I wanted to speak briefly about inefficiencies and duplication of efforts. Each of the 5 state agencies that we contract with have different processes, timelines, and deadlines for billing and reporting. Our direct care staff, as well as our billing staff, are forced to understand multiple systems to billing to satisfy these varying state requirements. Staff training time is increased, and managers are forced to interpret multiple guidelines when working in differently funded programs. This causes staff frustration and leads to retention issues. Some of our state funders require paper billing submissions, while others can accept varying degrees of electronic billing. Many providers in the state have invested in electronic consumer record systems to enhance documentation. These systems are capable of electronically billing for services, but when funders can't process an electronic billing file, we face significant waste of time and effort to manually record transactions. If we could consistently send electronic billing and receive corresponding electronic remittances, I estimate a savings at our agency of 2 full-time positions. Each funding agency has also a separate process for reporting, some through Core CT and some through Excel spreadsheets. Some agencies provide multiple contracts for services in different regions. Each site funded by the different contracts requires separate reporting in Core CT, causing inefficiencies as some components of cost overlap all programs, but must be entered repetitively. With one of our funders, we have 3 executed contracts serving 16 locations, so our cost reporting requires 16 separate files for submission. I strongly believe a consistent system of reporting and electronic billing would benefit all human service providers and state agencies by reducing duplication of effort and manual processes. I urge the committee to support Senate Bill 432. Thank you for your consideration.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from members of the committee, thank you again for your time and your testimony. Next, we will hear from Gretchen Raffa, who will be followed by Nora Taylor, who will be followed by Lisa Baxter. Welcome, Gretchen. The floor is yours.
Good evening, Senator Flexer, Representative Blumenthal, and honorable members of the Government Administration and Elections Committee. My name is Gretchen Raffa, Vice President of Public Policy, Advocacy, and Organizing with Planned Parenthood of Southern New England, testifying regarding SJ4,
resolution proposing a state constitutional amendment concerning discrimination on the basis of sex under the Equal Protection Clause. As the state's largest provider of sexual and reproductive health care, we believe all people should have access to quality, affordable, and compassionate health care as a basic human right, regardless of who you are, where you live, your income, if you have health insurance, or your immigration status. And we thank the committee for raising this important issue. Connecticut has been a leader state with a long and proud history of strong bipartisan support for advancing reproductive rights and LGBTQ+ rights. We unequivocally support protecting the right to reproductive health care, including abortion care in Connecticut, and believe our Constitution and our laws are meant to protect people's basic rights, because we believe that the right to abortion is a fundamental, essential right. While we work to protect and restore access to abortion that was stripped from us in the U.S. Supreme Court Dobbs decision, attacks on sexual and reproductive health care continue at breakneck speed in Congress and in states across this country, with 21 states that have banned some or all of abortion care, and those states are also banning gender-affirming care. Because of these abortion bans and restrictions, it's now harder for people to get life-saving medical care for miscarriages, ectopic pregnancies, and other pregnancy-related complications. People are being forced to carry a pregnancy against their will or struggle to find the resources to travel out of their home state to access the essential care they need. And the people most affected by these bans and attacks on reproductive health care disproportionately impact Black, Latino, and Indigenous communities, people with low incomes, and people living in rural communities due to our country's legacy of systemic racism and discrimination. And it's clear that overturning Roe v. Wade was never the end game for anti-abortion lawmakers and allies. They continue to come after abortion care, family planning programs, birth control, gender-affirming healthcare, and even IVF with the latest decision by the Alabama Supreme Court. These decisions not only deny our freedom to decide if and when we are going to become parents, but also now they're saying how we become parents. This has always been about power and control. Every day, people across our state and this country make deeply personal decisions about their pregnancies. Those decisions should be respected and valued regardless of the outcome of their pregnancy decision, and should be free from shame, stigma, and political interference always. Thanks to the dedicated leadership of our elected champions, abortion has been protected in Connecticut statute since 1990 and strengthened in the last 2 years with the Reproductive Freedom Defense Act and other laws that have been passed. Despite the progress we made, we know that in Connecticut, there are people that are still facing barriers to this essential care, which is why we have a bold agenda this session. Just as we're seeing states ban abortion care, states' bans on transgender healthcare passed at an alarming rate in 2023, and now over 20 states ban access to gender-affirming care. These attacks on LGBTQ+ people and their rights, along with concerns raised in the Dobbs decision, suggest that further erosion of people's rights beyond reproductive rights are likely, which is why we must do everything we can to enshrine these protections for LGBTQ+ people and families in our states.
Thank you, Gretchen. I'm sorry to interrupt, but your
Yeah,
time
no
has
problem.
elapsed. If you want to summarize.
Yes, thank you. SJ4 would build upon our state's strong equal protection clause to clearly prohibit discrimination based on decisions surrounding pregnancy, sexual orientation, and gender identity and expression. Connecticut must continue to lead and do everything we can to protect this essential healthcare for people who need it and further protect the rights of LGBTQ+ people and families in our state. Thank you so much to this committee for your time and consideration of this important resolution.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from members of the committee, thank you again for your testimony.
Thank you. Have a good night.
Next, you too. Next, we will hear from Nora Taylor, who will be followed by Lisa Baxter, who will be followed by Sage Steele. Is Nora here? Welcome, Nora. The floor is yours.
Thank you. And thank you to the committee for hearing these tonight. I am here to talk about the Bill 442, the designation of Mount Decatur as a historic site here in Gales Ferry, Connecticut. While I support Mount Decatur to be designated as a nationally recognized historic site, I do not support the proposed bill as it is currently written because it does not propose to protect the entirety of Mount Decatur, only a small portion of it. Stephen Decatur and his men and ships were at Mount Decatur for 3 months, keeping watch to defend in case the British, who were sitting out on Long Island Sound, made their way up the Thames River during the War of 1812. There is much history and many accounts to be found about this moment in time. Surely the documented, well-preserved fort itself and artifacts found there so far is not the only area or portion of Mount Decatur that should be preserved. The entirety of Mount Decatur should be preserved to create a historical landmark whose story can be told and seen by the public, and to protect it from destruction, to keep it intact. SB 00442 needs to be rewritten to include the depth and detail of preservation Mount Decatur deserves. The whole hill, not just a portion of it. Thank you for your time.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments from members of the committee, thank you again for your testimony. Next, we will hear from Lisa Baxter, who will be followed by Sage Steele, who will be followed by Matt Blindstrabas. Lisa, welcome.
Thank you.
Floor is
Thank
yours.
you. Good evening, members of the committee. Thank you for the opportunity to testify in support of SB 432, an act concerning state contracts with nonprofit human services providers. My name is Lisa Baxter, and I serve as the Chief Financial Officer of Child and Family Agency of Southeastern Connecticut. Child and Family Agency employs 260 staff to provide behavioral health, medical, and supportive services to over 10,000 children, families, and adults in New London, Middlesex, and Windham counties each year. We contract with Department of Children and Families, Department of Public Health, Office of Early Childhood, and State Department of Ed. All of the areas of this bill are very much needed, as expressed by my colleagues earlier. But we do appreciate that the bill directs state agencies to provide payment for services rendered by nonprofits within 30 days. This change would greatly benefit our organization. Child and Family Agency includes 60% of our budget is state contracted funding. Receiving timely payments is critical for the cash flow and operations of our agency. Department of Children and Families is the most prompt payer and is one of our largest contracts. Our next largest contract is through the Department of Public Health. And on the flip side, they are chronically late in processing payments and do not adhere to a reliable payment schedule. This goes back 30 years from my experience in managing grants and contracts for a child and family. Department of Public Health covers about 70% of the cost of our school-based health center programming. Therefore, when they're sending payments 3 to 4 months after the start of a quarter, we end up with an extreme cash flow challenge. Each quarter, we are forced to borrow from our savings or investments to meet our expenses. For the first time in many, many years, we recently had to borrow from our emergency line of credit in order to meet our payroll. Both options end up costing our organization either through a loss of interest earned in our accounts or the current cost of very high lending rates. In addition to monetary costs, there's a cost of staff time to continually communicate with every level within the department to get a status report or to try to explain the hardship that the untimely payments are causing us. It's fair to note that this is not a staff issue, it's really a systems issue. Having consistent payments from each state department would be one less challenge among many that contracted providers need to contend with. I urge this committee to support SB 432, and thank you for your consideration.
Thank you. Thank you for your time and your testimony. Seeing no questions or comments, thank you again for your testimony. Next, we will hear from Sage Steele, who will be followed by Matt Blindstrabas, who will be followed by Valerie Mara. Welcome, Sage. The floor is yours.
Thank you so much for having me. I appreciate the time. I'm a longtime resident of the Farmington Valley, and I thank you for allowing everybody this chance today. I know it's been a long day for you. I will join many others today in strong opposition to SJ4. My reasons for being so strongly opposed are based on several different experiences. I'll start with number one. As a former athlete myself and a mother of 3 high school and college age student athletes, that matters. As a television sports journalist over the last nearly 3 decades, most recently spent the last 16 years at ESPN here in Bristol, Connecticut. And as a board member of FAIR, which stands for the Foundation Against Intolerance and Racism, and that protects everybody. Let's begin there, because as a biracial woman who has experienced countless incidents of discrimination throughout 30 years, a 30-year climb, and as a woman in a man's world, I am really, really sensitive to any type of intolerance. That said, recognizing the biological differences between men and women and maintaining separate, safe spaces does not exclude anyone, regardless of how they identify. The overwhelming scientific evidence proves, as it always has, the undeniable physical advantages that men have over women in sports, even before puberty has begun. We've seen this on a national level. I've covered it on a national level. And unfortunately, the state of Connecticut is something I've also had to cover, making national headlines for its decision to intentionally allow 2 male athletes, for example, to take 15 high school state championship titles from girls in track and field over the last few years. One thing I think people don't fully realize is that it doesn't just take titles away from those 15 girls. It takes away spots on the back end too, of girls who are not allowed to qualify for the event because those spots were given away to biological boys. So this affects multiple girls on so many layers every single time that this is allowed. It's heartbreaking to me that the proverbial adults in the room are very clearly telling our girls with their actions that they are less than these boys and men, that their mental health is less important than the mental health of these boys that they're forced to compete against. This should not be a political issue. This is science. We like that word, right? Science. And this is protecting, and I think we're supposed to be uplifting these young girls and women. Period. For those who choose to ignore this science, I need to ask this, and I've asked this to thousands of people. I was on Capitol Hill last week asking the same question to senators. Why is this only happening one way, with biological men invading women's sports, but there are no biological women trying to join any men's sports? Why is that? We all know that answer. For the record, we at FAIR believe that there should absolutely be a place for transgender women to compete, and that is in an open category with other biological boys and men, a discussion that I will gladly have at another time. So I urge the committee, to commit to show these girls and women that they are truly equal to boys and men, and that all the work that we, millions of women, have done for the last 52 years since Title IX was not all for nothing. I have to add this on a personal note. The fact that SJ4 would prohibit restrictions on genital mutilation surgeries and abortion, such as not requiring parental notification and consent, only protects groomers and sexual predators. It does not protect minor girls. Isn't this about protecting our girls? I need to know, how do we explain this fact that girls must have a birth certificate in hand, and me, a parent, by their side when my daughter tried to go get a tattoo recently? However, we're fine with minor girls taking life-altering decisions into their own hands with no conversations. How about with abortion as well, with their babies? No parental involvement.
Interrupt you, but your time has elapsed. Can you please?
Thank you. See, this is just like TV. The producers are wrapping, I promise. I just believe in closing that we're better than this. And please, if all of you Connecticut lawmakers truly want to protect girls and women in sports, stop with hypocrisy. Please vote no on SJ4. God bless you all for all your time tonight, and thank you for hearing all of us.
Thank you. Thank you for your time and your testimony. I see no questions or comments from members of the committee. Thank you again.
Thank you.
Next, we will hear from Matthew Blin-Strabas, who will be followed by Valerie Mara, who will be followed by Chase Davis. Welcome, Matthew. The floor is yours.
Thank you. Dear Senator Flexer, Representative Blumenthal, and distinguished members of the GAE committee. My name is Matt Blin-Strabas, and I'm the Executive Director of Equality Connecticut, an organization with supporters in every corner of the state working to advance LGBT rights on the state and local level. And I'm here to testify regarding SJ4, a resolution proposing a state constitutional amendment concerning discrimination on the basis of sex under the Equal Protection Clause. Equality Connecticut unequivocally supports all efforts that enhance, expand, and secure legal protections for our community. We are grateful to the committee for their attention to this issue and their continued tireless support on behalf of Connecticut's LGBT community. Connecticut has a deep history of bipartisan support for our community, and we believe that support is demonstrated through the raising of SJ4. Connecticut remains a trailblazer in the movement to advance LGBT rights across the United States. In 1991, the CGA passed a law barring discrimination on the basis of sexual orientation, signed by Governor Lowell Weicker. In 2005, Connecticut passed a law legalizing civil unions for same-sex couples, and in 2009, Connecticut became the third state to legalize same-sex marriage through the landmark Kerrigan decision. The CGA then enacted a sweeping law bringing statutes into alignment with that decision. It's important to note that both the civil union and marriage codification bills were signed into law by Republican Governor Jody Rell. In 2011, the state passed historic expansions to our non-discrimination statutes on the basis of gender identity and expression, and the 2017 landmark ban on conversion therapy was passed with strong bipartisan support. When it comes to enacting laws that protect our community and families, Connecticut's laws are indeed robust. At the same time, we know these rights and protections are not equitably realized, nor can this progress be taken for granted. That is why Equality Connecticut is working with a broad range of organizations on an array of policies this legislative session and in the years ahead. And I urge each committee member to take a look at our policy agenda. It is vital that our elected officials do everything they can to support LGBT residents today. We are seeing a pernicious and aggressive assault on the rights of LGBT people in state legislatures across this country. States are proposing laws that make it restrictive and even dangerous to provide life-saving health care for our community. Efforts to remove books from library shelves by LGBT authors or with LGBT content, as well as attempts to erase LGBT people's history and stories from our school curriculum, are being considered through hundreds of bills of proposed legislation. While Connecticut enjoys comparatively robust support for our community, as LGBT people, we know we cannot take this support for granted. So thank you so much to all the members of the GAE committee for your continued tireless support for our community. We look forward to working together once again to advance this trailblazing initiative and to enact a community-informed social justice agenda that is a model for the rest of the country. Thank you.
Thank you. Thank you for your time and your testimony. I don't believe there are questions or comments from members of the committee, but Matthew, I do have just a question for you if you don't mind indulging me. First of all, thank you for reminding us of our proud history here in Connecticut, particularly in advancing rights for LGBTQ plus people in our state and being a leader for the nation. Unfortunately, today we've had a lot of testimony, which, we have a public hearing so everyone can come and give your opinion, but I am concerned there was a lot of comments made today that are harmful to members of the LGBTQ plus community, particularly our community members who are trans or non-binary. And so I wonder, Matt, if you wouldn't mind speaking from your perspective and the perspective of your organization as to what that kind of rhetoric does to young people in particular, or other LGBTQ plus people in our state and across the country.
Thank you, Senator, for that question. Totally agreed that it was a difficult day, hearing a lot of the testimony that was offered. I want to take a moment to just say to our queer community, especially our trans and non-binary young people, that we see you and that you belong in Connecticut. And I have to believe that through it all, that we know that our elected officials continue to stand by us. We've seen it time and again over the last 40 years as Connecticut has led the way. We know we have a lot of work left to do. Obviously, today was a big indication that there's a lot of work left before us. And I think going forward, it's extremely important that our elected officials continue to boldly and courageously speak out and listen to the community, and know that so that every LGBT person in Connecticut knows that you have our backs. So thank you for that question.
Thank you. Thank you for that response. And if you don't mind, I'd like to just repeat what you said to all members of the LGBTQ plus community, that we do see you and you do belong here in Connecticut. Thank you for that, Matthew. Seeing no further comments or questions, thank you again for your time and your testimony this evening.
Thank you.
Next, we will hear from Valerie Mara, who will be followed by Chase Davis, who will be followed by Michael Teleska. Welcome, Valerie. The floor is yours.
Thank you, and good evening. Good evening, chairs, ranking members, and committee members. My name is Valerie Mara. I am the superintendent of Catholic schools for the Archdiocese of Hartford, and I've been an educator in the state of Connecticut for 38 years. In the role of superintendent, I have had the privilege and responsibility of overseeing schools that serve well over 9,000 students. These students come from a rich tapestry of cultures, ethnic groups, and backgrounds, each contributing to the vibrant and diverse educational communities that are our Catholic schools. I've submitted written testimony with my fellow colleagues in Bristol and in Norwich Diocese, but I'll summarize our prevailing concerns and objections to Senate Resolution 4. As some of the other speakers have likely detailed, if this new definition of sex were to become part of state constitution, it would trump the application of our state statutory religious exemptions in litigation. I know there are others testifying more with legal expertise than I have, so I will focus on how this would affect our schools. These state religious exemptions currently apply to discrimination laws regarding employment decisions and matters of faith that are necessary for the ministry and operation of our schools, and without them would challenge Catholic and other private schools' recognized right to exist, and as a result, parents' right to choose a private or religious rather than public education for their children. Serious questions are raised regarding the loss of protection of religious exemptions. Potential outcomes include Catholic schools, seminaries, and colleges will be pressured to hire individuals who would otherwise be disqualified for religious reasons. The gender identity policy in place for Catholic schools might be considered unlawful, resulting in many practices that would be considered contrary to the faith and parental rights. Catholic school nurses and Catholic colleges' health services might be required to distribute contraception and provide abortion referrals without parental knowledge. Boys identifying as girls might be allowed to play on girls' teams and girls' locker rooms and restrooms in Catholic and other religious schools, and Catholic schools might be required to alter their family life curricula, among others. The church and its schools would assert the real probability that this state joint resolution, if it becomes constitutional law, would abridge our First Amendment rights of freedom of religion. Connecticut and the Catholic Church agree that parents are primary educators of their children. Parents are tasked by both with the responsibility to have their children educated, and the state allows parents to choose how to educate their children. It is not within the state's power to dictate all curricula. While the state recognizes school choice, it only chooses to fund public and quasi-public school choices. It is the state's responsibility to ensure that all children receive an education that is the preference of their parents, and this amendment will further frustrate this goal.
Thank you,
There
Valerie.
are
I'm sorry to
80
interrupt, but your
elementary
time
and
has
secondary
elapsed.
Catholic
Please
schools in all the
summarize.
dioceses of Connecticut, educating nearly 20,000 students.
Valerie, I'm sorry to
Yes.
interrupt you. Can you please summarize? Your time has elapsed.
I think that summarizes it. We urge you to reject this resolution, and I thank you kindly, all the members of the committee this evening.
Thank you. Thank you for your time and your testimony. I see no questions or comments from members of the committee. Thank you again. Next, we will hear from Chase Davis, who will be followed by Michael Teleska, who will be followed by Nick Postavoit. Chase, welcome. The floor is yours.
First of all, thank you for taking the time to hear us all out tonight. And like I said, I'm from Gales Ferry Intermodal. I am opposed or against Senate Bill 442. I submitted a written testimony, but I will talk to a few points on my written testimony. We purchased the site about 2 years ago, and early on we became aware that the southernmost part of the site had some historical relevance to the War of 1812. We then hired David George from Historical Heritage Consultants, and they completed a thorough study on the site, along with having multiple meetings with SHPO and other conservation societies as well. We divert to David George and how we're going to move forward with the site. We are still meeting with these organizations, and we'd like the time to do so. Please, listen to what David George said earlier this afternoon, and I believe our attorney Harry Heller will. I think he's coming on this evening. So again, just thank you for the time, and look forward to a positive outcome. Thank you.
Thank you. Thank you for your time and your testimony. I see no questions or comments from members of the committee, but thank you again for your testimony.
Thank you.
Next, we will hear from Michael Teleska, who will be followed by Nick Postavoit, who will be followed by Harry Heller. Welcome, Michael. The floor is yours.
Thank you. Dear members of the GAE committee, I would like to give some testimony on Raised Bill 5498. My name is Michael Teleska, and I have been one of the leaders and the founders of the Independent Party since it was formed in 2003. In Waterbury that year, we ran a full slate of independent party candidates for local election and put 6 members on the Board of Aldermen and 2 on the Board of Education. Since that time in 2003, we have consistently held office on a local level somewhere in the state of Connecticut, including such towns as Watertown, Newtown, Guilford, Winsted, North Stonington, Norwalk, and so on. In addition to many more cross-endorsed Democrats and Republicans who have enjoyed receiving our nomination and gone on to win local and state office. In addition to local ballots, we currently have well over 100 ballot lines on even-numbered years for state and federal office, including several statewide offices, which makes us one of only 4 minor parties with statewide enrollment privileges, as listed on the Secretary of State's webpage. Anybody anywhere in the state of Connecticut can join our party since 2008. So why is it now, after 20 years of trying to build a viable third party in Connecticut and give voters a real third choice on the ballot, the need to eliminate our chosen party name? There's little confusion among voters about the fact we are a real party. There's more confusion among the register of voters in many towns who do not put voters into our party after the voter states they want to be a member of the independent party. Because we may not be currently running any candidates in their town, the register of voters mistakenly think the voters do not have the right to join our party. They don't realize we are in fact a statewide party with enrollment privileges, and any voter in the state can join our party. Which brings up a point I would like to make to end some confusion on access to the ballot under the independent party name. Starting on line 894 of the Raised Bill 5498, it states, shall not incorporate the name of any major party, shall not incorporate the names of any minor party which is entitled to nominate candidates for any office which will appear on the same ballot if any office included on the statement, shall not be the same as any party designation for which a reservation with the secretary is already currently in effect for any office included in the statement. And that's how it ends. It should include this line too. Shall not incorporate the name of any minor party with statewide enrollment privileges. Why is this important? Because the way the statutes read now, the Secretary of State is allowing any group of voters that sees our party name on any local ballot that we're not currently running candidates on, thereby creating confusion among the voting public that we are in fact running these candidates. Any voter, no matter what party they may be enrolled in currently, may pull a form ED 601 and reserve a party designation, the party name, to run candidates in any of the 169 towns who are not currently on the local ballot as candidates of the independent party. No matter how we feel about the use of our party name or who those candidates may be, even though we may have voters enrolled in that town in our party already, we have lost control of our party name and who can use it.
Michael, I'm sorry to interrupt you, but your time has elapsed. Can you please summarize?
Okay. In closing, there's no good reason to take our name away from us unless you want to destroy our party and deny the voters a real third party on the ballot. and to destroy as she will by removing our hard-earned name from the list of parties in the state and not making any provisions for the 30,000 voters already registered in our party name, thereby making them unaffiliated on the voting rolls. The only real need for a fix on this part of the law is one I have pointed out on Form ED 601.
Thank you.
By adding the line I suggested. If there are any questions, I'm glad to answer them. And thank you for your time.
Thank you. Thank you for your time and your testimony. I see no questions or comments from members of the committee, but thank you again for your testimony. Next, we will hear from Nick Postavoit, who will be followed by Harry Heller, who will be followed by Edwin Colon. Nick, welcome. The floor is yours, and please feel free to correct me if I said your name wrong.
Hi, actually, Madam Chair, you said my name correctly. I'm pleasantly surprised. It doesn't happen often. So, dear Chairman and Committee, my name is Nick Postavoit, and today I am voicing my opposition to Senate Bill 435 because it is a gender affirmation implementation bill under the heading of farmland. So I'm going to read the title. This is what caught my eye: an act concerning government administration, including designation of farmland. And I heard a lot about farmland today, and I was touched by their fight. Provision of reproductive and gender affirmation healthcare services to patients located out of the state, and revisions to the Connecticut Entity Transactions Act. That was the part that caught me today. And as I listened to the farmers, I wish I could have wrote something about them as well in support of them. So, secondly, I do not agree with the purpose of the government. The purpose is to create a law that would protect the licenses of Connecticut medical professionals who lose their license in another state for performing gender affirmation care prohibited by their state law. The question I have then is, why are we welcoming these doctors into our state other than to perform gender altering operations? Finally, would this bill be an open door for other children to come from other states to have sexual changes made, perhaps even without the consent of parents? To me, this is a valid question, especially since 17 attorney generals have said already that they would not tell parents about this type of transaction, and including our own attorney general. And this was quoted last year and put in the press. One has to question the role of government regarding the gender affirmation and medical treatment. Where is the regards for the parental rights, religious freedom, and well-being of our children? We also must look forward to the negative effects of early exposure to gender identity. I've seen stories where children have made changes to their sex and then they wake up 20 years later going, they're very, very sorry that they've ever done this. Children can't make these kind of decisions. It is sad to see that the legislative majority would support this bill, but not propose a bill to let children be children, I came to the Capitol last month and I saw, and I was there with the press conference, and it was called a Republican bill. It was called a right-winged agenda. And I'm going, why is that? This is for all of us. We all care about our children. We want our children to make the right decisions. Recently, I provided testimony opposing a bill, HB 05417. This would strip the ability of school boards to exercise discretion on materials deemed inappropriate based on age, the age of our children in Connecticut. During this meeting, it was mentioned that children have First Amendment rights also. This is true to an extent, but not when it comes to altering their gender as a minor. We should not write bills.
Sorry to interrupt you. If you
Yeah.
could please summarize because your time has elapsed.
Sure. Wow. Okay. We should not let children make decisions about altering their gender at an age where they can't really make that decision. We wouldn't allow them to get tattoos. We wouldn't let them to go out and get drunk or buy drugs, or we wouldn't let them go out and go and eat. Any of these things, and yet we'll allow them to supersede their parents regarding their sexual transition. This is wrong, and it's not the government's decision. Thank you. Thank you for your time.
Thank you for your
Any
time and your
questions?
testimony.
Sure.
I see no questions or comments from members of the committee, but thank you again for your time and your testimony. Next,
You're
we will
welcome.
hear from Harry Heller, who will be followed by Edwin Colon, who will be followed by Ann Roberts Pearson. Welcome, Harry. The floor is yours.
Good evening, Chairpersons Flexer and Blumenthal, and distinguished members of the Government Administration and Elections Committee. My name is Harry Heller, and I'm testifying this evening in opposition to Senate Bill 442. I am an attorney at law admitted to practice in the state of Connecticut, and I represent Gales Ferry Intermodal, which is the private property owner of Allen's Hill or Mount Decatur, which is the site of the remains that accommodated the fort, the preservation of which is the subject of Senate Bill 442. Allen's Hill is the southernmost portion of a 165-acre site that was acquired by GFI in 2022. The entire property is contained in an industrial zoning district, and much of the property was previously improved with a Dow Chemical manufacturing facility, which was shuttered in 2011, with many of the buildings having been demolished and removed from the property. The previously improved portion of the property is currently in the process of environmental remediation. This property is strategically located for economic redevelopment with a deep water pier on the Thames River, rail service through the property, and thousands of feet of frontage on a state highway, and is bisected by a 115 kilovolt transmission line. It holds great potential to bolster the economic development of both the town of Ledgett and southeastern Connecticut. Its strategic location is uniquely supported by the infrastructure necessary to foster significant economic redevelopment. GFI is an out-of-state company that has made a substantial economic development investment in our state, both in the acquisition of the property and in the reconstruction of several hundred feet of deep water pier on the Thames River to support the expansion of its marine contracting business. The property was acquired by our client with knowledge of the historic site of Fort Decatur on Allen's Hill. Our client has consistently acknowledged both the existence and the significance of this resource. In order to ensure consistency with its redevelopment initiative, it retained the services of Heritage Consultants, who testified earlier this evening, to investigate the fortification and assist Gales Ferry Intermodal in formulating a plan that would reach a reasonable accommodation between the preservation of the historic site and the economic development initiative of the property owner. While it's not particularly relevant to the legislation at hand, Fort Decatur has not even received a mention in the cultural resource section of Ledgett's Plan of Conservation and Development. However, it has recently become sacred in the eyes of those who oppose Gales Ferry's initiative to redevelop its property. Redevelopment is a regulatory process and is administered in accordance with rules and regulations promulgated by Connecticut municipalities.
Harry, I'm sorry to interrupt you, but your time has elapsed. Can you please summarize?
I have submitted written testimony to the commission. I would ask that the committee review it. It sets forth in detail the reasons for our opposition to this bill. We do not believe that legislation is an appropriate means to resolve the issues at hand in this proceeding, and that is best left to both local and state permitting processes. And I thank you for your consideration, and I'll be glad to address any questions the committee may have.
Thank you. Thank you for your time and your testimony. There are I don't see any questions or comments, but thank you again for your testimony.
Have a good evening.
You too. Next, we will hear from Edwin Colon, followed by Ann Roberts Pearson, followed by Rashad Gibson. I don't see Edwin here, so Ann Roberts Pearson, you're next, who will be followed by Rashad Gibson, who will be followed by Carolyn Bennett. Welcome, Ann. The floor is yours.
Good evening. Yes, I'm Ann Roberts Pearson. Thank you, Mr. Chairman, and honorable members of this commission. Yes, I'm here to also show my opposition to Bill number 442, an act concerning the designation of Mount Decatur as a historic site. The purpose of this act supposedly is to require the state Historic Preservation Board to nominate a fort from the War of 1812 on Mount Decatur to the National Register of Historic Places. Mount Decatur in Gales Ferry on the Thames River, in whose shadow I have resided for just over 25 years, does indeed contain the site of a fort known as Fort Decatur, related to the War of 1812. But it is not just any fort site. Per David George, who gave testimony today, who is with the Heritage Consultants of Berlin, Connecticut, per their Phase 1A, 1B Cultural Resources Assessment and Reconnaissance Survey, quote, the Fort Decatur landscape is likely the only intact fortification dating from the War of 1812 remaining in the nation. So as well, this site also meets all 4 criteria for nomination to the National Register. So thanks to this report, we now know definitively that we have a rare site of national maritime significance in Gales Ferry. I'm basically here today because I feel a kinship with Mount Decatur, living so close. It is truly part of our community. It's always been there. And I've lived there for 25 years. And 20 years ago, many of us in the community worked very hard and long through public hearings undertakings to keep a 1.5 million gallon regional water tower off of Mount Decatur, because we knew it was a very significant place and that was not the appropriate place for the water tower. And we succeeded. And it just seems in a blink of an eye that here we are 25 years later, and the threat that is now looming large is even bigger than a 1.5 million gallon water tower. So in the past ensuing years, I have felt very badly that I haven't done everything I possibly could to preserve Mount Decatur in this special site. And so in light of the current threats that are facing it, here I am. This is a rare site associated with the War of 1812. And in May of 1898, a large commemorative boulder was engraved and unveiled atop the mountain from the Belton Allen Society of the Children of the American Revolution. So that was a significant way to honor the site at the time by putting, a stone. The stone was there, it got engraved, and it got commemorated, and it was a really big deal. And here we are in 2024. So I concur that I am opposed. I concur with Nora Taylor, Doug Schwartz, Stefan Danczuk of Preservation Connecticut, and David George of Heritage Consultants, and apparently with Harry Heller, the attorney who just spoke, and Chase Davis, that this bill, the way it is worded, regarding the methods and the conflict with the procedures of getting something on the National Register,
Thank
very
you. And I'm sorry to interrupt you, but your time has elapsed. If you could please summarize.
It's very problematic the way that it is written. And also, I believe that that this bill is way too narrow in scope, in that it limits the proposed nomination to only the fort, whereas the mountain and the entire context and scale that such a nomination needs is not being met. Thank you.
Thank you. Thank you for your time and your testimony.
Thank you for being here tonight.
Next, we will hear from Rashad Gibson, who will be followed by Carolyn Bennett, who will be followed by Randy Collins. Welcome, Rashad. The floor is yours.
Good evening. My name is Rashad Gibson, and I am opposing SJ4. This is a most troubling and contradicting amendment. The amendment reads, quote, discrimination is in the exercise or enjoyment of civil or political rights, including pregnancy preventing, initiating, continuing, or terminating a pregnancy. When did murdering a baby become enjoyable? Moreover, since this amendment is being proposed under the Equal Protection Clause, why isn't the baby protected? Wouldn't this be considered a contradiction, or better yet, an unjust law? You are proposing to us as taxpayers and constituents to approve this expansion of power based on discrimination, but the baby has no protection. And not only are they being discriminated against, they're being murdered. More conclusively, this legislation inherently discriminates against those seeking to protect the most innocent amongst us. And I just wonder, what will be the penalty for those of us by the state's definition is discriminating against abortion? Moreover, the amendment includes, quote, discrimination against sexual orientation, gender identity, and expression and related health care. Again, this is another contradiction. First, how does the state reconcile the protection under the law of a 15-year-old walking into a doctor's office to have their genitals mutilated? How are we protecting our young people, or anyone for that matter, if the result of this right will only end in lifetime mutilation? Secondly, if this amendment is passed, the state will consider myself and many other Connecticut residents as lawbreakers who do not believe in the ideological belief of gender identity and who are opposed to the evil of abortion. While not saying so explicitly in this amendment, it does infer discrimination against a specific demographic. And that demographic is Christian conservatives and pro-life groups, while protecting a selected group, that is, pro-abortionists in the LGBT community. In my view, this would express ideals more aligned with statism and not a state being a part of a free republic. As a result of this aggressive move towards statism, it fundamentally undermines our God-given liberties, which is the basis of all law. In closing, this amendment is unjust as it violates natural law and revealed law on which all constitutional law rests. Therefore, it must not pass. Thank you.
Thank you. Thank you for your time and your testimony. There are no questions or comments from members of the committee. Thank you again for your time and your testimony. Next, we will hear from Carolyn Bennett, who will be followed by Randy Collins, who will be followed by Linda DeLessio. Welcome, Carolyn. The floor is yours.
Thank you. Good evening. My name is Carolyn Bennett, and I'm here to strongly urge you to oppose SJ4. There are two main issues I have with this bill. First is the phrase preventing, initiating, continuing, or terminating a pregnancy. This statement is, in essence, adding a right to abortion to our state constitution. But you must remember that when you support abortion, when you constitutionally protect abortion, you are supporting and protecting a right to the violent destruction of innocent human life. This is both wrong and unnecessary. Abortion is a tragedy, and protecting it is not good for anyone. Not only is an innocent child's life lost, but abortion often negatively impacts the mother and the father, sometimes for years. And because everyone says that abortion is a right, no one validates their pain or acknowledges that it could be from their abortion experience. Legalized abortion promotes a culture of death that dehumanizes everyone involved. To quote Carrie Gordon Earl, a woman who had an abortion as a teenager, "The world is not a better place because of abortion. It's created a world where you're almost expected to abort if you're pregnant at an inopportune time. And it's created a society in which it's easier to push women to have an abortion rather than accommodate them and their needs as mothers. Abortion feels like your only choice if you want to keep your place in school or the workforce. That's not empowerment for women. That's bondage. This devastation is what you will be asking the people of Connecticut to protect in our Constitution. Please oppose this." My second concern lies with the phrase gender identity and expression. In looking at what is already protected, I see a list of things that I am born with. I cannot choose my race, color, sex, ancestry, national origin, or my physical or mental ability. These things are inherently unchangeable, and thus it is reasonable to expect I should not be discriminated against for them. Including gender identity and expression in this list is inappropriate. When laws that protect female participation in sports and society are expanded to include males who claim a transgender identity, the original purpose of those laws is destroyed, and women are soon erased by the laws that claimed to protect them. Equality becomes inequality endorsed by the government. As author Leah Labrisco Sargent says, when equal treatment for men and women means asking women to be interchangeable with men, women always wind up shortchanged. Real justice for women requires welcoming us as women, not helping us better pass as neutral humans. I ask you to please vote no on SJ4.
Thank you. Thank you for your time and your testimony. There are no questions or comments from members of the committee, but thank you again for your testimony. Next, we will hear from Randy Collins, who will be followed by Linda DeLesio, who will be followed by Gregory Baylor. Welcome, Randy. The floor is yours.
Thank you, Senator Flexer. Representative Blumenthal, thank you for taking the time tonight. My name is Randy Collins with the Connecticut Conference of Municipalities. Here just to speak very briefly, given the hours late, on a few bills. First, CCM would like to offer support of Senate Bill 431 regarding fees for redacting certain information from police body and dash cams, similar to Senate Bill 1222, which was passed last session. Given the mandatory requirements for police, the body cams and the dash cams, and the widespread requests for the information, it's taking a significant amount of time and resources for our municipalities and municipal police departments to comply with those requests, and looking to establish modest fees to assist in that process will be helpful. We oppose Section 1 of 435 regarding the designation of farmland. This would allow the Commissioner of Agriculture to have prima facie, present prima facie evidence in designated land as farmland. This is the role of the local assessor with appeals process that is built in. There's an inherent bias in allowing the Commissioner of Agriculture, and nothing against the current commissioner, but different commissioners will come, different ones will go. But the very mission of the Department of Agriculture is to promote the development and promotion of agriculture and farming. So this is something that, as I said, CCM would oppose. We would simply ask, if the commissioner were to designate a piece of land as farmland, what is the appeal process for a municipality? What would the appeal process be for a resident if the commissioner said, no, it is not farmland? Right now you have the BAA and the court process. We're not sure how that would work. We also have concerns with Senate Bill 441, election oversight. As currently drafted, it's just very vague as to what would bring a municipality into a tier 1, 2, 3, or even a tier 4 system. How would they get out? Would there be penalties if they don't comply with the sections that are in there? They're not spelled out. Furthermore, the idea of complete oversight of municipal elections, we would have, what does that mean? Would they then be able to spend municipal dollars? Would they be able to order, take control of municipal employees? A lot of different questions that I think really need to be worked out before we go down this path. And quite often, if we're looking at some of the election oversights that I've been hearing during the course of the day, are these, through the fault of, not the fault, but through gaps in our election process by which absentee ballots can be signed out, or different, if they're conducted by the Republican town committee or Democratic town committee, is that the fault of the municipality if they do abide by the laws as currently drafted? And if they don't, then that's why we have the Secretary of State, State Elections Enforcement. But we think the idea of taking over the complete administration of elections is something that we need to be very concerned about. And then 5498, I will wrap up very briefly regarding some of the costs that would be entailed with this. Right now, we would still actually advocate for no new costs and advocate for the funding of early elections as we're getting ready to do that. Thank you very much.
Thank you. thank you for your time and your testimony. I see no questions or comments from members of the committee, but thank you again for your testimony.
Thank you. Good night.
All right. Next up is Linda D'Alessio, followed by Gregory Baylor, followed by Terry Wood. Let's see. Linda D'Alessio, looks like you're on the Zoom. You can begin whenever you're ready.
Hi, my name is Linda D'Alessio. I'm going to speak on two bills tonight. I speak in opposition to SJ4. I have worked with many sexual abuse survivors, both male and female. Many survivors try to change their sexual identity due to the trauma that they have endured by being sexually assaulted. This bill preys on the confusion and trauma of those survivors and will expand the mental health issues we are currently seeing. This bill opens a door to expanding abortion up to birth without stating it. This bill is an assault on women and girls, period, and you should be ashamed that it has even been brought forward. I next speak in opposition to Bill 5498. I'm just going to point out points. Number one, CISA already recommends video cameras on drop boxes, and they recommended this in 2020. Towns in the Secretary of State's office did not follow federal guidelines on best practices to prevent fraud. Who will be responsible to review the footage? Who will report people for the irregularities? Who will prosecute and investigate? The common sense thing to do is remove the ballot boxes. Taxpayers do not need to pay police to police the fraud. Ballot boxes cannot ask for voter IDs or an electric bill, which currently violates our state election statutes. There is no ballot tracking, no signature verification, so they are already illegal. We no longer have a pandemic. Remove them. For point two, town clerks already record this in many towns. What is done with the list? It is not investigated. It is just a piece of paper waiting for a complaint that will never be investigated in time, nor can be tracked on who dropped it off. A ballot box can't ask you for voter ID. 3, who will you selectively limit for an absentee ballot set? What is a set? What is the limit? Will you limit this to 20 sets of 200, 500 sets of 4? This again encourages fraud and ballot harvesting. The ballot application requests need to end. When we FOIA these records from selective town clerks in selected towns, some political PACs got thousands of ballot applications. I have these records if you would like them. Number 4, clarify this. Destruction of any ballot is ballot tampering and should be punishable by severe penalties. Number 5, we found many people who lived in one state and voted here and in the other state, specifically New York, Rhode Island, Arizona, and New Hampshire. And that's just a small piece. Again, this has to do with the errors generated by Eric. This is not transparent and again hides fraud. 6, how does this make any sense? Do you only have a specific period of time to commit fraud? This should be no harvesting of absentee ballots or ballot
Ms.
applications.
D'Alessio, I'm sorry to interrupt, but your
Yes.
time has elapsed. Would you please
Okay.
briefly summarize?
I
the remainder of
will
your
wrap up. Okay, and what I will say is that you are the legislatures and the senators in this state. The Secretary of State has too much power over our elections, and she refuses to address the fraud. The fraud needs to be addressed. Thank you very much for the late night. Good night.
Good night. Thank you very much. Are there any questions from the committee? Seeing none. Appreciate your testimony. Next up is Gregory Baylor, followed by Terry Wood, followed by Susan Beck. Mr. Baylor, I see you on Zoom and you can begin whenever you're ready.
Thank you. Madam Chair, Mr. Chairman, and members of the committee, my name is Gregory S. Baylor, and I serve as Senior Counsel with Alliance Defending Freedom. Thank you for the opportunity to express our concerns with Senate Joint Resolution 4. Although we have other concerns about the proposal, we wanted to focus our testimony on 3 problems. They all relate to the proposed addition of gender identity to Article 1, Section 20. The first is the adverse impact of the proposed amendment on girls and women's sports. Earlier in this hearing, Christy Mitchell spoke poignantly about the wrongs her daughter Chelsea faced when the Connecticut Interscholastic Athletic Conference allowed males to compete in the female category. Under this proposed amendment, the people of Connecticut almost certainly would be stripped of the freedom to correct this sort of unfairness through their elected representatives. Indeed, the amendment would likely create a constitutional requirement that trans-identifying males be permitted to compete against women and girls in public school athletics. Our second concern is about privacy and safety for women and girls. In the summer of 2023, on a cross-country overnight trip, a Colorado school district assigned a 5th grade girl to sleep in the same bed with a 5th grade boy who identified as transgender, and they didn't even notify the girl or her parents in advance. We are concerned that the proposed amendment would actually require Connecticut public schools to implement similar policies and practices. And it could require state institutions of higher education to assign students to dorm rooms based on claimed gender identity rather than biological sex. Our third concern is that the addition of gender identity to Article 1, Section 20 would almost certainly harm children experiencing gender dysphoria and their healthcare providers. The proposal would likely be interpreted to require government-funded and perhaps even, government-employed and perhaps even government-funded healthcare providers to give gender dysphoric kids puberty blockers and cross-sex hormones and to perform sterilizing surgeries. Mounting evidence indicates that this is the wrong response to children with gender dysphoria. Connecticut should not lock itself into this approach by enacting the proposed amendment. In addition, many individual healthcare providers object on conscience grounds to performing these procedures, particularly on children. Thank you again for the opportunity to testify, and I'd be happy to answer any questions you might have.
Thank you for your testimony. Are there any questions from the committee? Seeing none, we appreciate your testimony and have a great evening.
You do.
Next up, we have Terry Wood, whom I do not see. Sorry to miss former Representative Wood. Just to have the adjoining district to mind. Next is Susan Beck, followed by Leanne Anderson.
Am I up?
You are, and we can hear you loud.
Okay. Okay. Thank you. Good evening, distinguished members of the committee. My name is Susan Beck, and I am speaking in opposition to Senate Joint Resolution 4. SJ4, by including and related health care in its proposed expansion of the definition of discrimination on the basis of sex, makes this proposed amendment vague and open-ended in a way that could prove truly dangerous to citizens of this state. Medical procedures and treatments almost always carry risks, and many of these risks do not become fully evident until years of data have accumulated. A number of procedures that would come under the vague umbrella term of health care related to sex, pregnancy, and gender identity are still relatively new, and the data on them is still somewhat scarce. In other countries, some of these newer procedures and treatments have already been banned or significantly limited just on the basis of the evidence available to date. For example, as has already been mentioned, in Great Britain, sex reassignment surgeries have now been banned for minors, and the use of puberty blockers in minors has been significantly curtailed because of the serious potential long-term risks and lack of evidence of benefit. Another pertinent example is that of using a surrogate to create a child. Surrogacy is banned across the entire European Union, whether the surrogate is paid or not, because it so often leads to the exploitation of poorer women and because of its great potential for abuses, including human trafficking. Yet because what is being proposed in SJ4 is an amendment to the state constitution, our government's hands would be tied should the citizens of this state, in interpreting accumulating evidence, someday come to agree with Great Britain or the European Union about the procedures I just mentioned, or should they realize that some other current or future sex-related treatment carried an unacceptable risk-benefit ratio. The government would be powerless to enact legislation to protect Connecticut citizens from that procedure or treatment. Its only recourse would be to repeal this amendment, something our Constitution makes exceedingly difficult. Finally, according to the wording of SJ4, The very part of this proposed amendment that is so vague and weak and potentially dangerous would be omitted in the way the amendment is presented to voters on a ballot. There, the expansion of the definition of discrimination on the basis of sex would simply say discrimination based on pregnancy, sexual orientation, and gender identity and expression. The clause "and related health care" would not be included on the ballot. This is highly deceptive and will be dangerously misleading to voters. So I strongly urge the members of the committee to vote no on SJ4. Thanks very much.
Thank you for your testimony. Any questions from the committee? Seeing none, appreciate, oh,
Chairman.
never mind. Senator Sampson.
Thank you very much, Mr. Chairman. Sorry, I just got back on the Zoom, and I was listening intently to Susan's testimony. So thank you very much for your comments today. I thought your comments were on point, and one of the things that made me want to interject was that something that has not been brought up much today, which is the actual question that's going to be posed to voters. I agree with you. The question reads, shall the Constitution of the state be amended to amend the Equal Protection Clause to provide that discrimination on the basis of sex includes discrimination based on pregnancy, sexual orientation, and gender identity and expression, omitting the very important words that you mentioned, and also using the term pregnancy when in fact they're not even talking about pregnancy. They're talking about the termination of a pregnancy. So I just wanted to thank you for your attention to the question, and certainly offer you the opportunity to add anything that you might have missed in your testimony.
That's okay. Thank you very much, Senator.
Very good. Thank you. Thank you, Mr. Chairman.
All right, here we go.
Thank you, Senator. Any further questions from the committee? Seeing none, thank you for your testimony. Next up is Leanne Anderson, followed by Ryan Fazio, or Senator Ryan Fazio. Ms. Anderson, whenever you're ready, you can begin.
Thank you. Good evening, honorable members of this committee. My name is Leanne Berry, actually also known and recognized as Leanne Anderson. In my capacity as the president of the Gales Ferry District, I am honored to represent our community in expressing our firm opposition to Bill number 442 in its current form. There have been ongoing efforts designating Mount Decatur as a historical site on the National Register, which is paramount to our town's comprehensive historical preservation efforts. Mount Decatur embodies immense historical significance, particularly from the War of 1812, with numerous artifacts already discovered and many more awaiting excavation. Its importance is deeply ingrained in our town's rich history. Therefore, it is imperative that the entirety of Mount Decatur be listed on the National Registry rather than the limited area proposed in Bill number 442. As others have previously stated, we oppose this bill as it's presently written. And I thank you all for your hearing my testimony tonight.
Thank you for being here for testimony. Any comment, or excuse me, not comment, any questions from the committee? Senator Sampson, is your hand raised on purpose?
Yes, it is, sir.
Looks like it is. All right.
Thank you, Mr. Chairman. I don't forgive me at this late hour. I don't mean to prolong things, but I wanted to just thank you for being here, Leanne. And I also wanted to make sure that either you or someone else that has testified is indeed sending us the information that we need to modify this bill so that it is more appropriate from a historical standpoint.
Yes, absolutely. We have our CALUA group, Citizens Alliance for Land Use. There's many of them have spoken tonight, and we've had others from historic commissions and so on. So I know we've had quite a few letters sent. So we will definitely give you all the information needed.
Okay, yeah, I just if you folks are working together, it would be very helpful to know who kind of the point person is. And,
sure.
And so we get the language right the first time.
Okay.
Which
No
doesn't
worries.
always happen in the way we make laws.
No,
I'm
I
sure
understand
my
that.
colleagues will attest to that.
Yeah, definitely.
Thank you so much.
All right, have a good evening now. Appreciate your time.
Thank you, Mr. Chairman.
Thank you, Senator. Are there further questions from the committee? Seeing none, thank you, Ms. Anderson, for your time and your testimony. Next up is Senator Fazio, followed, I think, by Tom Goldenberg. And then that should be everyone on the list. So, Senator Fazio, whenever you're ready.
Thank you, Mr. Chairman. I was hoping to be the closer tonight, but I guess I'm going to have one reliever after me. Thank you, Mr. Chairman and members of the committee. I'm testifying today in opposition to parts of HB 5494, an act concerning referenda on revisions to municipal charters and home rule ordinances. Local control of our towns and cities and the deeply engaged electorate that it engenders here in Connecticut is part of what makes our state a special place. The more discretion our towns and cities have to govern themselves, where it's proper, of course, encourages greater participation of our electorate and a healthy democracy. It also leads to better outcomes. A government that governs closest to the people typically governs best. Of course, democracy, including at the most local level, is often messy. However, by empowering our citizens, local democracy leads to the best decisions in the long run, even if it's not always a direct path to achieving it. Unfortunately, we as a state, from unfunded mandates to 830G to charter change preemptions and beyond, have undermined local decision-making and local democracy in recent decades that has often led to an even more unhappy relationship between our municipalities and the state. I fear that this bill, by allowing the Secretary of the State to effectively overturn municipal charter change process and referendums, like it or not, the will and the actions of a local democracy could further undermine our time-honored traditions of local control and home rule. Certainly, when there comes an issue that can only be dealt with at the state or federal level, those bodies should exercise their constitutional prerogatives to pass laws through the legislative process with our system of checks and balances in place to override local discretion. And they should only do so openly and with robust public debate and reticence to assert their powers. However, that is the process when higher levels of government should supersede local governments, not solely through the discretion of a single elected official. I appreciate that this Secretary of the State, our Secretary of the State here in Connecticut, has expressed concern about this bill for that reason as well. I appreciate the good intentions of the proponents of the bill and their desire to make local democracy work better in a more clear manner. There are good parts of this bill because of that. I only want to express my concern in opposition to the enforcement mechanism here because as is, I fear it would undermine the desires and rights of my constituents in the 36th district and beyond. I'm happy to help and work with all the proponents and advocates to make local decision-making work better and further these discussions. But as is, I have deep concerns about this part of the bill. Thank you for your time and happy to have any further discussions.
Thank you, Senator. Are there questions from the committee? Representative Branco.
Thanks for the promotion. Thank you, Mr. Chair.
Don't be so sure it's a promotion.
Thank you, Mr. Chair, and thank you, Senator Fazio, for being so gracious to let everybody testify ahead of you, except for one person, I guess. But Section 2 of the bill, lines 18 through 23, speak to the questions being limited to a single subject. So what are your final four picks?
What are my final four picks?
Hopefully one includes UConn.
That's such a softball question because obviously UConn will come out of the East. And then I actually think Arizona, Creighton, and Houston will also make it, with UConn cutting down the nets, being the first repeat champion since 2008. So go Huskies.
I like that ending. Was there anything you wanted to add to your testimony for the bill?
No, I understand that there's good intentions and there was issues in different municipalities around the state. I would just stress that in the long run, we want the best system, and the best system is embracing the messiness that often comes with local democracy. But a government that governs closest to the people governs best, and I think we shouldn't lose that sight of that fact, even with this bill.
Thank you, Senator. Thanks for hanging out with us all night.
Thanks, Representative.
Thank you, Representative. Any further questions from the committee? Senator Sampson.
Thank you, Mr. Chairman. thank you for being here, Senator. Thank you for sticking around to the final bell, so to speak. And I appreciated your testimony. Great minds think alike. Not the first time for you and me, but this bill's been before this committee a couple of times, and you sounded exactly like I did last year and even earlier today, discussing this with the proponents, which is I totally get that there's a problem. That sometimes, you know, these municipal governments, they'll put forward a charter question that's, you know, do you want to pass the charter revision? Yes or no, you know, without any more meat on the bones than that. And it's certainly an issue, but transferring that responsibility to yet another partisan elected person at a state level is not necessarily going to make it better. And I pointed to the questions that have been on our ballots in recent years for election criteria as evidence of that. Just curious if you had any thoughts about what might be a better mechanism, because, you know, I think you know, they're looking at this like, you know, if they put this into effect, many things may never even get to the Secretary of State, which was a kind of a compelling argument that if there was a little concern that there was oversight over what was being drafted as a question, they might do a better job of it. I'm not convinced of that, but it makes sense, you know, from their perspective. I'm just curious what your feedback is on what another enforcement mechanism might be.
You know, maybe it's not even an enforcement mechanism. Maybe it's allowing the Secretary of the State's office's resources to be a resource to localities as they're drafting questions. But as you pointed out, the state has been far from perfect at drafting clear questions for referendum in the past. And we shouldn't forget that the grass isn't always greener on the other side, especially when you centralize. Not only might you not be making better decisions, but you're now applying that decision-making process to the entirety of the jurisdiction of the state. So again, I think the proponents of this bill are well-meaning. I think they're good people. But I am very deeply concerned about the enforcement mechanism here. So maybe availing towns and cities of the resources at the state level to give them recommendations on how to word things in a more clear manner, or more proper manner, is a good alternative. But I'm not sure centralizing the decision-making power in the office of the Secretary of the State, veto or otherwise, is fair to citizens. And that's part of the reason why the Secretary of the State submitted oppositional testimony to the bill as is.
Right. Through you, Mr. Chairman. Yeah, no, I completely agree. And that's been the struggle for me too, is trying to come up with an alternative. You know, just the way our municipal governments are set up makes it a little complicated. One of those things I thought of is maybe giving the minority an opportunity to weigh in some of these type of situations, making it, you know, a required 2/3 majority to approve a question, something like that. But the vast majority of our municipalities probably do have 2/3 majorities, just the way they end up breaking down with minority representation, et cetera. So, but it's something worth thinking about. And I don't know what's going to happen with this bill going forward. I feel like I would like to do something to help the proponents. I think they do make a valid point, but I'm with you. I'm not prepared to move forward to put it in the hands of the secretary, you know, with veto power, et cetera. But I appreciate your.
I agree. I'm happy to have the conversation with them to help in any manner possible. And I will also note that I think there's a lot of evidence, a lot of studies in political science that say voters are inclined to vote no on referendums, generally speaking, because status quo bias sounds like pejorative, but they're cautious. So there's a built-in bias against voting for things on ballot referendums, which I think shows wisdom of voters in some sense.
Yeah, voting no generally does show some wisdom in my experience. So thank you for that, Senator. Much obliged, and thank you, Mr. Chairman. I appreciate the opportunity.
Thank you.
Thank you, Senator. Further questions from the committee? Seeing none, thank you very much for being with us.
Thank you, sir.
And looks like Ann Minuski has joined us. So Ann, you're up. I think you're probably going to be last unless Mr. Goldenberg, oh, there he is. All right, so Ann Moniski, Tom Goldenberg, and then I think we are at the end of the hearing.
Thank you, Representative Blumenthal. I have several pieces of testimony, and I'm just going to stay on SJ4, but I do thank Senator Fazio for making those comments. That was one of the bills I never got to send in testimony for today. But there's very good points there. So this testimony is in opposition to SJ4. Dear Chairman Flexer, Blumenthal, Ranking Member Sampson, Master Francesco, and members of the Government Administration and Elections Committee. The Connecticut Republican Assembly is an organization which has members and friends totaling almost 600 Republicans and conservatives across the state of Connecticut. We stand firm in our principles and our unalienable rights under the Constitution, as well as the rights and responsibilities within the Connecticut Constitution. I am Ann Moniski, a 25-year resident of Connecticut, former licensed professional counselor, and current president of the Connecticut Republican Assembly. The preamble of the Connecticut Constitution states, "The people of Connecticut, acknowledging with gratitude the good providence of God in having permitted them to enjoy a free government, do, in order more effectively to define, secure, and perpetuate the liberties, rights, and privileges which they have derived from their ancestors, hereby, after a careful consideration and revision, ordain and establish the following Constitution and form of civil government." And I also note the legislator's oath of office, which is critical in this day and time. This bill seeks to redo the Equal Protection Clause specific to changing the basis of sex. One cannot change one's sex. It is binary. God made man and woman. Genesis 1:27. In the last week, the WPATH files were released. I know several other people have testified on this, so I will just believe that there's been enough said on the files that provide research that was done on boys and girls, men and women, who attempted to become the opposite sex. The files provided that it was not scientific. It's basically pseudoscience. This bill is baseless. Please vote no on this bill. Thank you.
Thank you for your testimony. Are there any questions from the committee? Senator Sampson?
Thank you, Mr. Chairman. Ann, good to see you. Thank you for being here. I know you had to put a lot into 3 minutes. I thought you might want to elaborate on why the bill is baseless.
Well, to go to making an amendment to change the sex in this clause, it's ridiculous. There's no foundation. There is no base. Sex is binary. People have been trying to transition from one sex to another. It cannot be done. A man is a man and a woman is a woman. And I feel very badly for those individuals who have mental health issues, that they have been on hormones and have tried to transition. We see children now in schools that are being groomed to transition, but there is no basis to make an amendment to our Constitution to change sex, to enable people to think that they will be able to change their sex.
Yeah, I appreciate your point of view, and you have a very clear position. There's no question about it. And I feel very much the same as you do. I just listening to some of the folks that are in support of the bill, they tend to respond to that by saying, well, what is the harm? You know, if someone wants to live their life a certain way, how is that impacting you, or how would this legislation, affect others in a negative way? And there are certainly a lot of reasons that I could give. I just don't know if you wanted to add any concerns you have about, compelled speech, or undermining the being a woman, for example. I mean, there's a number of issues that have been brought up throughout today. I wanted to make sure you had an opportunity to get your words across.
Well, I thank you. As a former school counselor, it was over 25 years ago. I never thought that I would see what they are doing to our children in the public schools today, and making them believe that they can change. There's a program called Second Step, which until a few months ago, I was unaware. I knew they had it in our school system, our local schools, but I wasn't aware to the damage psychologically. They're actually grooming these children to think that a square is a circle and a circle could be a square. So I don't really can't expand further, but just it can have real damaging results, and it's just we're treating others in this clause. It's protecting all Americans. You can't change somebody, so that's my testimony. Thank you.
Understood. A lot has been said already today on this subject as well. So I think that we've had a lot of compelling testimony, and I thank you for being here and staying till this late hour. Thanks so much. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator. Further questions from the committee? Seeing none, thank you for your time and your testimony. Next and last, we have Tom Goldenberg on Zoom. Whenever you're ready, sir, you can begin.
Thank you, Chair. Blumenthal, appreciate your patience, and despite the technical difficulties, happy to be able to close this out here. I'm standing in opposition to House Bill 4598, specifically the section 27, that would effectively eliminate the Independent Party of Connecticut as we know it. I was in person for the first part of the session with a friend of mine. His name is Francesco Gervasio. We had a little mix up with the timing of speaking, but Francesco is a member of the Independent Party of Connecticut. I met him when I ran for mayor in New Haven, and I was endorsed by the Independent Party. And I got to know him and why he chose to positively affiliate with the Independent Party. And he's told me that he felt that it was the first time he really felt involved in the political process. And we heard testimony from Secretary of State Thomas, some things that stood out. One was that she mentioned a concern about overcorrecting and disenfranchising a majority of voters based on a few incidents. She also mentioned about unfairly biases towards people who don't belong to the major parties. Those are direct quotes from some of her testimony. And I stand here before this committee as a Democrat, a lifelong registered Democrat. And, I think we need to put our money where our mouth is. We claim to be the party that represents small d democracy, that has, really stood a high ground when it comes to maintaining the confidence of our electoral processes and our legislation, and not manipulating legislative rules to control elections or to enforce party rule. I'm sorry, but that's what I see this as. There is no need to effectively eliminate a party that has 30,000 members, that has been active for 30 plus years, for a very minor rationale. The only rationale I can think of is that this is a power move to shut out a minor party. And I brought Francesco with me today because I wanted you to hear from him, someone who is blind, someone who is disaffected, who's been through a lot, and positively affiliates with the Independent Party. So I find it very offensive that part of the legislation was introduced. I know that Representative Blumenthal and others made it clear that it wasn't directly written by the committee. And, I asked for this committee to really show their commitment to small d democracy and to remove that language from the bill.
Excuse
I'm
me,
happy
sir.
to.
Sorry, your time is elapsed. So if you could just
you.
summarize the remainder of your testimony in a sentence or so.
No, I mean, the other point that I mentioned in my written testimony, you know, in our urban centers, the Democratic Party has an overwhelming majority. In New Haven, it's 13-1. In other cities, it's more than that. And the Independent Party offers people a choice. And so saying that we're going to wipe out this party by making them deregister and re-register as another name is a really unfair political tactic in my view.
All right. Well, thank you for your testimony. Any questions from the committee? Seeing none and seeing no further witnesses, that concludes our public hearing for this evening. Thank you to everyone for bearing with us and for continuing to the end. And we will see you all soon. Good evening.